Good morning. We have what I think will be our last day of the Aaron Dean trial today. The defense should finish with their witnesses. Then we will go to closing arguments, and then we will go on jury watch. During jury watch, I think we're gonna watch Sarah, the body cam from the police arriving at Sarah Boone's apartment. Um, I don't think jury watch is going to be that long, but we'll see. Wait for a few people to get in here and we'll get started. I am watching, ready to go. When the cameras turn on in court, I do not see any movement yet. Morning, Miss Bruce. I got my Christmas sweater on today. I don't know if anyone saw. I was up fairly early, but then got a little late start because I was watching Law Talk with Mike's uh, video from last night. It's just glorious. If you get a chance, go watch it. Again, today should be the last day of the Aaron Dean trial. Defense will finish up with their witnesses. Then we'll go to closing arguments. Closing arguments are just like they are in the guilt phase. And then we will go to jury deliberations. During jury deliberations, my plan for now is to watch the Sarah Boone body cam footage. So the footage taken as the police arrived to her 911 call. Morning, 99. Morning, Cindy. Morning, Brittany. Yeah. I was almost late. Well, I think I was a minute late, and I blame it all on Law Talk with Mike's video. It's just glorious. Morning, Greg. Wakey, wakey, eggs and bakey. We are just waiting for the court cameras to go on. They usually go on between 7:30 and 8 my time, so that would be 8:30 and 9 Central Standard Time. Mike, it was unreal. And so what I understand is there's actually a wilder video, a wilder like hearing before that one, and I think that trial is actually supposed to happen today. I didn't get to the end of the video, so I don't know if the trial is still set to happen today, but absolutely hilarious. um yeah, I got it. I think I replied to you last night. Thank you for sending it. Yeah, I love Law Talk with Mike. I love law. I love a lot of the YouTube, the law tube, quote unquote law tube channels. Um, hey, make sure as you're all coming in, make sure you hit that like button. I know we're all kind of getting comfortable coming in. If you hit that like button, it certainly helps me out. I, my New Year's resolution is going to be to blow up this channel. So everything you guys can do to help me out by hitting that like button. If you haven't, for some reason, subscribed, please subscribe. But I'm pretty sure everyone here has. And if you want to share it out, if you have a social network to share this out on, please do. Again, resetting. I keep seeing more people coming in, so just want to reset again. Plan for today is to watch the defense finish up with their witnesses. We're of course watching the Aaron Dean trial. We'll watch the defense finish up with their witnesses. We will then see closing arguments. Closing arguments work the same way that they do in a guilt phase. So the prosecution will have their argument for the longest possible sentence. Then the defense will argue for probation, from what I can tell. And then the state will once again have their chance to rebut. As we've seen many times from the state, in this case, the rebuttal will probably be longer than their opening, or I should say their closing, their initial close. And then it will go back to the jury to decide Aaron Dean's fate. When we are on jury watch, my plan is to watch as much Sarah Boone as we can because Sarah Boone trial begins January 9th. We're going to kick off the new year in style, the suitcase murder. I'll get some videos out on her between now and then. Uh, Hopefully find some good angles, some unique angles that we haven't already seen. But in the meantime, we will definitely watch the body cam footage. Depending on how long this jury goes, I don't think it's going to be that long. Penalty phase verdicts are not usually that long. But if it goes long, we're watching police interrogation video as well. So that's the reset. Please make sure you hit the like button. Please make sure you hit the subscribe button. I do have my donation link in the bottom if anyone wants to help me out there as well. And again, I am watching for the cameras to turn on. They have yet to turn on. Thoughts on what the jury is going to do in terms of the verdict? If we remember from Friday, things didn't go very well for Aaron Dean on Friday. They went way less. I was frankly surprised. He's got a great defense team. Now, mind you, his lead attorney did pass away 2 weeks ago, 3 weeks ago, 1 week before the trial began. But he still has really good. That was his defense. His lead attorney was in bad health for a while, so we knew that he needed to get backup counsel, get them up to speed as far back as this summer. And the backup counsel that he got is extraordinary. I mean, defense attorney, a former judge of 20 years turned defense attorney, and then a former technical and forensic chief DA as his defense team. It's a pretty strong defense team. So I was pretty surprised at, and they did a great job during the guilt phase. From my perspective, they did a really good job. I was pretty stunned that he was found guilty of manslaughter. They did a terrible job in his penalty phase, and maybe it's that they just weren't expecting it. I mean, we expect lawyers to be ready for the worst case scenario in a case like this, but it's very human nature. Even as much as they thought they were prepared, if you have in the back of your mind that there's no way we're going here, it's going to be hard to be fully prepared. It could be that. I think it's a combination of that, and probably more strongly, they did what they could with what they had to work with. Aaron Dean's witnesses were terrible for him. Almost a little. There's that religious aspect that I don't know if his mom just felt that she had to be completely honest, or honest to a fault, kind of thing. But there were some bad answers that you could tell folks knew were not that great of answers. Where I just got the sense that they felt like they had to be overly honest. The testimony that Aaron Dean wanted from these witnesses was he was devoted to his community. He was devoted to serving folks. He would have been on that call to make sure that nobody was robbing a community member's home. We got more of, well, he's quiet. I haven't seen him do anything bad. His former field instructor straight up said, "Yeah, I don't really remember any specific instances with events with Aaron that were good or bad, but I don't remember like having to write him up or anything like that. That's not the ringing endorsement that you're looking for when you're trying to stay out of jail." So let's see what some of the predictions are here. Yeah, I'm with you, Brittany. I think he I think he was going to get the Kim Potter 2 years until Friday happened. I don't think he's going under 5. I think that's what you said in the next comment. I think he gets 5 years at the very least. Now, that said, the jury could have completely made up their mind on what his sentence is going to be in the guilt phase. They're not supposed to, but let's be honest. Like if you were just deciding guilty or not guilty in a jury room and knew that you had the power of the power to set his sentence later, and the jury knows this. They're probably not 100% certain on exactly how the process is going to go when they're deliberating guilt or not, if they're deliberating guilt, but especially in Texas where it's very similar for any type of case, they're gonna know well enough that they have the power to make a sentence, to set a sentence. So it's possible that many jurors, at least in their mind, if not actually spoken, had a set idea of the number of years he'll spend. Even in that case, though, I worry for him that Friday was so bad that they go back into that jury room and say, "Yeah, we were thinking 3 years, but man, this guy might not be as good of a guy as we thought he is, um, or might not be as bad. He might be worse of a guy than we thought he was." Is probably a better way to say that. Wow, Wombat Mommy has him going away for a decade. I hope not. I just don't think that's. I hate to use the word fair. I don't think that's just, but I could see it. And, and in a lot of ways, maybe it is just because the jury's not supposed to. The jury's supposed to take in the account the penalty phase, and if you take account the penalty phase, I might lock him up for 10 years too. If I ignore the crime, if I ignore, well, they're supposed to take into consideration the character evidence from the penalty phase. Sorry, I'm just getting some alerts in here. Okay, nothing about Aaron. They're supposed to take in character evidence in the penalty phase along with the facts of the crime when determining the actual penalty. Doing that, let's see what we have here. I did not hear about this either. I was on Twitter all day yesterday too. But I could definitely have missed it. Johnny Depp doesn't even care about the money. Johnny Depp already won, so if he takes $1 million away from this, it's a good deal. And that's almost her admitting guilt. I think him settling with her at any point, even now, is helpful to his cause because it's all about the PR. Her settling now is not a good look for her, and I think I'd take it. I'm not 100% sure. I haven't seen actual reporting on this, so but I'll trust Paul. So yeah, Aaron Dean may be spending a lot of time behind bars. And let's remember, sorry, I think things might be happening in the court. I'm seeing, nope, they're just changing their slides. Never mind. Oh, nope, they are going live. But it's still just the people at the desk. Man, let's remember, 2 years behind bars for a cop is a harsh sentence in comparison to 5 years for a normal criminal. Let's say life behind bars for a police officer is not fun. Best case scenario for him is he's in protective custody for however long he gets, and I think some people, I don't think anyone in this chat probably, but others forget that productive custody and solitary are pretty much the same thing. This killed him. This really, really killed him. It, in the mind of a jury, it says he may not, again, he's just probably not as good of a guy as you would normally expect, or as you would normally expect from your police officer, and not nearly as upstanding. Um, and the prior act's witness against him was good. She wasn't overly emotional. You could tell she was fighting very hard not to be emotional about what she went through, but the emotion came through at the a devastating amount. The lack of emotion from his family was rough. Um, the dude that tested his friend from church was like, "Yeah, we're good friends. We don't have a very deep relationship, but we're good friends." I just didn't get that he has deep relationships from people, and I would think that a jury is looking for something like that. We got the Tupac "Ain't Nothing But a Christmas Party" sweater on for Christmas here too. Speaking of that, as long as today is the last day in the Dean case, I will definitely not be streaming up until Christmas, and that's not because I'm like, oh, I need a break. Um, I'm going to be devoting that time to building this channel in other ways, making sure that I have trial calendars set, making sure that I get things like that intro video done, making sure that I get some good content put together for the trials that are coming up. I don't want to be this channel that streams and commentates. Oh, let me say that a different way. I absolutely want to be a channel that streams and commentates almost every day, but I'm not a lawyer, so I want to be able to deliver different sort of value, right? I have a journalism background, I have a marketing background, I have a technical background. I definitely want to use those skills and deliver more in-depth content. I want to make videos for you all that look at aspects of a case that other folks, including lawyers, may not be looking at. Um, I want to make sure that we're talking about the law that's going to affect the case well before we go into trial. Um, I, I want to make sure that we're super prepared for the cases we're looking at. I know a lot of folks say, "Oh, I want to take it in fresh," and that makes a little bit of sense. But I also think it's kind of an excuse just to start a trial without much work. So we're going to definitely put in the work, and so that's why I won't be streaming up and through Christmas to kind of put in some of that work. Then we have the Sarah Boone case starting on January 9th. If I find another case that starts right after Christmas, I may just kind of totally break the that ruling, the rule, or the message. I might just contradict myself right there and jump into a trial. Otherwise, we're gonna start working through the details of the cases that we're gonna be watching. And again, the next one coming up is Sarah Boone, January 9th. Oh no, I take that back. I think we have Mark Jensen. Let me pull it up. Sorry. We have Mark Jensen coming up on January 9th. The antifreeze case. And I've started to do some research on it. We'll definitely get videos out on that too. And maybe, you know what? There's a short 30-minute hearing that happened on Friday for Mark Jensen. I think we'll watch that, and then we'll go into Sarah Boone body cam just because the judge is so fun. This judge in the Mark Jensen case is gonna be fun. He's really smart, kind of harsh, um, but then I think he has a playful side to him. I think he's gonna be a fun judge to watch. So we're watching that 30-minute hearing too, just to get a feel for what he's like. There wasn't a lot decided in that hearing, but we'll watch it for the sake of watching the judge. Yeah, let's talk about the homeschool stuff here. Like the homeschool stuff, and I'm an extremely judgmental person, but I work very, very hard not to put that into a lot of calculus and a lot of commentary that I make. Um, I of course have my thoughts on homeschool. I wish I was more favorable to homeschool than I am. But it struck me as kind of that weird homeschool, like the weird religious group homeschool stuff that and it just didn't come across well. It just did not come across well. And all the homeschoolers families that came in after completely just made me think back to the woman that was assaulted, who had started a homeschool on campus group. Like, every time they brought up homeschool, I just thought of her again, and that's not good. I think the prior bad acts, it's not going to be as much the homeschooling. It's the prior bad acts that are going to put him in jail for a lot longer. And in fairness, maybe it should. So we have a small screen up of Aaron talking to his sister right now in court. So I'm sure that we're going to be going full screen on the court feed very soon, and I'll pull that up just as soon as we do. Yeah, so I won't get in. You guys know, I won't ever try to espouse to be an expert in something that I'm not. So I won't really get into whether they're pass or fail. What I will say is, having one person come in and say that he should have quote unquote failed or should not have been allowed on the force due to the exam, but then having that same person admit that 3 other people thought he was wrong, I think at least neutralizes his testimony. But if I'm a juror, I have conflicting thoughts on what that testimony is, because part of me says, oh, well, it's not really his fault, because he should have never been allowed on the force, and therefore this would have never happened if the results of that exam were used to exclude him from being on the police force. The other side, and when you have these split thoughts, just think some jurors that are probably thinking right and some people that are probably thinking left, right? So the flip side of that is, in some jurors' minds, being like, oh man, this dude should have never been a cop. That psychology test just proves that he was a gung-ho cop, and that should factor in a longer sentence. So I think that testimony kind of cuts both ways. And but I do think it's odd. You have one guy get up to say, yeah, I wouldn't have let him on the force, but 3 people overrode me. Well, there's a reason it's 3 people. And we're going live.
You can stand right there at the rail for me, please. Now raise your right hand for me.
Oh, let me fix this.
The truth, whole truth, and nothing but the truth, self to God.
Oh, no, we're not going live, but this is still fun to watch. This is the guy getting arrested.
I'm swearing you in as a witness. So, all right, here goes the juror.
This guy's just lucky the judge didn't have him shocked.
Everyone may be seated. Mr. Mata? Is your name Manuel Mata?
Yes, sir.
Your date of birth is 7/8 of 1980?
Yes, sir.
All right. I have issued you an oath to testify truthfully. Are you going to take that oath?
I have a question, sir.
No. Are you going to take that oath?
No.
All right. You are on bond on some cases, is that correct?
Yes, sir.
Those bonds are being declared insufficient, Sheriff.
What, sir? What's going on? What did I do? I need my lawyer present, sir.
We will get your lawyer.
You questioned without a lawyer present.
Merry Christmas, Tom. Merry Christmas, everyone. Perfect timing for that, right? These guys getting arrested.
I'm asking a question.
I think the judge was a little too fast on this. This was pre-planned. They wanted this to go this way. Both the defense team and the judge wanted it to go this way. I think this is more retribution for what happened the night before. But then again, I have no idea why this guy would have walked in open court. So who knows? Craziness. So again, we'll go live as soon as they do. I don't think we're any more than 3 minutes away from going live here. Oh, really? I thought he was just an activist. I'll look into him too. Well, I probably won't. But yeah, I thought he was just an activist. Yeah. Unless that wasn't going to work. Unless she would have had bad testimony as well. My feeling on this is that they did the best with the witnesses that they had. Thanks for stopping in, Amber. We'll see you soon. Hopefully you can at least pop in for the verdict. I've always hated when I've spent tons and tons of time watching a trial and then couldn't be around for the verdict for one reason or another. Oh yeah, that judge knew him. That defense attorney knew him. Okay, now we're going to the courtroom seal. I see the judge's head. We'll go live again.
Before we bring the jury in, does either side have anything we need to put in the record?
Nothing from the state, Your Honor.
Mr.
Judge.
Mr. Brissett.
Traditionally, under Rogers versus State, the defense would put stuff on outside the presence of the jury and the state for trial strategy purposes. But given the events that have transpired over the last 2 days we've been in court, I think it's appropriate to make sure the record's very clear as to what was going on Thursday evening outside the Kim Curry Criminal Justice Center, if I may.
Yes.
So, without revealing sources and methods, when the Dean family was removed or escorted from the building, there were individuals not part of the Carr family at all. They've been most gracious to us and to the Dean family throughout this whole trial. There are hangers-on, though, that have taken it upon themselves to interject themselves in this case. And one of those is Mr. Mata. Mr. Mata and several other individuals.
I'm going to learn a lot more about him right now.
Some dressed in full face coverings or baklavas to hide their identity, decided to speak in words that probably should be spoken in open court and cause the Dean family to be in fear to the level I say rises to Texas Penal Code 2207 of terroristic threat.
Oh, shit.
Knowing which law enforcement agencies were in plain clothes, law enforcement officials that are Texas peace officers were in close contact with the family and observed the 2207 violations. And at the time, they did not know who Mr. Mata was. As we came into Thursday evening, at the same time that's going on, simultaneously a series of death threats were being issued to the defense team as a whole via communication systems, which isn't the first time we've received death threats, but these were more specific and carry the same tone and nature that was going on the streets outside the Justice Center at the time. As we went on to the next day, Friday, when we were here last in court, initially the state was gracious enough to provide us an image of Mr. Mata from the Tarrant County Sheriff's Department system. Mr. Mata has a series of pending cases. He's also a convicted felon. He has assaulted cases in his past, and the undercover plainclothes officers were not able to do a positive identification based on the last mugshot that we had in the system. It wasn't until Mr. Mata made his appearance here in your actual courtroom that the plainclothes officers were able to positively identify Mr. Mata as being one of the same that did a bull rush toward one of their vehicles and was creating the overtones of the terroristic threat.
Holy crap.
Was well aware during the history of this building that we have metal detectors, other objects that can cause people serious bodily injury have been brought into this building surreptitiously. My law partner, Bob Gilman, he was a prosecutor, was attacked with a knife made out of a glass shank during Capitol Board Ire at one point. Metal detectors only do certain things. Mr. Mata sat within the 21-foot rule of the Dean family in the courtroom. As the state's expert, Mr. Priest, talked about 21 feet, probably should be 35 at this point. He had on multiple layers of clothing. We could not identify if he had anything on him. The same people he was threatening to cause harm to the day before, he's now within arm's reach of in the courtroom. The defense's contention all along is this case should have been moved out of town for publicity and the security risks that were going to go on. The defense
Yeah, me too.
sworn in,
And I'm glad it's being made very clear that they did.
A bill of exception to our continued issue of the change of venue. We were going to do that with Mr. Mata at a break. That's why we asked to have him sworn in. Mr. Mata refused to take the oath, and everybody else got to see what happens when you choose not to take the oath at that point, and they're disrespectful to a court that's in session. So for those reasons, that's why we asked to have Mr. Mata sworn in without revealing all the sources and methods of the undercover peace officers that are assisting in this case. We felt that the terroristic threat event that took place on Thursday warranted him being sworn in to be put as part of a proffer for our bill of exception as to why the change of venue had not been granted.
The court had received information from security as to their concerns as to Mr. Mata. And additionally, the state had furnished to the court a list of his convictions, his pending cases. There are multiple convictions for assault. There are 4 pending cases for interference with public duties. And when I saw him come into the courtroom and sit within the immediate reach of the Dean family, it caused me some concern.
So maybe you should have granted the change of venue, bro.
My goal is to do a fair trial and to make everybody feel safe in this courtroom. And
if I could add, Judge, without revealing our sources and methods, Mr. Mata is quoted in the hallway, "I shouldn't be here today. I know I'm going to be arrested." And that was on Friday, indicating, I guess, events previous, which I can only think would be the terroristic threat crime that he committed. Not only in the presence of those plainclothes.
Dude, let the judge finish his record. You didn't need to jump in with that. Let him finish his record.
Witness and know what a violation of laws when they see it.
well, as I said previously, my goal is to protect everyone. In fact, when all this was happening, I looked up and the state was over in the well of the jury box, away from their tables, and I felt what I needed to do at the time to protect everyone for courtroom security. Mr. Mata's bonds will be reinstated today, and so we can move on.
Why?
Mr. Smith, does that state anything you need to place in the record?
Nothing from the state, Your Honor.
All right. Are both sides ready for the jury?
State's ready.
Okay, let's go.
And this judge, a lot of these judges, and they have to be like this, just want to keep it rolling. Yeah, it's a big deal. But you guys can deal with that on appeal. We got to keep this case moving. Man, his chin is just non-existent. Yeah, change of venue is almost always denied. I don't know why judges don't allow it more. I guess it's probably like the professional courtesy aspect of not wanting to put more on some other jurisdiction's docket, but it doesn't seem that hard to do. And it does seem like it would help protect rights.
Everyone may be seated. Good morning. Members of the jury, the defendant Aaron York Dean has been found guilty by you of the offense of manslaughter. Therefore, it now becomes your duty to determine the punishment to be assessed against the defendant.
Okay, so the defense did rest.
The punishment for the offense
I was
of
speaking out
manslaughter
of
is by
turn
confinement
when
in
I
the
said we'd
Texas
see more
Department of
witnesses.
Criminal Justice
I do
for any
remember
term of
them
not
resting.
more than 20 years.
So we're going to go
less
right
than
to
2
closing
years.
arguments.
In addition, a fine
Yeah, I
not
think
to
my
exceed
earlier tweets say that.
$10,000 may be imposed. You are instructed that in determining the defendant's punishment, you may take into consideration all of the facts shown by the evidence admitted before you.
I have a
in the
feeling
full trial
security
of
has
this
now been
case
instructed to
and the
not
law
allow him
as
in.
submitted to you in this charge. In this case, the defendant has filed before trial his sworn motion in which he requests that if he is convicted, he be placed on community supervision.
Yeah, I'll look in and see
If you find that the
if
defendant
Mata's
has not
trial
ever
is
been
on
convicted of a felony
camera,
in
I
this or
doubt
any
it,
other
but
state,
we'll see.
and you assess the punishment of the defendant at confinement for a term of not more than 10 years, and you
What?
recommend that he be placed on community supervision, then let your verdict show the punishment which you assess, and further show that you recommend that his sentence be suspended and that he be placed on community supervision.
That was just for the
If you
record.
recommend
Or that's
that
just
the
for
defendant
example
be
there.
placed on
I thought that's
community
what you were saying they
supervision,
did.
the judge shall determine the conditions of community supervision and may, at any time during the period of community supervision, alter or modify the conditions. The judge may impose any reasonable condition that is designed to protect or restore the community, protect or restore the victim, or punish, rehabilitate, or reform the defendant. You may
Judges
not recommend
just do
that
not
part
want to
of the
move
period
them.
of confinement be served by incarceration and part by community supervision. Should the punishment assessed by you include a fine, a recommendation of community supervision should state whether or not the fine will be paid or be suspended and probated. Whether you do or do not recommend community supervision for the defendant is a matter that rests within the sound discretion of the jury. However, if you do recommend community supervision, the court is required by law to follow the jury's recommendations. Our law provides a defendant may testify in his own behalf if he elects to do so. This, however, is a privilege accorded to the defendant, and in the event he does testify, that fact cannot be taken as a circumstance against him. In this portion of the case, the defendant has not testified, and you are instructed that you cannot and must not refer or allude to this fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against the defendant. The length of time for which a defendant is imprisoned may be reduced by the award of parole. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed. If the defendant is sentenced to a term of less than 4 years, the defendant must serve
so
at least
reset
2
here real
years
quick.
before the defendant is eligible
Defense rested
for
on
parole.
Friday in the penalty phase.
Eligibility for
So
parole
we are
does
now
not guarantee that
beginning
parole
the
will be granted.
we
It cannot
have
accurately be
closing
predicted
statements for the
how
penalty
the
phase.
parole law might be
State
applied
goes
to
first,
this defendant if sentenced
defense then
to
goes,
an
and then the
imprisonment,
state has the rebuttal.
because the application of
And then
that
it will go to
law
the
will
jury
depend
to
on
decide
decisions made by parole
Aaron
authorities.
Dean's
You may
sentence.
consider the existence
Well,
of the
we are on
parole
verdict
law.
watch.
You are
We're
not
going
to
to watch
consider the manner in which the
Mark
parole
Jensen's
law
last
may be
hearing,
applied to this particular
and then we're moving
defendant.
to some Sarah Boone stuff.
Your verdict must be by unanimous vote
In
of all
terms
members of the
of what
jury.
else happened this
In
morning, we're
deliberating on
just
this
putting
case,
more
you
info
shall
on the
consider this
record about
charge as a
that
whole and
gentleman with
must
the
not
last name of
refer or
Mata,
discuss any
who
matters
apparently
not in
made some
evidence
terroristic
before you.
threats towards the
If you need
Dean
to
family.
communicate with me during your
And
deliberations, the presiding
that's
juror should
the
write the
gentleman that
message
was
in the
arrested
jury
on
call
Friday
button on the
afternoon
wall and
and
give
had
it
his
to the
bonds
bailiff.
revoked.
I will either reply in writing or bring you back into the court to answer your message. You are the exclusive judges of the facts proved of the credibility of the witnesses and the weight to be given to the testimony, but you're bound to receive the law from the court which is herein given and be governed thereby. And I've signed these instructions as judge. The last 2 pages of the instruction contain the respective verdict forms. The first verdict form says community supervision not recommended. We, the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment of confinement in the Texas Department of Criminal Justice for, and there is a blank, for the presiding jurors to fill in the number of years that the jury agrees to. In addition, we do or we do not, and the presiding juror will circle that phrase, assess a fine in the amount of blank. So if you assess a fine, circle we do assess a fine. If you don't assess a fine, circle that. We do not recommend community supervision. And there's a space for the presiding juror to sign on that form. The second verdict form is on the last page, and it recommends community supervision. So in that situation, the presiding juror will fill in the number of years that you assess between 2 and 10. There, again, you can assess a fine or don't have to assess a fine. If you do assess a fine and you're recommending community supervision, there's a third blank for the presiding juror to certify whether you want the fine that you assess be paid or that it be suspended and placed on probation. Ms. Diener. I need the lights, Brian.
I find it interesting. He never explains that,
Yes, ma'am.
that they're going to make argument.
Atatiana's family,
Here we go.
they received their life sentence on October the 12th of 2019. They received their life sentence without her. They'll never get her back. As we approach the Christmas holiday and the end of this year, we think about those that we love.
I feel like she was in theater when she
We grieve
in high
for
school, at
those
least.
that we've lost. And for them, that sadness, the grief, there's multiple stages when you go through the loss of someone close to you. For those of us that have gone through that, we know what that's like. A few years can pass, and yet it feels like just yesterday that they were here.
Good Lord, she's
You heard Adarius testify.
she's dramatic.
You heard Ashley testify. For Ashley, for Amber, for Adarius, for Zion, their whole lifetime will be without her. There's a part of grief that we all suffer when we get to a certain point. When we think about that person, there's a realization for us all. It's the finality of it. Right? In your heart, you miss them, you love them, and then you really realize they're never coming back. And that's the hardest part. And that's worth something. And in this case, it is worth something. Her life is worth so much more than a probation sentence. So much more. This family, her memory, her legacy, this community deserves more. In punishment, we brought you multiple witnesses. And those were witnesses we were not able to bring you in the guilt innocence portion. You heard from Dr. Kyle Clayton, the forensic psychologist. And this is an expert that both sides call. He testifies and works for the defense. He testifies and works for the state. Whoever calls him, he does good work, and he testifies to whatever he finds. He was hired by the Fort Worth Police Department, as he's been with many other agencies, to do a pre-employment psychological evaluation.
3 others disagreed with him, though.
Grandiosity, has grandiose tendencies, domineering, over-controlling, forceful,
I
dominant
honestly think this is their
personality
worst
traits,
argument.
uncritical of himself, denies flaws,
They have some good
minimizes
arguments.
behavior,
This isn't the greater
little
one.
tolerance for disagreement, can be aggressive, has an unrealistic view of himself.
Yeah, they want that
Someone
in.
that thinks that he can fly
That's
all
why
of us in a commercial airline, despite never having an hour of training. Someone that when you're asked to rank yourself, 9 out of 10. Not suitable for a position as a police officer. Psychologically speaking, he is not suitable because these tendencies that are well formed, ingrained, a thread throughout his entire personality, these are unchanged traits that put himself and others at risk. It is like a roadmap back in 2017 to how we ended up here and how we lost Atatiana.
Okay, I take it back.
back in
I see
October
how they're
2019.
weaving it. They're weaving it well.
These things don't
Great
change.
argument.
And how do you know that even in the 3 years between the time that was done and today? Because last week, the defendant testified. I think they did a pretty good job out there. You shot a woman in her own home. You disregarded every single standard operating procedural, general order, and just pure reasonable human instinct. And a 28-year-old woman died, and you give yourself a fine job. You give yourself a B. This is not somebody that thinks he has done anything wrong. When the defense counsel gets up here, they're going to talk about the witnesses that they called. And those witnesses are not witnesses that you could hear from until now, till punishment. You heard from us, Dr. Clayton. You heard from us, Adarius Carr. You heard from us, Liz Turner. And why is Liz Turner important? Because we wanted to show you everything that we knew about him. And it's important to know, going all the way back to college, that's the way that he treats people. He's entitled, he's arrogant, he's
Exactly
aggressive.
this.
And that was 20 years ago. And she
They were
was
the
talking
3
to
hired
you
hands
from a place
to
going right back there. She
get
remembers
those that were
she got emotional.
blocked from
It's
getting
hard
on.
for her. Because that's who he is.
Give you 7 minutes, Ms. D.
Thank you. So when he gets up here, when the
Oh man,
defense
he's
counsel
giving him
gets
a
up here
short
and
amount of
talks
time
to
for
you
argument.
about why you should give him probation, because that's what they're going to do. They're going to get up here in a minute and they're going to ask you for a very low sentence or probation. They're going to ask you for mercy. Mercy's been shown already for this defendant when your verdict was returned for manslaughter. Mercy is earned. It is not just given. And I want you to listen to why they're asking you for a low sentence or probation. Because his family got up here and said he was a good guy.
Kind of.
Every case that I prosecute, there's a family member that gets up there and says they're a good guy. It's part of the deal.
Yep.
But I think it's important to think about the witnesses that we didn't hear from.
Yep.
Just as much as the ones that we did, right? Family members. We heard from one field training officer, just one
cop
single Fort Worth officer
who
that
didn't
said,
have wasn't that glowing.
I knew him for about 3 or 4 weeks. Didn't have very good personal skills. We kept up. I don't know anything about this case. But don't you know the Fort Worth Police Department and all those guys and girls that work for him, 18 months side by side with him, almost 2 years. Don't you know if they had something good to say, they would have been in here? There would have been a line out the door. And don't you know that those 3 psychologists that gave him a passing score, if they had something
She's
good to
crushing
say, if
it.
they disagreed with Kyle Clayton,
But
don't
that's
you
kinda
know
like
they've been in here
celebrating
saying that? They would.
Barry Bonds hitting a
Guarantee you.
softball pitch, slow pitch softball.
But instead, we have a family, which they're good people. This is not their fault. This is not their fault. But valuing them or him over her is a tragedy. It is not right. It is not just.
This is exactly what I think. Even if it was
In this
subconscious.
case, the only appropriate verdict is the maximum sentence. It's the only thing that's appropriate. And when the judge talked to you about the court's charge, I want y'all to think about, and y'all don't have copies with you, but you'll be able to go back and read this. When you go to this certain page, I want to ask you, do you feel comfortable with the fact that the judge gets to set the terms of probation? He gets to get off. If he wants to get off early, judge sets the terms. You heard from the probation officer talk about probation and how it is. It is no different than what all of us do every day. That is not enough. That's not even a slap on the wrist. You heard that this defendant has been out on bond for the last 3 years.
I don't
with his
think
family,
he's not getting probation.
laughing, doing projects with them.
They don't give him
Something
manslaughter
they
in
don't
probation.
get to ever
They
do.
just don't.
They don't get to ever do that. Doing probation values that over them, and that is not okay. The other thing that's talked about in the court's charge is a fine. I can always get questions about the fine. If you want to put an exclamation point on your verdict, then you put a fine. It doesn't go directly to the family. It goes to a fund.
Yeah.
So you put
Nobody cares with the fine.
as an exclamation point. When you think about this case, you all leave here today. They go home without her. Zion never gets to have Aunt Tay again. It doesn't matter if it's a year from now, 5 years from now. People are going to ask Zion, what happened to Aunt Tay? What happened? What did the jury do? And thankfully now with your verdict,
Oh, this is good.
he gets to say that they found him guilty.
My
They're
respect
also
for her
gonna
is
ask
growing
Another extremely important question. What did they do?
in terms of being able to win. I still don't like what
What do
she
you
did in
want
the closing,
Zion's
but
answer to be?
she knows how to win.
The only just verdict is 20 years. Anything less is a travesty of justice.
Mr. Gill?
He's given him. I think that was all of her time that she was allotted.
Morning.
He may not even give her a rebuttal. I don't know. I'm sure he should.
Having an entire weekend to think about what remarks I was going to make here this morning is a long time. So I guarantee you, I went over this matter in my mind 100 times or more about what I was going to say this morning.
Good for you, man.
I've been
Who
up here for
cares?
30 seconds now, and I already know it's going to come out in a different way. Your verdict at the first phase of the trial.
I wrote a speech,
is
but I'm going to
important
go from
note.
the heart. Is what he just said.
It's important to
What the hell?
note what was said by the state of Texas. Because if you take the emotion
No one believes that, right?
out of their remarks, there's really very little left. They want you to base your verdict on emotion. You know, the family's not going to get to see Atatiana anymore. We know that. It's a tragedy. We've acknowledged that. We've talked to you about that. There is no change that. Your verdict won't change that. It can't change that. You were talked to at the jury selection phase of this trial about whether or not you could give fair consideration to the idea of probation, to assessing a probation for someone that's been convicted of the offense of manslaughter. And each and every one of you said you could give fair consideration to that concept. And that presupposes that someone's life has been taken. And it presupposes that that person isn't going to be with us anymore, that their family's going to miss them. It presupposes there's been a tragedy overlaid over the facts of the case, which is exactly what we have here. A tragedy that will never be changed. And the prosecutors were very defensive about the fact that we were going to ask you for probation in this case. That's because they know that that's really what this case is worth.
Good argument. I don't think that's true, but good
But
argument.
they want you to do something else. So look at your verdict at the first phase of the trial. You found that Aaron did not act intentionally. You found that he did not act knowingly.
These lawyers,
You found
all these
that
lawyers,
he did not
when it
intend
comes down to it, are really good lawyers.
for there to be a death resulting from his actions. Your verdict said you felt he acted recklessly, which is a much lower culpable state of mind than intentional or knowing.
This is also a great argument.
You know from the facts of the case
Counsel on both sides
that
agree.
this case was not,
We don't normally see that in
premeditated.
cases we watch.
there was no malice involved, there was no forethought involved. Remember
I
the
still
state
hate what the
stressing to you during
prosecution
closing
did in their
arguments how
closing.
fast this matter happened? That is a very important fact for you to consider in your deliberations at this phase of the trial. How quickly that decision had to be made. Aaron Dean is literally being judged for a second of his life
I
today.
hate that argument too.
And he's being judged under man's law, not God's law. The talk about eye for an eye, I'm not sure exactly what that was meant to convey to you during questioning of our witnesses, but we're not here about God's law. We're here about man's law. And the man's law is contained in the court's charge Judge Gallagher gave you.
And not gonna lie, I was sitting
We're
in
not here
church
about money.
yesterday
damages.
thinking about that exact question. I was like,
That's from the civil court.
why didn't
down
she
the
just
street.
come back with
And you heard
Sir,
there's
that's
a
the
matter
Old
pending
Testament.
down there
like
regarding this. This is about what is a fair and just verdict under the facts of this case and this case alone. What is the fair thing to do here? It's not a weight or a balancing contest between the Carr family and the Dean family. It's not who's worth more. The judge doesn't tell you that in the court's charge. It's about what is the fair and just thing to do under the facts of this case. On the questionnaire that you filled out before trial, asking you about the three goals of punishment in the criminal justice system. Those three goals are the three purposes of punishment are punishment itself, rehabilitation, and deterrence. Those are the three things that you are to consider as jurors in a case. You are asked which of those is more important to you, punishment, rehabilitation, or deterrence. And the answers from the group of you vary. But if you are talking about punishment, what is he being punished for? There was a life lost, tragically. But Aaron was working in the line of duty as a police officer, as a law enforcement officer. He didn't take it upon himself to go hunt someone down that had wronged him before, or knowingly place someone in a dangerous situation waiting for him to spring a trap on them. He was trained by the Fort Worth Police Department. He was hired by the Fort Worth Police Department. He was assigned by the Fort Worth Police Department. He was dispatched out there that night in the line of duty. And his testimony to you was that he was protecting himself and his partner. So what are we going to punish him for? Yeah, there was a life taken. That's true. But look at how these things happen. Look at the chain of events that set it all up. What is he culpable for? He didn't plan this thing. He didn't set out that night. He didn't get up that morning and go down to the police, go down to the headquarters to get his assignment with anything like this in mind. He was trained in the Fort Worth Police Department Academy to eliminate a threat. So keep that in mind, please. Secondly, rehabilitation. What are we going to rehabilitate Aaron from?
I think this is always a great
Third,
argument in these cases
he'll never be a
too.
police officer again. This situation is never going to repeat itself. You'll have to move on and find some other form of employment, which he's
Prison's
done.
is supposed to be about three things: punishment, public safety, and
He's
rehabilitation.
probably the least,
When you can make the argument like
least in need
a
of
very
rehabilitation
logical argument, I don't think
ever
anyone
sat in a
disagree
defendant's chair.
that you're taking two. You can automatically take two of those things off the table.
Because he's a God-fearing,
There's no
law-abiding
real need for
citizen of our
rehabilitation. And if there is, he's not going to get that.
yeah, Dr. Clayton
what
came
he
in and
needs
said
for
he was
rehabilitation in
narcissistic. He
prison.
saw all those things.
And
Place
two,
on
he's
the board.
not a public safety risk. He's
Dr.
never going to be a
Clayton
cop again. And
Had a
someone
very
who may-
isolated opinion.
someone's who convicted of an
Not guaranteed.
unintentional homicide, well, as being a police officer,
Three other
it's not really a
psychologists agree
public
with it.
safety issue. So this is
Hired
all
by the
about
Fort Worth
punishment.
Police Department.
And I think juries kind of don't like the idea of what they're handing down is straight up punishment. Nobody
Dr.
likes that.
Clayton didn't follow Aaron around the church. He didn't follow Aaron around.
Exactly.
in the
Public safety
choir.
is not an issue.
He didn't follow Aaron around in engineering school on his physics degree. Dr. Clayton said, he could fly a commercial airliner. At least that's how I took it, which tells you the subjectivity of the discipline of psychology. Dr. Clayton had a very isolated opinion of Aaron Dean. Look at the opinion of the people that know him best. Of course, his
It
fans
wasn't
are
great.
fans. That's who he spends most of his time around. He's a family man. He's very involved with his family. Is that wrong? The prosecutor tried to make it seem like that's wrong to be a family man, to be around your family, to be in church with your family. It's not wrong. That's not a bad trait that Aaron has. That's a good trait. He had an isolated incident as a late teenager in college. You heard that Aaron was homeschooled. You heard that the purpose of the
I don't like this argument. I would ignore it.
people socially adapt
The prosecution didn't bring it
to
up.
college, in the college environment.
Ignore it. Oh,
Is Aaron going to be judged for one isolated instance in his youth?
well, now it's two isolated instances
An incident
because
no
you just
doubt
brought
he's
up two
deeply
different
embarrassed
instances that you'd be
That
judged
has been
for.
since that day? A
Dumb.
teenage mistake? You know if there had been anything else in his background, speaking of people that didn't testify here, If there had been anything else in his background,
This is
they could have
dumb.
brought it to you.
Dumb,
There are 190
dumb.
prosecutors and 60-some investigators
If the
in that
state would have
office.
hammered on
could
this
have brought
point
it
in
to
their
you.
closing, okay. They
You didn't hear
didn't.
about anything like that.
Let
could
it
have brought you
go.
police
Let it go.
officers.
Let it go.
If he had messed up anything in training, they could have brought those officers to you, and they didn't. Detective Dugan came to testify because he and Aaron developed a friendship while they were riding around that squad car together. A friendship that they've carried on after this event. Detective Dugan told you Aaron was devastated, as you would expect a Christian man to be over the situation. Deterrence? What about deterrence? One thing prosecutors like to argue at the punishment phase of it,
Just when I go off about how
is that
great
the jury has to
all
send a
the
message.
lawyering has
you've got
been,
to send a message to the community.
they
You've got to send a
make me
message that this type of thing
eat
is
my words.
tolerated.
Stop talking
Ladies and
about
gentlemen, In
religion.
this case,
Absolutely do not talk about that
you have to
prior
be
act.
very, very careful
What is wrong with you, man?
of the message.
This argument would have worked 20 years ago. Well, the prior act argument should have never
Because in
brought in.
addition to the folks here in
This
this
Christian
courtroom,
man argument would have worked a lot better
this
20 years
case
ago.
is being followed region-wide. And the police officers that have been
Have a
here,
good one, Walt,
and the police
Mommy.
officers that are
Thanks for
watching,
stopping by. I'll try to tweet out when we're gonna,
need to know
if we have a verdict, so you can jump in. I'm sure you have notifications on and stuff, though.
that when
have a
they
good one.
leave, and their families need to know, that when they leave for work in the morning, that they can follow their training,
It's dumb. He started with a great
they can
argument.
defend themselves. Your verdict must walk
Ugh.
a very fine line between what you believe Aaron Dean did.
It's more than
what
unnecessary.
other police officers
It's
in
dumb.
the same or similar circumstance do. Because this situation, this exact situation, is an extremely isolated event. It's a one-of-a-kind fact scenario.
This guy's talking his client into
The
time.
message needs to be tailored. If
Okay,
there is a
this
message,
again is a great argument.
needs to be tailored to this event.
He lost himself for like 10 minutes.
Because the policing, the training, the methods involved, those were out of Aaron's control.
The tailored sentence is a perfect argument.
You heard Judge Gallagher's in charge of the probations in this court. Judge Gallagher's in charge of the terms and conditions. And you can trust Judge Gallagher to make sure
Yeah, I think that was kind of a
that
bad
this man is
argument
followed
by
along.
the prosecutor to be
Make
like,
sure that
you're going to
he
leave it in the hands of this judge to determine
knows everything that there is to
how
know
long probation is.
about what's going on with this probation.
This judge, I don't think the jury is like, oh, I don't know if I trust this judge.
Tailor the terms and conditions. He could take it and put
Aaron, the jury is seeing, he seemed very serious, and
this
that was a dumb argument.
event so that Aaron never forgets, which he won't anyway. Judge Gallagher could order Aaron to sit down with administration from the Fort Worth Police Department, any other regional police training academies, and help them develop training curriculums so this situation never repeats itself. Aaron Dean can be an asset to law enforcement.
I agree, but in my opinion, it seemed very
He can
genuine
follow every other term
and as
condition
though
of
she
probation
didn't want
Judge Gallagher
to still
set out
harbor
for.
serious resentment. I don't know what
Punishment, rehabilitation, and deterrence.
it seems
do not
super
include
genuine and
the
not like
term
she was like
revenge.
a woe is me type, but that she just couldn't shake it.
And believe
that-
me,
just-
there are plenty
just
of
one
this
opinion.
community that are seeking that. But that's not the function of a jury. The function of a jury is to follow the law and set out the terms and conditions of probation that are applicable, or to make a decision that's applicable and based upon the facts of that particular case. There's no one else in this community that has heard all of the testimony and seen the demeanor of the witnesses and had your experience. This is your verdict and your verdict alone. And let's make no mistake about it. We are asking you to recommend to Judge Gallagher that Mr. Dean have his sentence probated. Because there is nothing to gain by sending this man to the penitentiary. No one can punish him more than he's already punished himself.
Going back and
Talk
forth
about
on that
his
argument.
Need for rehabilitation.
I personally think something like that
And we
is
talked
true,
about
but I think
what
others think that's a
exactly
very
is it
trite argument.
that we would deter by a penitentiary sentence here. What exactly would that be? Aaron didn't know who was on the other side of that window. As much as people want to make this a racial issue, it's not.
Nobody brought up race until you did right now.
He didn't know. who
Race
was
is
on
not
other
the
side of
word
that
race
window.
has not been used once.
All he knew.
The skin color of people have not been used once until the defense just brought it up today. Why, bro? Why?
So everything that's happened from then on is of low value in deciding what the sentence should be in this case. We had to file, the law requires that a motion, an application for permission be filed pre-trial, as the judge tells you in the jury charge. That's because both sides have to have the ability to question jurors such as yourselves about your ability to follow the law and to give fair consideration to the concept of probation, which all of you said that you would do. Every one of you. Ladies and gentlemen, on Aaron's behalf, on behalf of police officers and those who risk their lives on a daily basis to keep us safe, we're asking that you give that concept fair consideration here. Because this case deserves that fair consideration. Aaron deserves that fair consideration.
You have 2 minutes.
Ladies and gentlemen, this is Aaron Dean.
Oh,
This is the
God.
man that you'll be passing judgment on in a few minutes.
I don't know how I feel about this move.
You heard from family and friends, members of the community that know Aaron the best.
I think I like it.
He's a good man. He's a very good man. He's a very good man who finds himself in a very tough situation.
I would have said who made an awful
We're
mistake.
asking that you take into consideration all of those good qualities that you heard about. Because this man possesses all of those. Those people got up here, those people got up here, and everything they said was heartfelt. Because they know him best.
He just said heartfelt.
Ladies and gentlemen,
Heartfelt.
you have Aaron Dean in your hands.
Sorry.
And like the prosecutor asked you to do, I hope you remember my remarks when you go back into the jury room. Because like at the first phase of the trial, the prosecutors get to close here. They get the last say. I don't know why, but that's what the law allows.
You don't know why? It's because they have
I'm
the
asking
burden
you
of
to go
proof.
into the jury room, start your deliberations. If you recall the things that I've said here this morning, and you take all of those into consideration, and you arrive at a just and fair verdict. Thank you very
He
much.
seriously just said, I don't know why the state gets a rebuttal. Oh, God.
I have a moment, Your Honor.
Yes, sir.
Hey, I would just like to personally thank Bob Gill for making me look like an idiot. The second I said, he's doing great. All the lawyers in this case are awesome.
May I please
He
call
went
this one?
and shit the
Ladies and
bed.
gentlemen of the jury. Probation. You said you'd consider it. You never promised to give it.
Yeah, for
And I
sure.
want you to remember when the
Good
probation
point.
officer was on the stand. 15 minutes a meeting, maybe up to an hour, but that's usually just the first one. 15 minutes a meeting once a month. 3 hours a year. That's what that comes to.
Yeah, thanks, Ned.
That's what that comes to. When you say probation, if you're considering probation for him, what you're saying is what happened that night, in the early morning hours of October 12th, is only worth 3 hours a year for that man. Probation's not appropriate, and you know it. So let's talk about what is appropriate. Let's talk about what the defense attorney said. He's punished himself enough already.
Yep.
You can
Dumb
consider
argument.
what he told you from this witness
Don't
stand. When he
say
took the
that.
stand a week
It
ago
never
today,
works.
that morning, did that seem like a man who had punished himself? Or a man that
Hey,
had
thanks
given
everyone
himself
for the
an
kind
excuse
comments.
for his conduct?
That
And the defense attorney told you this is an
my
isolated
last comment was
incident.
really
You know why it's
directed
an isolated
at
incident?
a
Because
commentary on Bob
officers
Gill, not myself.
don't act this way. Other officers don't make the same decisions that he made. That's why this is an isolated incident. It's because of him. It's because of who he is. He had a good family. He had a good education. He had a good support system. So why is he here? He's here because of who he is. I want
If
you
he
to
says, "Can I
watch
get an amen?"
that body
I'm
cam
done.
video again. I want you to look at every decision that he made. I want you to look at every time he had the opportunity to save Atatiana's life, he made the wrong decision. And then I want you to look at that in the context of what Dr. Clayton said last week. Because it should all be clicking in your head now. That's who he really is. He's manipulative. The overconfidence, the narcissism, ideas of grandiosity that he can do anything. He flaunts the rules. He runs in, just like I told you. Now when you hear that, the hard charger, the gung-ho, that's who he is. Because those are the decisions he made that night. It didn't just that when that split second when he pulled the trigger. Every step he made towards that backyard was who he is and his personality traits and what he can't change.
I kind of hate that there wasn't a lot
So
of
that's why we're here.
testimony
It's
about
because
him
of
being a
him
hard charger.
is why you're
gung-ho.
sitting in these chairs. You're judging him for what he did.
They're
You're holding him
focusing
accountable
on
for the
so
choices
that
he
they're
made.
using that in argument,
And now,
but they
you
don't
do
really
have to
have
ask
to have a lot of
yourself,
testimony to be able to do that. So
what
it's
is
fair
Atatiana's
game and it's
life
working. I don't really love that
what are you going to
they
tell her family?
don't have more testimony behind that to back that up, more evidence to back that up.
Atatiana, she'll never be married. She'll never have a family. She'll never get to be a doctor. She'll never grow old. Her mother lived longer than her. Mom living longer than a child. At 28 years old, she died.
I could make a terrible joke about it
This
only
wasn't
being
some
2 months
tragic,
longer,
tragic
but
accident. He's
that's
the
not
one that
right.
set everything in motion. Her sisters, her brother, Zayd and Zion, they'll never hug her again. You saw the defendant's sister touch her hand as she left the stand. That close human contact of support.
Oh, was it Brittany that called
touch
that out? Who
anyone
called that?
of her family would give anything for to have one more opportunity to experience.
Somebody
But they
called that
can't.
in the
Not
chat
because
on
of anything
Friday.
that they've done, not because
I
of
didn't
anything
think
that
of
Atatiana
it being
done,
used out
but
of
solely because of the
that.
decisions that he made on October 12th,
Smart.
2019. And that's why he's sitting in that seat. And that's why you're making this decision.
Whoever called that in the chat, take credit for
So
it.
what is her life worth? What are you going to say to them? What are you going to say to this community? She was in her home. I've said this before, but that's because it's so important. Where else? Where else should you feel safe? Not in your own home. She didn't ask for this. Her family didn't ask for this. It was him. So what is her life worth?
Killed me.
We've talked about who the defendant really is. We've talked about Dr. Clayton. We've talked about Atatiana.
He's the reason all the mics are so low in this courtroom.
The defense. All they want to talk about is the defendant. This is the person that lost her life. This is the family that lost a loved one. This is two nephews who lost an aunt. Two sisters who lost a sister, and a brother who lost a sister. And a mother who buried a daughter. A woman who went to college. She wanted to be a doctor. She wanted to contribute to society. And we've all of us, you included, have been robbed by the defendant taking her from us. Is that okay?
You
Is that
include.
worth 15 minutes a month?
I hate hyperbole.
No,
I just
you-
really hate hyperbole.
Is that really what you're going to tell this family? That that's what this is worth? 15 minutes a month? It's not. And you know it's not appropriate.
I hate
The bishop said
hyperbole in a
tragedy will
courtroom.
never be changed.
I love it other places.
He had so many opportunities to make other decisions so that we wouldn't be here. And yet he didn't. He continued to push forward because that's who he is. His overconfidence, his personality.
See,
Can you go
that's,
back to
I
Dr.
don't
Clayton
take that
because it's
away
so
from the
important.
case.
And if someone back there starts talking about his family and the good person he is, and I have no issues with his family. It's about him. That's what you need to direct him back to. It's not him. Who is he? Dr. Clayton told you. And the best evidence to show you, to look into his soul, to tell you who he really was, who he really is as a person, and why Dr. Clayton was spot on in his evaluation of this defendant was whenever he finally got into that room. And take this back and watch it again. Finally got back into that room.
It's
and
when he
Tatiana
finally
was
got in
taking
that
her
room.
last breaths
That
on the
drives me
floor
nuts too.
in front of
Not
her
whenever he
nephew.
finally got in that room. When he finally got in that
gasping
room.
for air, struggling to live, and he
English guys,
stood
come
over
on.
her, lorded over her, providing no aid, not attempting to do anything, only looking for that gun to give himself yet another excuse for his behavior.
Yeah, 10 minutes, Mr. Smith.
That's his heart. That's who he is. And she deserved better. She deserved better from that defendant. And she deserves a sentence from you. Don't just stand there and watch this happen. Take action.
Did he say watch this
Tatiana
bullshit
deserves
happen?
Give him the maximum. That's what her life is worth. Give him the 20 years. Thank you.
I'm glad he said at the end because I was still a little confused
Okay.
if it could be 10
Sorry,
years.
Your room, if you need anything, let me know.
Can we get an 8 man? All right, let me kill this. Maybe, hopefully. All right, so there we have the arguments. I want to hit on a little bit of what you guys had to say because you guys had some really, really good comments. But first, I want to see if I can get this question answered. Does anyone, and please, if you do, please speak up in chat because I want to hear the other side. I'm probably missing this. But where in evidence are we getting that he was a gung-ho, hard-charging cop? I don't see this incident as I don't see this incident as a classic hard-charging gung-ho cop. I mean, I guess it's because he didn't back off. Maybe that's it. But that's not the to me wasn't the huge takeaway I had on why to convict. No evidence. Come on, okay. I was hoping someone would disagree with me. Anyway, let's go hit your spots. Or hit a couple of your comments because there's some good ones here. Okay, yeah, you guys all agree with me. And I don't like closing arguments that have a theme that doesn't align with a huge portion of evidence. I don't think they're doing anything unethical in terms of how they're doing that. All right, Brittany, what do you think? Okay, making the story based on the psych doc, and the psych doc did say he was hard. You could definitely take from the psych doc's testimony that he was hard charging. I hate that, and that couldn't have been in the guilt phase. I don't think they might have been able to get that in the guilt phase to go to state of mind. But this judge seems kind of hardcore about that. And then no evidence, but trying to make it look that way. Yeah, and I think the psych doc is a little bit of evidence, so I think that's a really good point. Yeah, it was his personality test. Had a flashlight and extra gear. Okay. Let me think through that, because my takeaway from flashlight and extra gear isn't hard charging. To me, that's preparation. But then again, why do you need a flashlight on your gun if you're not going to be pulling your gun all the time? I could see that state of mind as being hard charging. I see what you're saying. Yeah, let's go see what else we have here. Yeah, I don't like, I mean, a lot of you guys agree with me. That's probably why you're here. But I just, the evidence wasn't strong enough as to him being hard charging to make it your theme of your close. Again, I don't think there's anything unethical. But I also think if you stand to the most utmost, is all that noise coming through? God, my house got loud. It's winter break already. What else do we have? I saw a couple other things in here. Okay, I can't find exactly what I want, but I'll just hit on that closing real quick. I think the state did an excellent job, despite. So I have a few. We'll call them ethical problems, but I don't think they're going beyond actual like into ethics violations. I have a few ethics issues with what the state is doing. We just talked a lot about the one in terms of honing in on hard charging. The other, I mean, in closing argument for penalty, I think it's I think it's much more appropriate to be emotional. They didn't get as emotional as they did in the guilt phase. Miss Dean has surprised me. She's got stronger as this case has gone on. Her closing arguments to, if you're considering, she's putting this in front of folks that aren't probably not as analytical as most of this chat is. I think she went to a good theater school. That was a damn good speech. Good pace, great tone. Sitting on the desk kind of was good. Then we had the defense come out. His initial argument was great. The initial argument of one, like, I mean, going after the fact that he's not going to be a danger to society is right. Having him stand up, I thought was great. That whole middle, so the big on-force error in this whole thing, and this was short, so there's not a whole lot to commentate on, but the biggest on-force error is why in the hell did he Oh, there's two. I saw one other one, and it started with why in the hell. But let's go with my first one first. Why in the hell did he bring up the? I wish I knew her name. I need to start I'm gonna get a legal pad for the next case. But the we'll just call it the victim of his prior assault. That's what it is. Why in the hell would you bring her up when the state? I don't think they mentioned her at all. If I was rambling and missed it, they would have just barely touched on it. I don't think they did at all. Why in the hell would you bring that up? Why would you focus on it much more than the state did if they did at all? Dumb, dumb, dumb. Maybe he wrote this thing thinking that's what they were going to harp on and wasn't ready to change it on the fly. But it's kind of easy to change it on the fly. Cut that out. You don't have to rewrite anything. Cut that portion out. Have a little bit shorter of a closing. God. On forced error. And then why in? Now, so I don't know if everybody knows this, but there is not a black person on this jury. There are said to be maybe 3, possibly 4 people of color on the jury. And there is when the jury was selected, that was the headline in the Dallas Fort Worth media, that there are no black jurors. Okay, fair enough. Race in these things can matter. I'm in no way scared of talking about race, especially when in a very demographic general form, and not stereotypical form, but in the general form of makeups of a jury matter. So maybe he could get away with this a little bit, but why wait till the 11th and a half hour to bring up race if you want that to be part of your case? And then in this situation, why in the hell would you want that to be part of your case? And just as a person, as an American, I hate that he brought up race when the prosecution didn't. The prosecution alluded to East Side. I have no idea the actual demographic of the East Side. I'm purely speculating that her comment there might have had a racial undertone. He had no need to do it from both a legal, from a tactical strategy standpoint. There was no reason to do it, and just from where we're at in the social implications of a case like this, there was absolutely no reason to do it. Crazy. Let's see what Miss Pris says about the racial aspect. And guys, I pulled these up before I fully read them, so I have a thought about the racial aspect. I find it strange that there were no black jurors given the community demographic. I did too. But I mean, but it's, I think the thing that people miss, when I say people, the mainstream media in this case don't understand, is that it is up to the prosecution and it is up to the defense to get who they want on these juries. The prosecution may very well have liked other folks. I shouldn't say liked. Have thought other folks would be more favorable to their argument than the potential black jurors that were in the pool. Now that said, there was one black juror selected, but then she was dismissed. I think it was due to a health issue. It was not due to misconduct. I know that. It was due to something totally outside of, and I think it was her. I'm almost positive it was her. It was something totally outside of her control. But she had to ask to be dismissed from the case. So there was going to be one. But the media went and ran with that. And I honestly don't think it matters that much in a case like this. Sure, in the George Floyd, Derek Chauvin case, it absolutely mattered. In the Kim Potter case, I think it mattered a little bit just because of where Minneapolis was at the time. By the way, my favorite cousin will be here in a couple days. She actually lives a block away from George Floyd Square. I think that's what they call it, where that incident happened. It's crazy. But I don't think race really mattered that much in this case. With the exception that I forget that we're watching this on TV. The jury is watching this inside of the courtroom. And I'm sure that the racial makeup of each side of the aisle is so stark that that it'd be impossible for, completely for people that don't think about it that much to notice. I think this is way more pro-gun. Maybe. Okay, so let's think about it from this standpoint. What if it was what if the jury was made of a bunch of gun-toting libertarian white dudes like me, who were like, she had every right to point a gun at that cop, and he had no right to shoot her, and we're going to find him guilty because of that. I think that's just as possible. I just don't see, and it could have been it could have been a demographic, could have been pro-cop or anti-cop just as much as race. And we all know that all intertwines. I honestly think, and maybe this is just okay, yeah. And when you guys bring up better comments than where I was going on a tangent, I'm going to switch and go to your comments. I think you're very right. And let's push back against that racial narrative for a second. Let's stereotype just for the sake of argument, just for the sole purpose of building a case, a thought experiment. We're going to stereotype for a thought experiment. Atatiana Jefferson is black. She was in a neighborhood that was less expensive to live in than a lot of neighborhoods in the Dallas-Fort Worth area. The East Side is supposed to be is supposed to have higher crime. We would probably think that she may be anti-gun. That you could make a lot of stereotypes and make the leap that Atatiana Jefferson would be anti-gun. Well, in Texas, someone like that still has a concealed carry permit. It's not like she just had a gun. She went and got her concealed carry permit, which means that she took training and had it for self-defense. Stereotypically, that's not. So I think that's a very good point. And let's just we're stereotype Texas, right? It's Texas. They're all very pro-gun. So I have verdict watch up. I think they're gonna have a verdict quick. Trying to think of how I can do this. Let me try something here. Because I want to have verdict watch. I want to have everything I need to make sure that we don't miss the verdict. But I still want to I also want to go and watch the Mark Jensen stuff. I think this is going to work. Yeah, this will work. So what I'm going to do is put a Twitter notification for any time that Kathy, what's her last name? Kathy Russo, I think. Kathy Rusan, who's in court, tweets. And then, so we will, I think she's there. Let me make sure. Yeah, she's at least monitoring it. So let me throw notifications on her. And then, Chad, if you can watch as well, we'll then go to watch the Mark Jensen hearing. And actually, before we do that, sorry, y'all. I also need to go make sure that I update our description to make sure that everyone knows that we are now on Verdict Watch. All kinds of fun stuff I get to do. So, yeah, I think he's not getting probation. I'll make that prediction right now. He's going to spend time in jail. I think it could still be 2 years. But if I have to make a bet, I'm going to bet it's 5. And I wouldn't be shocked if it was 10. I don't think he's getting 20. I will be shocked if he gets 20. All right. Verdict Watch. Aaron Dean's fate is now in the hands of the jury. Let's publish that. Makes me make my content warnings every time. It's so ridiculous. One thing I didn't fully understand before I started doing this was the work that YouTube makes you go through. All right, so that's set. We have notifications set for Rusan, don't we? Oh, ring that bell. Hey, speaking of it, so I just rang the bell for on Kathy Rusan's tweets. So if you all want to make sure that you ring the bell on my YouTube channel, that would be awesome. Get notifications whenever I come live. We're all set. So let's go. Hold on. There's a reporter on. Let me pull her up real quick. Let's see what she has to say.
Heard the threats, that I could see why they made the decision that they did. I guess.
Let's hear what she has to say. The reporter at WFA is pretty good.
Well, I mean, if a judge feels like there is a threat in the courtroom, and they have undercover officers in there that heard the threats, then I could see why they made the decision that they did.
Not uncommon to have undercover officers in a courtroom for a case like this, by the way.
You should be allowed to say what you want to say in regards to protesting and that kind of thing. I do understand that, but if they have threats and they have heard undercover officers hear those threats, then I could see why
you should not be protesting in a courtroom either, lady.
Take it seriously like that.
Well, you could tell though that it was clear that Miles and also the judge felt they very much needed to explain themselves what went down in that courtroom on Friday.
Absolutely, because they had everyone asking, like, why aren't you out? Why can't we see what's happening? Why don't we know what's happening? Why did you lock the courtroom? I mean, there were a lot of questions.
Okay, so the terroristic threats were what was we discussing.
Yeah, I mean, I wanted to hear a fuller explanation. What do you think, Kobe?
Okay, I don't care what they think.
I mean, I guess it makes sense. I mean, we're having to take.
Whatever. Yeah, so that makes more sense. I was a little concerned why they would have contempt of court hearings in a locked courtroom. I can absolutely get behind the fact that they had undercover cops, undercover police officers, letting the judge know about terroristic threats in a courtroom, and it's because they don't want to reveal source and method, which is if they made the undercover police officers testify in open court about this, they would have to go find new undercover officers for the rest of the trial, and folks would know what to look for in terms of who was an undercover officer. I can get behind the fact that they did that behind closed doors, while still keeping it on the record. I'm okay with that now. All right, let's go to Mark Jensen. This is a fun little hearing. It's only about 30 minutes long, and we're in verdict watch, so let's watch it. 1 second. Sorry, I got kids home. All right, let's watch this. Oh, and they cut it down, so hold on. Sorry. Get it set. They didn't cut it down. And dogs are barking. 1 second. All right. Sorry about all that. Let's go with the Mark Jensen hearing. Remember, this guy's been in jail for, I think, like 2 decades. This judge is fun.
Absolutely.
I enjoy him.
You guys want more chairs?
I think you all will too.
It's going to be a while. Could be. There's
Mark Jensen trial starts on January 9th. We'll be watching it. I'll be doing my research in the next few days and coming up with some really good videos for you guys. But I think this is his 3rd new trial. The judge refers to Mark Jensen 1, Mark Jensen 2, and then this trial. I've only read about one previous trial, but this is definitely a new trial handed down, sent back, or a new trial. I shouldn't say sent back because that would be more of a retrial. This is a new trial ordered by state Supreme Court.
she can.
I'm gonna be quiet because the judge has fireworks just at the very beginning.
All right, we're going to call number 2, Mark Jensen, 2002 CF 314. Let's have the appearances, please.
The state appears by Carly McNeil and Special Prosecutor Bob Jamboy. Attorney Bridget Krause, Jeremy Perry, and Mackenzie Renner appear on behalf of Mr. Mark Jensen, who appears in person in custody. Good morning, Judge.
We have victim notification from the state.
We are in compliance.
All right. We are here for a final pretrial. We have a jury trial date of January 9th. We have some motions that have
I
to
think
be
that's very
signed.
possible. I think
went
he has some
through all the
really deeply held religious beliefs.
letters and the briefs and all the documents. that were
And he
filed
may
as to the
truly feel like
motions, and
that.
I'm just gonna
I mean,
go
I
through
believe
them,
Kim Potter
right now.
felt that she deserved to go to jail for at least
first
some
one
time.
that I want to deal with is the testimony that was in the original trial, which I will call Jensen 1. The transcript has been provided. I'm dealing with a letter that was dated December 15th, 2022. It's on the issue of the termination of Maureen Levin, who was the prior county's medical examiner. The transcripts that were provided from the original trial, there was a question to Dr. Malin that says, you knew at the time you were hired that Dr. Levin had been fired from her position. Yes, and that she was fired for conduct in this very case. She goes on to answer under oath, I heard that may have been a factor. I really don't have access to her personnel file, so I don't know the whole case against Dr. Levin, to be honest. The next question was, when you took the job, there's something you were interested or why Dr. Levin left that position, right? The answer was, well, we're all kind of nosy, but I did not know. I did not go and inquire of the personnel department why they fired her. The next question was asked and her answer was, I heard the scuttlebutt that occurred. I heard the scuttlebutt. So, I mean, that's all. We're on the record.
We're on the record. Please, no side
That's all
conversations.
Speculation. She has no knowledge of why this doctor was fired, and she admitted it under oath. In court, it's not like she's given some sort of statement to one of the attorneys. She's basically saying, I don't know anything. I'm speculating. It's all scuttlebutt. So that line of questioning is not going to come in.
Judge, can I ask for a clarification? Is the
No, we're going to make decisions today, okay?
Want to make sure
I
that
just said no. It's not coming in. All right.
I think he's just dealt with a lot because that wasn't like overly grumpy. It wasn't like over the top, but it's a little more than it's a little
Here's the,
shorter than we hear from most.
Important.
He was a little short
motion today, and that is
even for most
the
judges.
decision that I'm going to indicate for the record, Jensen 1 and Jensen 2.
He talks about Jensen 1 and 2. I promise I'll get some good videos out over the next few days for you guys on this.
Second 267. And State versus Jensen.
I think a jury is back by lunch, by the way.
440. They're both identical as to the letter. And they ruled that the letter was testimonial. And they both ruled that the statements made by Julie to Kosman, who was a police officer for Pleasant Prairie, including the letter addressed to the police, are testimonial. So that letter, those statements, it's not coming in at all. I'm not the Supreme Court. I'm not the Court of Appeals. This is the law of the land. It's not coming in. But all the other non-testimonial statements, and the testimony, it was in the first trial. It says here, the statements Julie made to her neighbor, talks about Wojt, W-O-J-T, her son's teacher, DeFazio, all those non-testimonial statements that are in Jensen 2, which is 331 Wisconsin 2nd 440. They're coming in. That's a distinction. And that's the law, and that's what's going to be going to happen at the trial. And if anybody does anything different, they'll pay the consequences. And it's the same
pay
principle.
the consequences. He seems very deliberate in his decisions.
For this,
which then it makes him empowers him to
the defense has
be very stern in his rulings.
And
also, this case has already been
who's
essentially overturned once. He's not about to have it be overturned
I
again.
reviewed it, Dr. Sarah West.
What's it?
Dr. Sarah West.
All right. Now, I read State versus Thomas, 399 Wisconsin 2nd, 277, and it talks about that the state shouldn't have an opportunity to bring in this inadmissible evidence through some sort of back door. They can't get it in through the front door, so they shouldn't get it in through the back door. I know that the expert looked at the letter and used it in their opinion, but if we look at page 305 of the decision, it talks about the Supreme Court quoting Professor.
And
Dave
y'all
Jones,
remember our
who's
main
well
purpose of
respected.
being here is a verdict
says
watch for
problems
Aaron Dean.
arise.
So don't feel like you got to stop your
If I do give
conversation
some
about
sort
Aaron
of
Dean.
limiting instruction, which
I'll
the
still pull
state
those
is
chats up
asking
and
here,
throw my 2 cents in too.
it's meaningless. It says the jury's going to know about it then. I know Mr. Jamboy's gave me a limiting instruction that says it's only going to be used for limited purposes, but the jury's going to know. And I think limiting instructions sometimes, I agree with Professor Boinga, are worthless. They get to hear it then. And then I'm going to tell them they can't consider it for the truth of the matter.
I hate limiting
or the
instructions.
guilt or
I am 100% on
innocence of the defendant, but it's already
on his
in.
side on this.
So to be consistent.
And what he means by that
Jensen 1
is
and Jensen 2,
letting
that
something
this
come
letter and
in,
all the
but
statements
saying that
were
you're
ruled
only allowed to
testimony
use this
are not
evidence
coming in.
for the
We're not
limited
gonna get
purpose
into it
of
with the expert
X. And come on,
either.
juries try. They try to follow their instructions and all of that, but we all know if a bell is rung, it can't be on wrong. This
I have
judge is
not gotten
wholly
it
right
yet.
on the
It
limited
was put in
instructions.
the mail sometime Tuesday.
All right, I'm going to reserve that until you get that disc because I did make the ruling on it. The other ruling that I wanted to make today, and I'm going to reserve it. I still haven't determined what to do with it because it's not an easy issue. Is this letter that Mr. Jamboys wrote to the prior attorney that the state wants to use when they cross Dr. Long. So
To me, this judge seems a little bit more
I'm sorry,
pro-defense
you're
than
correct,
most.
Mr. The defense wants to use.
And that just might be because
That's a
this
very close call.
has
and
already
I'm
been
gonna
overturned
wait to
once.
make that decision. I mean, I
Or
don't
it might just be
think
his
it's gonna
style.
be a major problem for the attorneys if I rule one way or the other.
I
So,
can't wait to watch the trial with this judge. January 9th, guys.
okay.
This guy's going to be fun.
Any other motions that I missed that I was supposed to decide from the state?
Yeah, I don't think so.
Any motions I missed from the defense that I didn't decide?
No, Judge.
Okay. Next thing we're going to cover is when we do come back for the trial, we're going to have 80 jurors here. We're going to seat 28 jurors. We're going to have 4 alternates. Each side will have 6 strikes. To have no issues as to any prior publicity or some sort of issues of prior knowledge about this case. I'm going to have 10 jurors come over at a time. The others will be in another location, and each side will get to ask 5 questions as to
Jury
prior
selection
knowledge
is going to be
and
audio
publicity
only.
to these
As
10
long as I can
jurors.
find the feed of the audio,
And
we
if
are
we have
absolutely
any
going to listen to
issues,
it.
Those
I
jurors
think
will be excused so they won't poison the whole
juror selection
proceeding.
is
The
critical
other
to
ones that we will keep will go
our
to another
of this channel's
location,
understanding
and we will go
of
through
what's it's critical to my
all 80
analysis.
then,
And I think it helps
10
you
at
all
a
too.
time.
So I will
Once
definitely
we've
stream the audio if I
completed
can.
that, we'll bring everybody back and we'll do the regular voir dire. I don't want to have all 80 in this courtroom and then somebody starts talking about prior knowledge, and then we have a problem with that whole pool. Any problems with that from the state?
So, Judge, I'm just looking at 972.03 for the peremptory challenges. And it looks like because this is a life imprisonment trial, then each side gets 6 strikes, as you had mentioned.
Right.
And then I'm just reading a little bit further on in the statute, and I think it says if there are going to be alternate jurors, then each side is allowed 1 additional peremptory.
Then we'll go to
challenge.
7 and we'll put 30 in the box.
So this is the state making an argument that they don't really care
I'll
about,
change my ruling. We'll have
with the
30 in
exception of
box, and we'll have 7
they
strikes.
care about following
And
the
Your Honor, are you
statute,
planning on having
because
the
if they
jury selection in the
don't,
courtroom, or are you
it
gonna
gives
do
this
a grand-
Mark Jensen
Judge has a
another
jury
very
trial.
appealable issue in the
Oh,
future.
so we're gonna be doing.
They don't care if there's 6 or 7
Busy week.
preamps. They probably would
So
rather
I
it
know
be
you
6.
turned around. There's not a lot of room here. We're gonna
Oh,
have
yeah,
to
so check out this courtroom. This is the courtroom they're going to hold this trial in. It's tiny.
So I asked the state, any problems with doing 10 at a time?
No, Your Honor.
Any problems with the defense?
No, Judge.
All right. The next thing to help the, I'm sorry.
So there'd be 10 in the box. The rest of the panel would be all seated behind us.
No.
I love how
rest
they
of the
both said
panel
no,
are
Your
gonna
Honor,
be
and
in
then
a
are
different location.
completely confused
We'll
on what he
put
was
10
saying.
in the box. We finished with this 10. They go to another location. We bring another 10 out until we're done with all the 80. And then whoever's been knocked out won't come back, and we'll bring everybody back that just passed the first 4 deer
So we'll
test.
do like 8 voir dire. Is 10 at a time.
Right,
So it'd
we'll
be
do it
voir
8
dire.
times.
But just the limited voir dire
Right.
as to the publicity, and then the
Yes.
big voir dire will
Right.
be everybody else. Yes.
And again, 5 questions apiece. We're not going to hammer them with 100 questions. And I think it. I've
They get
done
all
it
confused
before.
again here, too.
The
It's
5
amazing.
questions, you can get right to the point.
Yes. So each side gets 5 questions during voir dire.
Right, for the first voir dire. The second voir dire, we're back to the normal, whatever questions you wish to ask. This way, we're not going to have any problems.
Okay.
Dude literally thought he was going to give him 5 questions for
Because of the
voir dire.
tremendous amount
Voir dire.
of
Voir dire.
exhibits in this case, I want both sides. This doesn't mean you're going to have to. You're going to use the exhibit to make a list of their potential exhibits, because it would help the court and the clerk to know that.
Okay, just the list of the exhibits, not have to actually produce the exhibits themselves?
No,
Yes?
just the list. Just give us a list.
Okay.
The state clarifies every
Judge, as
freaking
to exhibits,
ruling.
Is there a specific number?
It's not that
we're
complicated.
gonna start with, or are we just gonna alternate as we're going? Like, is the prosecution gonna start with 1 and we're gonna start with 200?
That
or-
said, I never have a problem with people asking me clarifying questions because I'd rather be clear.
Exhibits you have and the prosecution will have, they have to go in order
Okay, so they'll do theirs and then ours will be
after
after
what,
that.
yeah,
Okay.
if you let them know.
Obviously, the parties are aware of the press and the
This is important
live
for us.
feeds that are going to happen during this trial. We're not going to have any photographs or live TV cameras when we do the voir dire. The only way the press can do that is through audio. I'm not going to have a issue where they're filming the jury during voir dire. There's just
So-
too many issues.
I'll reiterate on that. I actually agree with
Once
his
that
ruling on
phase is
this.
completed,
I'll reiterate on that. If I
the
can get the
media
audio
can do
feed,
their
I'll
normal
play the audio.
activity.
I think it's helpful to
The
us.
other rule that I wanted to enforce.
And we weren't
during
going
the
to see much
trial,
anyway
and
because
this was
juries,
the
you don't
attorneys
want to
to
risk
tell
the
their,
jury being exposed.
their witnesses or whoever's going to be here for the trial. Once we start the trial, if somebody wants to leave, they are free to leave, but they're not going to go back in and out. This door is right by the front door of the court entrance. You open this door during the day, you cannot hear what is going on.
I'm an open court
You can be in
absolutist
here, it's open
who also
court,
agrees with him on this.
But if you have to
I think it's
leave,
fine.
you're going to have to wait for a break to come back. I don't want people coming in and out, in and out. It's just terrible for the
Record.
record being made.
And it's in fairness, if it's that bad for the record being made, it'd probably be bad for us trying to view it on on a live feed too. I have a feeling this judge is going to make sure the mics are good.
Okay.
I think we're going to have good audio in this.
Anything that the state wants me to address further on this case?
So last time we had indicated to the court that we wished our investigator to be accepted from the exclusion order, and we
He's
still
gonna have to bring his own chair. There's no more chairs.
You can sit on the floor.
All right.
So I think the only other person that the state would request is there might be brothers of Julie Jensen who would like to watch at least parts of the trial. And they are also listed as witnesses, but I believe they should be accepted from the exclusion order as victims under the definition. They do meet the definition because they are siblings of the deceased person.
Defense has no objection to that.
What's that?
We have no objection to that.
All right, thank you.
And so I believe there's 4 brothers that we have listed, and so each of those is what we're requesting.
Yeah, I don't
Anything I missed from this?
see any reason to object to that.
Judge, the only, there's 2 things that I'd ask the court. Number one, is there a way to get one, I don't know if there is, one table? We have a lot of exhibits and it's going to be hard.
You mean an extra table?
Either an
Oh,
extra
I meant so
table
last time I thought it was the
I'm just
prosecution asking for
concerned
this.
because of the volume
So
of
the
transcripts.
defense has a lot of
And the
physical
case
evidence?
physically not
That's
enough
interesting.
room on the tables to deal with that. I don't know if that's possible, but I just wanted to ask.
We could move something up
Yeah.
front
We have
here.
a folding table, and we could.
We could put one up here maybe.
Okay. And then the second thing is, I know the court ruled that the manuscript as described by the prosecution was admissible and denied the motion to reconsider. Within the pages that were filed by the prosecution within the last week, one of those includes the actual letter. And I assume that based upon the court's previous ruling that that would not be allowed.
The letter's not coming in.
I understand the court's ruling, Your Honor.
I don't want to keep talking about it.
Yep.
I'm not the Supreme Court. I don't want to be on a Supreme Court.
That was the only other thing that had recently been filed after the last motion hearing that I.
I
just wanted
think this
to
is more his
clarify.
sense of humor
Some
than being
additional
like
stuff
an
was filed
angry
yesterday,
guy.
but I believe we're
I think he
gonna be
gets a
able to
little loud when
provide
he's trying to be a little
the
funny.
transcripts that were provided.
All right. I do have one more thing to say. Both sides filed an order from the last hearing. I didn't hear any objection from either side, so which order do you want me to sign?
So
I'm talking about the order about what was decided on November 21st. So I got one from the state, and then I got one from the defense.
So Judge, somehow we must have missed the defense's order. I did not see it. And so when I saw the entry into CCAP of the order, I thought it was mine. So that is.
So we haven't seen the defense
Yeah,
order.
that's-
Could we see it? It's
E-filed.
filed.
And I would ask the court to sign the defense. I think it's simple and just states exactly.
I don't
what
want to
the
get
court
into that argument.
That's fine.
You know, you guys got to work that out.
The male prosecutor
We can
seems
do
a little
joint
dopey,
combined order after the
That would be
ruling.
one.
and the judge doesn't like him.
Sorry about that confusion, Judge.
It feels like if you're coherent and make coherent
Have
statements,
that
arguments
done
with the
prior
judge,
to,
he's a very nice guy. But the second you're,
Okay, again, I
it's
still have
filed,
the
bro.
one limited issue that I will decide on that day. Okay, anything else before we're adjourned from the state?
No, Your Honor.
Anything else from the defense that we're adjourned?
Nothing, Judge. Thank you.
Thank you.
All right. Well, that was short and sweet. I just wanted you guys to get a little bit of a flavor for the judge. I think he's going to be pretty pro media, at least moderately pro media, and I think we're going to enjoy him. I think he's going to give us a few good moments. All right, let's go for Sarah Boone as promised, and let me actually check on see if we see anything in the Aaron Dean case. Nope, I see messages. Oh my God, I turned chat off. Sorry, guys. Let me go fix it. Thank you. Who learned me that? Is it Jahag? Jahag, if you're still listening, thank you, man. And your snark in your comment is absolutely much appreciated too. What an idiot. I'm so sorry. I had no intention of turning chat off. What happened is I went and updated the description on the video to let everyone know it was a verdict watch, and fucking YouTube. It's me. I can't blame YouTube. I'm an idiot. I clicked the wrong button and turned chat off. Welcome back, chat. Welcome back. You guys should be able to respond now. Please, someone say something to make sure that it worked. I miss you all. Again, and Jahag, if I'm mispronouncing your name, please forgive me. But again, thank you so much for alerting me to this. I yeeted the live chat. I did it. I did that just to get you guys to follow me on Twitter, so that you could DM me. I swear. Hi, chat. Sorry, y'all. My chat is my favorite part. Hopefully, you're all back. It says you should be. Back. Oh, you're gonna all have to refresh too. Ugh. Welcome back. Sorry about that. I was like, why am I talking to myself? They're all just completely bored by this judge. He's not nearly as fun as I thought. Well, at least y'all could hear me. At least I wasn't on mute. Yeah, chat will never be disabled intentionally. That is definitely against my brand. So anyone have any thoughts on that, Judge? I'm just going to pull up the... It's funny. I saw a bunch of DMs and I was like, oh no, am I missing the verdict? No. It's everyone just trying to tell you that the chat's not working. Okay, let's go. I don't see anything coming out in terms of a verdict. So let's go. Let's go watch Sarah Boone's body cam. I think Sarah Boone's body cam is more interesting than her police interrogation, because by the time you get to the police interrogation, we kind of know, and we'll go in order, because if this deliberation goes longer than I think it will, we have something else to do, and that's to watch a very long police interrogation. But let's go with body cam first. That way we go in order. And I'm not gonna lie, the first time I ever watched the Sarah Boone body cam, I had a little bit of, I thought she might be telling the truth for a second. And then reason took over. All right, Sarah Boone, body cam starts now with chat able to comment on the ridiculousness. Yes, Brittany, I saw that. I just accepted you too. So now you can, oh, you actually signed up for Twitter? You guys have my back, but no, that was my strategy all along. I needed a few more Twitter followers today. So I set you all up. Brittany, welcome to Twitter. It's not as fun as YouTube, but it's still a fun place, especially as of late. All right. Very beginning of the body cam. Speaking of following me on Twitter, I'll throw out all the normal stuff again. Please hit that like button. Please, please, please hit the notification button. I think the notification button is most important to me because when I go live, I want all you all to be able to know, at least. And then hit the subscribe button if you already haven't. And we should have full volume here. Body cam should be on now. He might just not be saying anything. His audio should be on by now, though.
Yep.
He was last seen last night, so.
You could get all your guys out of there.
What's that?
You could get everyone out
Wrapping
of
up
there.
good info. You gotta report out the LUDs and stuff.
Oh, yes, thank you.
I watched this a long time ago, so I haven't seen it in a while. The one thing I kind of remember is I feel like the police did a really good job. But again, it's been a long time. I could be misremembering.
Who pronounced?
She did. Oh, right there.
Did you call it? What time did you call it? Hello there. You live here? Yes. Okay, I'll talk to you. We gotta get some information from the fire department.
The property manager.
Hey, Jolly Rogers.
Tell him really quick, or
Um,
where is he at?
we heard closing arguments in the Aaron Dean
We'll take care of that for you.
penalty phase. I think the prosecution was strong. Now we're on verdict watch. Just we're watching Sarah Boone's body cam. And you also miss me complete. I'm not a boomer. I am actually by age definition, I'm not a boomer, but I boomered the chat for a while, so you missed that fun.
Put the time that you called it. That's the time you called it? Okay, perfect. You can't go back inside. What's going on? Who is he to you? Boyfriend?
Yes, for like 3.5 years.
What happened?
He and I, we drank last night. We had a.
Can you pass this to the around to the FD guys? Stop. They need to sign that for sure.
They're with me, so they're not.
Oh, they're not leaving.
I
Okay.
think I woke her up.
No. Each of them has to. So this might be a real thing. So each of them has to put their name.
Normally
in
we all I just put everybody.
What's going on?
Sorry,
I just got here, so fill me in.
No problem. Like, he and
I remember this deputy being
You were putting a puzzle together.
having a very good command of the scene.
Okay.
But I could be wrong.
Stuff off the wall to make
It's been a while.
new art put up there, like having a good time with one another. But we're drinking. We had a bottle of wine last night.
Okay.
So then it's like we decided to play hide and seek, right?
Okay.
So he gets in the suitcase. Okay.
Who is this guy?
That's my ex-husband, my former husband.
How did he live here with you guys?
No, I called him over here.
Okay.
I didn't know what to do.
Okay.
I didn't know what to do.
Okay.
So then he came over here.
Here, let's talk in private, okay?
I called you guys.
It's not stereotyping, it's analyzing, and I think you're spot on.
The problem is I fell asleep.
When did you do CPR?
This morning. When I.
Wow. I gotta fix this.
I found
It just hasn't been breaking.
Before you called. 1 o'clock right now.
I tried. I was awake, but I actually got out of the bed at like 12:30ish, whatever. So I came downstairs and I was like, oh, he's in the suitcase still. And that's when I found him and I took him out. I tried doing CPR and then I called him and then I called you guys.
Did he get here before the fire department got here?
Who?
Your husband or
Yes.
your ex-husband?
Yes.
Okay. Where did he live at?
Right down the street.
So you were planning.
Yeah, thanks, Kara. Well, and yeah,
I did, but then I fell asleep.
plus your donation is gonna go to that. I promise.
I wasn't here. I'm just trying to figure out what happened.
There's way too much going
I
on.
don't know if he suffocated or like had an aneurysm or a heart attack or what.
What kind of medical conditions does he have?
None that I know of.
Nothing that you know of.
None
You
that I
didn't take
know
any
of.
medicine
No,
last night?
no. All we had was a bottle of wine. Literally.
I missed
just
it
a
the
bottle of
first time,
wine.
but she's got the high pitched
Doing her artwork.
the high
It was
pitched
great, so I
lying
had him
voice
speak.
going on.
That's all that happened. Okay. So I don't know if he had a heart attack or what in there. Like, I don't know what happened.
So how long were you doing CPR on him prior to you calling 911? You tried that all morning?
Yes.
How did I miss that the first
Then
time?
I
That's
called
like
him while I was
What
doing
time
CPR.
did you start? Probably.
telltale sign of lying.
Ballpark. Here, let me fill this deputy in, okay?
Please, may I have my Dr. Pepper? I am
Hold on,
so
one
cotton
second,
mouth
one
right
second.
now.
Ma'am, and you can't talk to him until we get done with this, okay?
Just don't leave, okay, Brian?
Thank you, ma'am.
Well,
Appreciate it. Thank you.
I feel bad for her ex-husband.
Do me a favor. Stand over there by that car. Give me 1 second. Just give us a second, okay? We gotta
Somebody else on that call operation.
It's on the counter. I can't remove anything from out of the house. Here, I want you to sit down because I don't want you passing out. This is probably a lot for you to deal with, right? Sit. I don't
water. Just water.
I can get you some water, okay? Just I want you not on your feet because I don't want you passing out on me.
I need water.
Okay, I'll get some for you.
You're trying to, Charlie, but you're on it.
Okay, so you don't live here in this house.
Fair enough.
No, I live down in Lake Winona Cove.
Lake Winona Cove. Okay. So kind of tell me how you came here today, or
Well, I had been calling.
come down here. We gotta talk about
I've been calling since.
You've been calling your ex-wife or current wife?
Yes.
Okay.
No. Ex-wife. We've
Okay.
been divorced about a year and a half. About 11:30 is when I started calling to find out because this is supposed to be her day. So, her child.
Okay.
She's generally not very good about always doing it. She tends to drink.
They called back and said still there, or she came back.
So I was calling to find out if she was going to be getting him or not today.
From school.
Yes.
Okay.
Yes. So I started calling like 11:30, called every half hour or so, and then
She was back and said the lobby.
finally got a hold of her
I'll go
at
back to you.
12:49, which is when she told me what was going on and if I'd come over here. So I came over.
She called at 12:45.
Yeah.
Okay.
Or 12:49.
12:49.
Got over here, told her she needed to call 911, get somebody over here, and then basically she said she needed to go outside, have a drink and a cigarette. I walked back out the house because I didn't really want to
Who
be
called?
there.
Did you call or did she call?
Well, I called. She called me back when I was on my way to make sure I was coming over. But I
He
called her.
seems
You want
way
that,
too
okay?
put together to be have ever been
I called her
connected to
Do
the
you have water in your car by any chance?
clown show. This Sarah Boone.
Nothing?
No,
Okay.
No, I don't.
Okay, so she called, you get over here.
Well, I called her first.
Okay.
Trying to find out if she's going to get Lucas. That's when she told me everything's going on. I got my stuff together, put the puppy up in his crate. When I was starting to drive over here is when she called me to make sure I was coming, and then I got over here right after.
Did you go inside and see, and then?
I walked inside the front. I didn't see the little front tile area.
Come on, step this way.
I saw legs. I just didn't really want to get her around it, so I told her.
Well, just for the sake of the crime scene, I want to know if I were to find your footprint, it would be because you went this far into the house. So did you actually make entry past the threshold?
I don't think I ever made it to the carpet. I think it was just in that.
My memory is right. This deputy was on top of her shit.
No, I don't think I stepped past that tile area.
Okay, so
Maybe she's an investigator, but she's like right on first at the scene. I think she's just a
Okay,
really,
so
really
that's the gist of what you
good
have.
deputy.
Well, sit tight for us. We're gonna make a few phone calls and then we'll go from there. Do you know any medical issues or?
I don't.
Okay, but you've met him before.
I've
Because...
met him before, yes.
Okay.
Yes. They've got a whole fun history.
Oh, really?
Oh, yeah, you guys have called over here quite a few times.
For the two of them?
Yeah, he's been arrested like, I think 5 times.
Really? Okay, I'm not familiar with. I haven't been here personally.
It's
So they have
he's currently on parole because of it. So
because of domestic violence with her.
yes.
Oh, okay. Okay.
Yes. Last
Drug
time
addicts.
He got like retrial something or other. He had to go to a domestic violence class.
Okay.
I know he was doing it at a parole officer, stuff like that. But I mean, like every time she had him arrested, the next day she was trying to get him bailed out too. So I don't know what it is.
Oh, she's getting water from the tap. Probably gonna pass out on it. Okay. Well, listen, please do me a favor.
Oh, no.
I'll make a few
Not
phone
a problem.
calls.
I mean,
where's your kid need to be picked up?
Lakeline Elementary.
How soon though?
3 o'clock.
3 o'clock.
I
Okay.
normally move out.
Let me find this.
Sarah Boone definitely should. The ex-husband just seems like callous to the drama. Like
Martinez.
he knew something bad was going to go down at some point. Oh my God.
I'll go ahead and start making the calls. Sam, could you go ahead and give me his last name? Torres? Spell it for me. Torres. And his first name? George, Jorge. 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 His birth date? 2/13/78. And this is the boyfriend? Yes. How long? 3.5 years.
Word.
Most entrepreneurs
Oh my God.
don't have a business. They have a funnel, and their funnel is a turd. Why? Because
I suck.
And your last name? Boone. Spell it. Boone. First name? Sarah. Sarah. Birth date? 10/10/77. So you've had a second to kind of collect yourself. Tell it to me again. You guys were playing last night, drinking a bottle of wine,
Putting puzzles together, doing
doing
artwork.
puzzles, artwork. Okay.
Had a bottle of wine and then decided to play hide and seek. So he
What time was that? Do you remember?
I mean, I know that I was in bed probably by like.
Oh, I forgot how
12:30.
good this story is.
Okay.
Well, I went upstairs at least, and I fell asleep, forgetting that he was
So
in
you
the
guys were
suitcase.
playing a hide and go seek.
Yes.
And at some point you put him in the suitcase?
No, he got in the suitcase. So
Okay.
he thought it would be funny to be put in the suitcase. So I was like, okay, well, I'm going to joke with you and I'll zip you up and make him, squirm a little bit, whatever it is. But then I fell asleep. I fell asleep.
Where was the suitcase?
Right
When
where
he got
it
in
is.
it? Right down there?
Yes.
You zipped him in there?
Yes.
Thought he would be funny?
I am
We both were
by
laughing
no means a
about it.
prude,
And then I fell asleep.
but I don't
Where
think
did
I've
you fall
ever
asleep
played
at?
adult hide and
Upstairs.
seek.
In your bedroom?
Yes.
Okay.
Totally forgetting that he was in the suitcase still.
Okay. And then you came back downstairs
This morning or this
around
afternoon, yes, when I got
ballpark,
up.
what time?
Hey, Miss Priss, welcome back.
12:30-ish. I was awake, but I totally
Didn't mean to
forgot
kick
that
you
he was
all
in the
out.
suitcase. He can tell you there's a lot of things that we have been
Oh, or maybe you're just commenting on. I think you're actually commenting on my last comment.
So I just totally
So you
forgot.
began to do CPR on him?
Yes. Yes.
About
And he
what time
gurgled,
this morning
like he
did you
gurgled.
start doing that CPR?
No, it was the afternoon. It was afternoon
The
because
afternoon?
I was awake, but then I finally decided to come downstairs at like 12:30-ish, whatever it is, and I was like, I forgot he was in the suitcase and he wasn't moving. Nothing was happening. So I unzipped it, took him out.
I mean, that's what I'm
CPR on
thinking.
him.
I don't even know why charges are brought at this
He was
point.
on his way over here. I called you when he got here.
Once he got here, you called us?
Yes.
Okay.
And air was coming out and he was gurgling, but I could just tell by looking at him.
I could hear his death rattle.
Doing that on your own?
Yes.
Okay.
And then
All
the
right.
person that was on the phone with me also, I counted with him doing.
And he's got no medical? He doesn't take any medication?
I don't know. I don't know medical wise. I know he doesn't take any medications whatsoever.
Okay.
The only thing, like I said,
I mean,
I don't
meth,
know
but
if alcohol had something to do with it, but we had a bottle of wine.
Okay, all right. Here, I want you to sit back down because I don't want
Can I
you.
have one more sip of water,
Yeah,
please?
go, go.
29 residential audible 1303 Island Bay Drive.
I'll do what I can to get you a cup because I don't want you to have to keep doing that.
oh, come on, just put your mouth right up to it.
Motor unit on the channel.
The cups are like right there.
Okay.
You're not going in there.
Talk to the ex-husband right
Oh,
now.
I won't.
Okay?
I won't. Can I have a cigarette, please?
Ma'am, I can't take anything out of the house.
It's on the back porch.
Nope, all of it. It's secure, okay? I'll try
Cigarette
my best to
addiction
get
is
you what you need,
crazy.
okay? Maybe one of these deputies has a pack from someone, you know, sit down and I'll try and get you what you need, okay?
Just cut, please.
Okay. I don't want you on your feet.
Like in the Ortiz case, his victim that survived, all she could think about is a cigarette. I mean, I've smoked. I kind of get it. But in this situation, I don't know if I'd be a one-track mind for a cigarette. I don't even think she's the detective. I think this is a deputy first responding to the scene that is doing a kick-ass job. So we're not on mute. She just got body cam audio turned off for a second, I think. Yeah. Got a lot of people coming in, so I'll just say it real quick. Hit that like button. Subscribe if you already
It's
haven't.
Boone. Okay. And then your first
Haven't
name?
already.
Brian, Brian.
Brian. And your date of birth?
52775.
And your child is in school right now. He's not here with you.
No. He's
okay.
at school.
He's in school. What? How old is he?
This will be a fun one. He's 9. He's third grade.
I can't even start with how you would explain something like this. Okay. Sixth grade, you said?
Third grade.
Third grade. Third grade. Okay.
Yes.
All right. So sit tight.
She does a great job of
maybe
switching
the middle
tone
that would be a
too.
good spot to
She's
sit.
talking to the ex-husband. She's like,
So
bro,
we'll
this is
take it from there. I'll
crazy.
keep you updated.
Okay.
Talking to Sarah Boone. Totally normal. So far, we just have her side of the story. That he could have, but didn't try to. I think later on we find out that he didn't really have any chance to. He was zipped in completely. God, I couldn't imagine. You're zipped into a suitcase. All that stands between you and living is getting out of that suitcase. It seems kind of like a simple proposition. Seems like there should be some way to figure out your way out, but there's not. God, how horrible.
Did we get that dog by any chance?
That just went dark in my brain. Sorry, y'all.
So your backyard's not fenced. Okay. Because we put him in the backyard and I guess he knew to.
Sorry?
Your dog. We thought the backyard was fenced.
The dogs are outside?
No. We have them contained.
One's deaf and one's blind.
Okay.
That's why I was making sure they were under the table.
Nope, that's yours.
She seems way more concerned about those two dogs than I.
Wait for us to get instructions on what to do next. You got some water. Good. Okay.
I guess I don't know 100% sure, but
Not right now. We can't have you go and
maybe
do anything.
I got to be careful if this was just my assumption or if I've seen something, but I'm almost positive it was just a soft-sided
Or maybe a
suitcase.
little closer here where the shade is.
Oh my God, don't kill me, guys. Sorry.
Still on?
Yeah. Are you?
We're getting
Oh no, you're in 24 right now. What in the world?
I'm like, nobody's going up there?
I heard silence. I said 220. I was leaving econ in 50. Just gonna go get me a sub. And then I said, well, I need to go to that.
223 Delta,
Hey, oh, is this quiet? I can probably boost it. I'll boost it a little.
We can't let you guys communicate right now. I know. You want me to get a cigarette from him and bring it to you? I could probably do that.
Super common in deputy too.
No problem.
All right, I boosted volume a little bit.
I was going to have him arrange childcare.
Okay, good.
If we need more, tell me. I have a lot more room to go.
Okay.
Is my name on there yet?
No, sir, it's not. I need to get her on there too, and him. So they're en route already, probably?
Did anybody call?
No, you want me to call? Yeah. Oh, I thought you were calling. All right, let me get homicide.
I was 99% on that.
All right. Okay, let's see. Hold on, I'm still on. Let me.
I don't know why they go quiet so much. She is just super calm for someone that killed somebody.
It's not
And trying to get away with
You
it.
have the anxiety, you're scared, right?
Okay, maybe not.
It's okay. You don't have to.
I don't know how to.
I'm going to boost more so we can hear her.
I could tell you this. I'm going to be here just as long as you are, including my. It'll be a while. I'm welcoming this breeze right now. It's kind of warm. All right, so just bear with us.
I know.
All right.
If you could like give me whatever updates or anything that you know of, just how I work, so I know like kind of what.
Well, let me look at my computer, see.
According to Sir Boone,
You already got a detective
they had a
on
bottle
his
of
way.
wine.
He's on the screen.
According to other facts that I've seen, they were both doing drugs, and would be classified in that addict category. But I don't. From the allegations, I don't think there's anything that she drugged him without his knowledge.
Honey, that's my call. Pick it up.
All right, so the detectives are here. Yeah, I just started thinking about that side of things, and I can't imagine the sheer terror. So they just keep cutting body cam audio in and out when they're not actually talking to her.
Hey, Sarah. Did you get enough water? No, if you want to stay seated, don't. I don't want you getting lightheaded. So remember I said the detectives were going to come out and talk to you and go from there. You know what I'm saying? They're here. They're going to ask you a few questions and then go from there, okay? All right.
All right, Sarah. My name's Chelsea. My partner, Scott. To my understanding, you reside here? Okay. Is it just you? Okay.
We are fully boosted on audio now.
Your former husband. Okay. But you reside here with George, and then your son lives with you, or lives there's 50-50. Yeah. Okay. So from what
Rodriguez
has told me, she explained last night that you guys were drinking a bottle of wine, and around midnight, you decided you guys. Yeah. Okay. You guys decided to play hide and seek.
Well, we were playing hide and seek, and then
Was your son home at the time, or okay?
no, with Brian.
X.
With Brian.
Okay.
Decided to play. We're just stupid like that. Like, sure. We were putting puzzles together. We were doing artwork. You can see.
With Create Studio Pro, you can create amazing character explainers just like Pixar.
The puzzle that we finished in there artwork, and decided to play hide and seek. Just being stupid.
Okay.
So he decided to get in the suitcase. So I thought it would be funny too, and he was laughing about it too.
I see what you did there.
I go upstairs and go to sleep. So this morning when I actually got up out of the bed, I thought for sure he was downstairs on the laptop because he was being really quiet. But then I came downstairs and I'm like, where is he? Like, and then that's when I found him.
Okay.
I don't know what happened.
Okay. And then you weren't sure about if you woke up this morning.
It was afternoon. I mean, I was
or
awake,
this afternoon.
but I just didn't want to come downstairs. So
Okay.
I just laid in the bed for a little while, and then I eventually came downstairs and was confused about where
The
he
story
was.
reminds me of the story I tried to tell my parents when I was like 13 years old. That some random guy in a car made us smoke marijuana.
Got here, which is 30 seconds down the road.
It just makes no sense.
Okay. The person on the phone had me do the confessions continually still and count with him until you guys shut up.
Okay. And so as a part of our investigation, we obviously have to go inside the house. We have to look at things. Are you okay with us going in the house and looking at things? Yes. Okay. Okay. And forensics, so we have to have our forensics crime scene investigators come out. Are you also okay with them coming inside, taking photographs and okay. Okay.
Can I ask, is Brian, I'm sorry, George, is he diagnosed with any kind of medical history?
Not that I know of. Not that I know of. I don't know. I mean, he doesn't take drugs. I mean, we'll have the occasional bottle of wine here and there, but I don't know. Like,
that was going to be my next question. So you guys don't normally drink? You just drink once in a while, or?
Well, I'm going to say, like, okay, I guess normal drinking is, like, we will have, like, a glass of wine or two, like, while we're cooking dinner, or here, and we'll play a board game with him. I mean, little games in there. But, I mean, it's not, like...
A couple of beers a day?
Well, but I don't understand, though, like, for the little bit that we had, like, not having anything to do with it. Like, I don't know if he had a heart attack or a stroke or an aneurysm or what happened. I don't know.
And were you guys together all day yesterday?
Yes.
Okay.
Yeah,
Like you, neither of you
the
left
recording
your
and yelling at him
apartment
part. Oh god, that is gross.
Okay.
But I mean, you can walk.
So I wonder if his defense is just like the battered woman defense. We shall see next month.
No. I mean, he's from Philadelphia, and so I don't really know like a whole lot of like medical history or anything.
How long
like
have you
that.
guys been together?
Almost 4 years, like 3.5 years.
You guys been living here the whole time?
Yes.
And we'll keep doing Sarah Boone stuff
Ever been to the doctor
until
or
the verdict
the
is
hospital
reached.
during that time?
So if it takes longer than I expect, we may definitely get to that video of her recording him.
Hospital from that, and then I talked him into going to see like a regular physician so he could get just like a regular like checkup thing.
Yeah.
But there were no red flags.
How long ago was that?
The surgery or
Yeah,
the doctor?
both.
The surgery I think was at this point what? 2 years maybe? 2.5 years.
I mean, seriously,
Checkup was
who drinks a bottle of wine, does a puzzle, and then plays clothed hide and seek?
Yep.
Is it normally stored down there? Did you guys travel recently?
No, he was going to start putting some of the what do you call it? Donation in there. So that's why
That's why it's out?
Yes.
Okay. You guys didn't recently travel somewhere or anything like that?
After you zipped them up, did you move the bag around and mess with them at all?
I will definitely take a vote before I play it.
Walked away that-
It's hard to watch.
I went upstairs and I fell asleep.
But what position was he in when he went in? Was he sitting on his rear end and his head up and just kind of bent over?
Okay, so like this is
Come on, meth heads like to take their clothes off too.
like this was his head and then he right here and his feet were down.
So he was laying on his side.
Yes. Yes.
You just closed the flap and zipped it around.
Yes.
Him. Okay.
I believe we were playing.
Understandable. Okay.
So he said that I needed to tell you guys about his family. Like, who do I talk to about that?
We're gonna do that once we walk through and see. Yeah, we're
not
gonna.
going anywhere. We're gonna
I'm
be here
just
for a
telling you,
while.
like,
This is gonna be a while.
I'm afraid for my life. I want you to know that. I'm
Why
afraid
is that?
for my life. His family
This part gets weird.
have never liked me. I'm the blue-eyed white devil, is what they call me. So they've never liked
You
me.
proved them right.
Taken me in. They've never accepted me. I'll put it that way.
Have you called any of them?
We talked to his daughters yesterday.
No, I mean like about this. Does
No.
anyone know? Okay.
That's
So
why
no one's gonna know until we will be making that notification. So
they're going
it's
to kill me.
okay. Well,
Do they live local?
Yes, they're down the road. They're going to kill me. His kids are going to kill me in Philadelphia. They're going to kill me. This was not intentional.
Okay.
And they're not going to understand that. They're not going to accept it.
Yeah, it's the cackling of someone that's
thorough investigation.
absolutely evil,
We will
or the cackling that had
make
just
sure that you don't
been
feel scared.
severely abused and had finally had enough.
Well, he's at school. He's with your husband.
I know. Well,
ex-husband.
Your husband said that, or your ex-husband said he made arrangements for your 9-year-old to be picked up.
Oh, okay, Mom. Probably. Okay.
Okay.
All right, we're gonna go inside if that's okay.
Yes, please, but can you guys just keep me posted?
Of
So
course.
I know what's going
Okay.
on.
All you have to do is get their attention if you have.
I got you.
need to talk to her. He's standing right there. She'll be right here.
Yeah. Okay, but
That actually makes sense.
like, so you're telling me like you won't call whoever it is without telling me, right?
No.
I mean, I have all their phone
And we're
numbers
not
if you need
calling.
them.
We're not making phone calls. We're actually going to speak to them in person.
Yeah.
We
That'll
are.
be later
They're
on.
going to. Okay.
It'll
You'll
be
know
later.
prior to us making.
Yeah, I mean, all this sounds reasonable. I still don't get why they do it with the clothes on.
We'll address all of that, okay, before we leave. Okay?
This was.
Okay?
Yes, absolutely.
Thank you.
Just stay seated, okay, Sarah? I know you're panicking, okay? Just relax. We'll come and talk to you.
Oh, dear Lord. I'm going to have to go sign up for Premium Live.
When it comes to advertising online,
We'll keep checking on you.
They talk. Who are they just protecting the inside, or were there kids there? I don't think there was kids there. No, her kid was at school. I don't know who they're blurring. They might just be blurring the inside of the house. Yeah, no, I'm not absolutely not talking in. Yeah, at the time, he wasn't. There wasn't battery going on. You're
They're
absolutely right
coming
on
out
that.
now. I'll get
There
you
are
some, okay?
allegations. I think he did get arrested a couple times for DP.
She wants to say something. She wants to talk. Come on.
At some point, you need to stop talking.
We don't know anything though, like why or how. So we will not know the answer to that because we're not doctors. So what's gonna happen is he's gonna go to the medical examiner's office and he'll have what's called an autopsy. Yeah, that'll be first thing tomorrow morning. I'll know a lot, hopefully a lot more.
Yeah, he does have a DV record.
As far as him, but I cannot. There's no way I could say how, why. So just
Now this is just a guilty person fishing for info.
Oh, that's normal when someone passes away. Lividity, you turn.
As soon as the heart stops beating, the blood starts to settle to the lowest points of the body, and then it becomes very pronounced. So that's just called a public bleed. It happens every night.
I'm like really scared. I want you guys to.
You have all these deputies here, so while we're here, nothing's going to happen.
Seems right.
Before we go and make any notifications, you'll have plenty of time to leave or do what
Run.
you need to do. Whatever you need to do. Okay? And we can talk about that more in length. But yeah, it's not going to be a surprise.
Real quick, and then. But like, I don't like this was totally like not intentional. Like.
Like totally not like intentional.
We'll have all the answers. We'll have a lot more answers tomorrow after medical examiner looks at it. Like you said, what you're seeing here is common. This is us coming out.
Protocol.
Yeah. His age. No.
Except I don't know about much of that story. I believe either.
For him to have passed away, we come out.
I know.
Yeah. We come out and do an investigation. Medical examiner's office is sending people out. This is what we do. If he was 75 years old.
Jolly Rogers, those statements seem to me a lot more like, don't tell his family because they're going to tell you that
That's what we're here to find out. We're just here to get the answer.
that I'm likely to have done this on purpose, more than them being like
I mean, I know I can't go anywhere.
actual mafia.
So do I just like sit out here and wait for you guys?
If you would, please.
Is anybody else having to show up, or everybody's here that needs to be here? My team's here that needs to be here. The medical examiners will show up when we call them.
She's just fishing for answers now.
So they're going to take him. They're going to take some photos, take him. But that's towards the end of it. And they'll be called well in advance when we're ready for them. But we're not ready for them at this point. So then we won't be calling them quite yet. Okay. So like I said, I got to go do some paperwork. They're going to chat with some people, and then we're going to come back and talk to you if you're okay with that. Just give us a little bit more time. Like I said, I need to go and do that, and he's gonna go do. So, like, do you guys tell his family like today or after tomorrow? We have to. It's the law.
Okay, right here. She does.
Once our investigation is pretty much complete here, once they leave here, we will leave here.
But again, you'll know. I'm not going to just go and do it without you knowing. You'll know. We'll talk to you prior to doing anything like that.
But how, I mean, I understand what you guys and how you do it, and, you know, so, but like, what do you just tell him? What do you tell his parents? Like, what's the reason he passed away?
We tell them what we know at that point.
Yeah.
We tell them the truth.
And that we're going to be waiting for the autopsy results, and I will be at the autopsy in the morning, and hopefully the doctor will be able to give me some of what they think and see.
We'll give them their number. They can contact them and get it from them.
Yeah, again, to me, this sounds way more like I don't want you to get info from them than I'm really scared of them. But just a hypothesis.
They always have said that. They've always have said that.
Oh, that's why.
Because I'm the
They're going to think I'm guilty.
white dragon. That's what they call me. Because they don't want him with me. So he's basically just not really been around his family because he chooses me over them. Even after I've encouraged him numerous times to go over there and see his family. They've never accepted me. They've always been reasonable. got nobody. I have a brother that's in the Marines, and I've got another one that's in jail.
This is Sarah
My brother
Boone.
that's Marine, is local.
She's in Orlando.
In Altamont, but I think he's doing whatever Marine thing he's doing. But the only way, correct? Yes. Does he have a phone? No, he doesn't have a phone. He used my phone. He uses your phone. Yeah, we did it together. So the only place I could go.
Damn, he wishes he had a phone.
Kurt's Brian's house. So I don't think he'll have a problem with it. Okay. So.
Well, like I said, we're not going to leave here. If you do not feel safe, you're not going to leave here with you not feeling safe, because then we're liable.
And then his ex-wife in Philadelphia.
Well, she's in Philadelphia, but yes.
There's going to be a funeral.
Right. That you're talking like days and weeks.
No,
and I'm talking right here, right now. So let me do my investigation. Let me go do this paperwork that I'm talking about.
This is like the most.
So back and forth about what it all day long.
I know. Sorry.
I promise we're not going to leave here for you and you not feel safe. Okay. I promise.
Please. Okay. It's just, I don't even know what to tell you. It's okay. Just
Detective's like, we know you're guilty. There's not much else to do here.
Let us do our thing, and we'll be back to talk to you. I promise. Okay.
Like you said, we just again, let them know.
Sure. Thank you.
Okay.
Thank you.
You're welcome. Yeah.
Go ahead and type.
Okay.
Sit down and type and keep like eyes on. Do you have anyone in here?
There's nobody here, just me.
Okay, that's fine. You're right there, right?
Yeah.
Sit there and type. You're fine. I have relief coming, so just keep typing.
All right, so let's go to the police interrogation. I want to save her video, her recording herself until the end. I'm a little shy. I'm a little gun. I don't know what the right word is. I'm gun shy on it. All right, so where is? I need to find full police interrogation. All right, here we go. Wait. Oh, YouTube's killing me. One sec. Sorry, y'all. Okay. This is right. Coming up. No news in Fort Worth, Texas. If anyone does see anything about
I'm going to read you
Aaron
your
Trail,
rights
let me
again
know.
because we have to talk about that. And since I'm talking about the incident, we just have to do it, just like we did yesterday. Just like we did yesterday. Remember I read you the rights? Your rights? Yeah. So it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay? Sure. All right. So you have the right to remain silent. Anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one, one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me? No. And do you understand what I just read you? Yes. Perfect. Okay. So this morning we went to his autopsy.
I'm gonna go check on one thing. I will be right back. I'm gonna keep this running.
Of some injuries that he has by the doctor. So I want. So he's got scratch marks to his back. I know what that's from. Okay. And it's called a contusion. Do you know what a contusion is? So like basically you're getting hit and then you get a mark from it. You'll get bruising. Like someone hit you or something like that. It's called a contusion. So he had some injuries to his left shoulder. He had a cut near his lip. We could see his mouth was a little.
I haven't laid a
swollen.
hand on him.
Okay.
Also too, he fell off my son's bike.
Okay.
So I don't know, and he's notorious for running into the wall or the hall tree. So
Okay. Okay. What about the scratches? Because there's also sex.
Yes.
Okay. Because there's also like a scratch on the back of his neck like kind of like going, but it's like going straight across.
I have no idea what that's from.
And they're all recent, like they occurred recently. It wasn't something that occurred post or that occurred a week ago or 2 days ago, 3 days ago. They definitely occurred, you know, the night leading up to when he was.
In all honesty, we have not gotten into it.
Okay.
That's why, like, the only thing I thought you guys were going to ask me about, which I was going to be honest with you anyway, are the scratch marks on his back.
Mm-hmm.
Everything else, I have no idea what it is. No idea what it is. Nonetheless, I've had my son over the house too, so.
Well, your son was there when? When was he last there?
Oh, gosh.
From my understanding, he was there like last Tuesday?
I don't know if it was Tuesday, but yes, he was there last week, so.
Well, we're talking about Sunday.
Yeah.
We're just talking about what occurred Sunday. Because like I said, the injuries they occurred within that time period.
So you're talking about day before yesterday?
Sunday leading into Monday. You called us yesterday at 1, so, but the incident, you guys were painting and stuff the night prior.
Correct.
So we're talking about Sunday and then into Monday.
I'm thoroughly confused because we had a good time sitting on the back porch, having wine and smoking a couple of cigarettes, and then decided to go inside and literally paint, do puzzles, and play, and listen to music. That's why nobody got out of sorts. This is what's mind-blowing to me. Like, I have no clue. Nobody laid a hand on anybody.
He also had, like on the left side of his forehead, he had basically bruising, and on like his head and his skull.
I have no idea.
As if something hit him.
I
considered
have not
force
touched him.
trauma.
I have not touched him. I have not touched him.
Then how would you get that?
January.
Tell me
see if I
we'll
get the
both
exact
know.
date.
I touched him.
Yesterday, when we took photographs of your overall body, and they did the buccal swabs, did they go under your fingernails?
No.
Okay. Are you willing to let us
Absolutely.
swab underneath your fingernails?
Go for it.
Okay.
I have no idea, and I don't want to
January 30th.
but I have no idea. We had a good day.
Mm-hmm.
It was a good day. We've had good days lately, even considering
After
everything
November,
that's
they
going
moved
on
it back
with
to
our
January
jobs
30th.
and life in general and ex-wives and everything. It's been good. Like, I don't even know where this is coming from.
Yeah,
I
you
don't
said
even
the
know.
last physical was probably, you said, I think, what, a month ago? Where you got the injury, right? You said that was a
I'll
month
say
ago?
a few weeks, give or take, yeah.
A few weeks. That was the last, like, physical altercation between the two of you? You said a month ago he hit you with a curtain rod.
Yeah, with a curtain rod. That's why I can't believe you guys didn't take that either.
Wow.
Like, we've been good. I don't know if, like, it's since the last time he got out of jail. Like, we've been good, and he's been having his classes and seeing his probation officer, who's amazing. So.
What do you mean by good? What's your definition of good?
The probation officer?
Oh, no, you said you guys have been good. What's your definition?
I've been good. I don't think you all understand. He comes at me all the time. He comes at me. So it's either I sleep or try to go upstairs and go to sleep. That's usually what it is. And I don't know if you talk to Brian about any of that, but most of the time when I sleep, I go over there. So.
Right, but you're saying that you guys have been good, and when I asked you yesterday, the last incident that you could remember was the curtain rod incident, which you said was a month ago, so.
Give or take.
Right, so what do you mean by he comes after you? Like,
he gets belligerently drunk.
Mm-hmm.
Like, I don't know if you all have looked through my phone yet and seen any of the pictures and the videos that I have taken.
Mm-hmm.
And at one point, I started documenting everything.
Okay.
So you all will see in my pictures, bloody fingers, split foreheads, he split my nose. I've got this.
Right.
I don't know if Brian told you about it, where I had to have almost I had one really bad surgery, but then it got really, 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 really bad where I had to go like 4 or 5 more times afterwards for them to tend to it, from him poking me in the back of the leg.
Right.
So it's.
Then why are you still with him?
Everybody asks me that. When I tell you guys this, I really love him. like I do, and I feel like I can help him. Like I feel like I could help him, which I did because he came a really long way from where he was in Philadelphia to moving back to here and to dealing with everything else that he's been dealing with. I've really helped him. I've bailed him out of jail, 3 times. I've gone to every single hearing and every single arraignment, everything that I did for him. Gone to see all his public defenders, go to the state, I've gone to the state. I did everything for him because I'm trying to help him, because I had hope in him. And he was trying. He was really trying.
She doesn't testify on her own behalf. She is terrible.
I think he gets overwhelmed. And then it's like, next thing I know, he's drinking. So it's like, oh man, I know where this is going to go. So I'm going to go upstairs and read a book. Or I'm going to go for a bike ride, or I'm going to do something else. Or I don't want to drink. I don't want to drink. The occasional wine, whatever, or if it's a weekend, that's when you have a good time.
Except I get
You
fucked
don't
up.
have to wake up the next day. I have
Except
to
the
wake up the
weekends.
next day and do things. I
That doesn't
have
count.
to tend to Lucas. I have to take him to school. I have all this stuff to do.
And
He doesn't know how
teaches you
to,
that, right?
I guess, maintain himself, where I can do 50 things at once and still know the 50 things more prior that I need to get done. He can't process like that. He didn't process like that. So he would literally, not literally, but have smoke coming out of his ears. So the next thing you know, he doesn't want to deal with it. I'm going to go get something to drink. So the majority of the time I would hang out outside or do something else because I don't want to drink. And every time, his job broke his heart. And it made me sad because he had so much pride in his job. And the store that he took care of so much totally went downhill. And that broke his heart because he had put so much work and effort into fixing it up. And his manager was awful and basically gave up on all of the employees. So I think that had a huge bearing on why he would drink so much. His ex-wife is bonkers. She was all over him all the time. Send me money, send me money, send me money. How can I send you money when I don't have a job? And he's still trying to take care of me and Lucas by paying a bill here or there, getting some groceries. So he always had something on his mind, which is why, again, I got the puzzles and the paint to try to get him off of it so we don't have a drink, or he doesn't have a drink. So when you all see my phone, you can see all of the damage he has done to me and the videos of him smashing my television because he's belligerently drunk. Where most of the time, I just don't want to be there. And I try to help him. I try to calm him down. Eventually, he just passes out.
Well, yesterday it made it sound like you guys were just drinking like a glass or two. Like, yeah, you obviously had the bottle, but you told me you told me on recording like that you were not drunk.
I love
you
you
were
all.
not drunk. You guys were having a good time.
There's no way.
I can't get drunk. Number one, I do not want
He was sober that night.
I don't like being non-complimentous, having my wits about myself. I don't like feeling out of control. So
I'm just saying you're making it sound like he's a raging alcoholic today, and yesterday I was kind of asking you those questions and you're like a little defensive, like, no, we're not alcoholics.
I'm not.
We are not, but you guys were both sober on Sunday, to your knowledge, because when I said you went and passed out, you were like, no, I didn't pass out, I just fell asleep. So now it's kind of like, were you guys drinking and it got heated?
No.
It got physical?
No.
Or is it?
Sunday was one of the better days that we have had in quite, that too, on the pictures, him loving the dog. He loves the dog and dancing around, having a good time, and just being happy kind of thing. He doesn't know, I can get maybe 2-3 glasses of wine, and I'll be fine. But I have to have my wits about myself because I don't know what to expect.
Well, let's talk about Sunday. What was Sunday? How were you? Like, how many glasses of wine did you have? How many glasses of wine did he have? The bottle was gone. I mean, I don't know if you poured any out. Yes.
No, that was from previous.
You said that there was a half bottle left
Yeah,
over.
about this much.
And then that you had well, I don't even know how how'd you guys get the wine for Sunday?
I'm guessing he went to Publix.
Does he leave
The only time I don't say I passed out is when I actually passed out.
Okay. Did you go with him Sunday?
Actually, kind of.
So most of the time what happens is, because the convenience store where we get cigarettes is here, and then Publix literally is cattywampus to it.
Okay.
So what he'll do is he'll go by Publix, and then on the way back, catch
I think this is a
the
very valid
convenience
take.
store.
Okay.
So
Is that what he did Sunday?
I'm trying to save him.
I'm guessing that's what he did, because the next thing I
He
know, he's
hears
walking
me.
in with a bottle.
Okay.
So it's him trying to be nice, so I don't have to go out and do it. Plus, there's stuff that are around the house that I had to take care of. So that's usually what will happen. Or I'm folding laundry and he'll go run out and do whatever.
So where were you guys at on drunkenness, not drunkenness on Sunday? You told us you weren't drunk.
No, I was not drunk.
Right.
I was not drunk. So with him, I don't know.
But I don't think she was drunk.
I
Just
know
from the
when
video.
it's like, oh, okay, man, where I have told him, slow down. It's starting to catch up with you. Slow down. Slow down. And another thing too is I don't like listening to music with him, because he gets too involved in the music, and the music that he listens to is a little rough around the edges, and it makes me fractious listening to his music. So I kept asking him, let's just you and me talk. You and me will just be the ones that are talking, which was fine, because we were playing with the dog, whatever, and then it's like, okay, now let's do the painting. We just did the puzzle, took a break, now let's do this. Sure enough, sat down, we're sitting in there talking, laughing, talking about new movies. We're watching movie trailers while we're doing painting and all that other stuff. So it's still background noise to him, because I think that's what he's used to, is having background noise. Where me, I can sit in here all day with not a peep. But he always has to have some kind of background noise, which I didn't mind, because the trailers were cool. And he was interested in showing them to me, getting excited about movies that were out or upcoming.
Okay.
So
on your laptop you're talking about?
Mhm.
Okay.
And and then it was.
But you said it was a good day. Like, you guys didn't have any conversations about your relationship. You guys didn't go down the rabbit hole, had too many to drink, and you guys start getting.
Nope. When I tell you this, it made me so happy that he actually listened to what I had to say. With just, we'll get through it. This will be fine. It's a small hurdle that you and I together will get through, because.
I'm talking about the money, jobs,
daughters.
stress.
Yes.
Nothing
No.
relationship-wise, though. No issues. Did you guys have a conversation about your relationship, or was it just about
just
the
what's
stress
going on right now?
Got it.
I try to evoke it from him so he gets it off his chest, because I call him the volcano, where eventually he's going to erupt.
Volcano.
And what he has learned in his classes is to communicate, which is a huge thing in a relationship,
Right.
where he has been practicing
We didn't know
communication.
that.
So he actually talks
Anyone
to
else?
me about things.
That's
Okay,
revolutionary.
unburden
Communication
himself.
is huge
Put
in
it
a
on me.
relationship.
I'll sit there and try and figure it out for you. I have almost everything. Not a worry. Just tell me. Get it out of you.
Right.
But it was, when I tell you, I was so
Lost
happy.
without her.
It was such a good day. I kid you not. The weather was beautiful outside. I'm the one that had him go inside so we can do puzzles and painting and listen to music or whatever else he wants to do. So then he starts doing whatever it is we're doing together in the living room, and then starts talking, because I think he gets comfortable with, okay, you know what, we're here, it is a good day. Let me go ahead and explain myself. So I know. Nobody else knows, but I know. Nobody knew George better than I did. I say that I knew George better than himself. And I tried in every way, shape, and form. Ask everyone. I helped him. I took care of him.
Describing the whole reason why I'm starting this right now.
I miss him a lot, and I didn't even sleep.
I figured, hey, if I could
miss him a
actually.
lot.
Is there any chance it got
background
to be too
noise
much
could
for
be
you
the
and
same
you
thing,
couldn't
that would be
handle
awesome.
taking care of him and
I never stopped.
trying to.
I never stopped. That's what I'm here for. I never stopped. I'm I'm here now because I'm still trying to help him.
Who else like completely got nothing
Yeah.
done for
We just
the 6
don't, I
weeks
mean,
of
it's
the
unexplainable how he
Johnny
got these
Depp Amber
injuries
Heard trial?
and. I have no idea. You were the only one with him.
During that 6 weeks.
100% right hand to God. I have no idea how he got them. Nobody touched anybody. Nobody touched anybody.
Okay. You had mentioned that you would take photos, videos, just kind of like a proof and just in general.
Yeah, I started documenting at one point, but that was way before, I think the last time that he got arrested, where he was flying off the deep end. But then I had him bailed out. I got him out of jail.
Right.
But because he had violated the pretrial diversion, this time it's probation, so you don't have a choice in it. You have to go see your probation officer. You have to go to these classes. It's court ordered.
Mm-hmm.
Where it took him a while to get used to it and understand, they're not messing around. I even went down and met his probation officer, which I say she's wonderful. That's one of my questions too I need to talk to you about. Hugged me and said how much she knows that I take care of him. She called me personally one time when George was at work, when he was working. 42-minute phone
Just a
call.
lost piece of luggage.
She and I just saying how grateful she is that George has me. And she knows how hard I'm working to help him, just as she is and just as the classes will. So once he started actually going on a regular basis to the probation officer, and then to
Turned
his
that off so fast we didn't even know.
substance
She
abuse
turned it
class and his,
off so fast I didn't notice she turned it off.
Matters Intervention Program. And actually listening to what it is everyone had to say, he changed. Like I could see a change in him, where before lashing out, he would think about it. And would always come home and show me his papers, and we would look over his papers together. Where it's like, wow, you actually are learning this in class? And some of the stuff that they would show them, like videos, he would come home and be like, Sarah, I'm so sorry for what I've done to you. Because for a video that he watched,
The PO didn't actually hug her.
make him feel that way, where it's like, oh man, I have done her wrong. But he's changed. He changed.
And that's why you're still with him, even though he's done all these things to you. And
when I tell you I love him, I love him.
Even when you have.
Wait, I didn't accidentally like rewind back
Everybody
to that same
tells
spot,
me that.
did I?
All my neighbors still tell me that. The office property manager.
At some point,
Everybody says this.
Gets enough, then they have to do something to defend themselves.
I would just flee. And I don't know if you would like to see on my phone, or I think it's actually on a laptop. I actually, because, and you have to
Make sure
understand
you hit
too,
that like button. Let's get this in the I don't
like,
think there's too many other people
classes in
birds
PO.
watching right now. So
kicked him out. How many times? I had him arrested. How many times?
But you also went down and bailed them
I
out
know.
the next day.
I know.
What's on your laptop?
What was I going to tell you? Oh, previously, I actually looked up how to file a restraining order.
Okay.
Because I would take him out, his parents, because of them constantly having to take him back in, his bags of clothes,
that proves
all
it.
his stuff. The last time, their father came out and irate and just not even, I don't even know if he knew Lucas was in the car. Just opened the back of my car and just started throwing all his crap in, just throwing it, like the car would jostle. He was throwing all his stuff. At that point, because I continually did it, not continually, I think I maybe did it 3 times, and he has nowhere else to go, they got fed up and said, nope, either you're staying there or you're staying here. But if you're staying here at their place, it's permanent. You're not going back over there anymore. So what happens is he pursues me. So I don't know if y'all know where Katie Way Trail is. Okay, so it's literally right there from our apartment. Would ride his bike to work, but before he would leave extra early and come up to the wall, stand on top of his bike and poke his head over because he would know that I would be outside having my morning cigarette and cup of coffee. And I would also know too what time he would get off of work, where I would know, come getting off of work, he's going to do the same thing. So it's not like I ever got like a break from him where I told you all yesterday or whenever it was. I started to feel that it was too much togetherness. And when you have too much togetherness, friction happens. So I'm going to go right by. I'm going to go upstairs and read a book. But what does he say? Every waking moment, he wants to be with me. So, and mind you, our townhome is either upstairs or downstairs. So it's like, if you would like to sit downstairs and watch a movie or play on the laptop, look up some jobs, you're more than welcome to. I'm just going to be upstairs, maybe watching one of my shows or maybe reading a book. So, and then when that would happen, we really needed that. So what's for dinner? And then we would cook together and eat dinner and then crawl in the bed and watch a movie.
Are you talking about this is like recent? I don't. You kind of like lost me. Like when? What are you?
It was a while, like a little while ago.
But now you're talking about tension building up and that you need space. So have you been feeling that way lately, or?
No.
Okay.
No.
People that want to be around you anyway.
My thing is too, so you all know.
I've found actually what's best is to zip them in a suitcase for a few hours. You get your piece. You let them out.
When I say a monster, she's a monster. Like she withholds their children from speaking to him. So he gets upset about that, and then she like completely berates him about money, about the father that he is, what he did to her, all this other stuff. It doesn't matter. I mean, mind you, this has not like been recent, but which is why he didn't even bother calling anymore, because he knows that she's going to answer and he's going to have to talk to her, so therefore he can't talk to his daughter. The other time he talked to her, made her talk to Cookie. That's on my cell phone too, so you can see it.
Okay.
It doesn't matter.
It's neither here nor there.
It doesn't matter.
What does she have to do though with anything about what happened Sunday and into Monday? Like,
no, I'm just saying like previously why the incidents, what happened is she plays a big part in it.
Okay.
On top of jobs and money and groceries and all that.
Okay.
Sunday, when I tell you this, I have no idea. I have no idea.
Is there anybody else at the house?
No, it's just me and him.
Since talking yesterday, do you remember any like timelines better? Like what time you guys were playing? What time he was zipped up in the luggage? What time you went upstairs?
We started because we cleaned the house a little bit, did some laundry.
You started the activities around 4, you said?
Yes, around 4:30ish, and then.
You just said that it was dark when you were playing hide and seek, and I'm just curious if you remember.
But when we were outside, that's where we would start and talk about things, and then eventually I was the one that had him come inside, so we could.
At what time? Do you remember what time that was? Is what she's asking.
And you said you went up to bed around midnight, fell asleep around 12:30ish. But those are the only times I have. So I have 4 and I have midnight. So there's a big gap. So I'm just curious, like, if you recall when you went upstairs to hide in the shower, or
like when we started to play hide and seek.
Yeah.
Well, we went inside probably about, if I had to guess, we weren't out there too long. Maybe about 6-ish. Then
you're talking about from hanging out outside and like. Okay.
Well, we have 2 beach chairs that are out there.
Right.
Just enjoy the weather.
Gotcha.
Plus, it started to get dark and nasty.
It was a strategy. If it was, I think it's a good strategy
let's go inside.
too.
I don't want to be out here anymore.
Okay.
All right, let's go. So we're doing whatever. We did it for a while because that puzzle, I don't know if they took it or they saw it. Worked on the puzzle again, finished it. Started to paint. Well, started listening to music for a little bit. Started to paint. Can we turn the music off? No problem. Start at the top, paint, whatever. Maybe, gosh, that puzzle, we worked on that for probably a good hour and a half. So 8 o'clock-ish?
Is when you went to hide upstairs originally?
No, that's when we were like painting. So then it's like, okay, well, I don't want to paint anymore. Let's just, come on. Okay, you want to play hide and seek? What he does is, okay, tag, you're it. So it's like, okay, we know. Okay, take off. That's what we did.
And then you went upstairs, and then he didn't come up, and you came down, and the suitcase was there originally because you guys were planning to do donations, so it was already there.
Have you guys ever played you said you played hide and seek like probably 3 times in your relationship. When you have played, have you ever zipped him up in a suitcase prior?
No.
Okay. So it was just kind of like that prop was there and it was there
Yes.
and it was in play because.
Why do you say it like that though?
I would never do that.
You would never zip them up in a suitcase?
Well,
I mean, we were playing.
No, I know,
that
but
time, but
I'm saying, I'm talking about hide and seek, which is a game. So
the suitcase originally
to
is
save
in
herself-
our closet, buried
If she
all
was
the way
smart,
to the back.
liar, she would have said, yeah, I mean, we did that a lot.
Inside people stole our closet. Our closet needs to be cleaned out really bad. My son's clothes need to be cleaned out really bad because they don't fit him anymore, and I'm tired of looking at them. So he took it upon himself, including that suitcase, to take it downstairs so we can get all of our clothes, our donations and everything, and just leave the whole thing by the clothing and shoes at my son's school.
no, I'm just asking in the past, like, have you ever zipped him up in anything, jokingly or not? But obviously,
No.
I understand, you're claiming that Sunday it was a joking matter. You were laughing, he was laughing. But what I'm just asking is in the past, like, is it something that you guys normally do?
Absolutely not.
Okay.
We were actually this last game running out of places to hide because we have a townhome where it's upstairs or downstairs. So
that is all the answer.
Okay, so do you remember making any videos or maybe having any photos, videos that you remember doing on your phone on Sunday?
well,
No.
I think I took a picture of a dog.
Okay. But your phone is password protected, you have the password, he has the facial recognition, so it's not like someone else could be on your phone.
No, I have both.
But you have the face and the password.
Yes.
Yeah, but he only has the face, correct?
No.
To be able to get onto your phone, you told me that he looks at the phone.
Oh, I misunderstood. I thought you were asking me if I did. Yes, it's me.
Okay. Does he have access to your phone? Because you said it's your phone. Okay, how does he have access?
Sarah, can I borrow your phone? Yeah, it's right there on the
That's
kitchen counter.
the story.
Okay, so how does he get into it? Because it's password protected.
He'll come and get it to me, and I'll just do the face thing. Where sometimes too, like he'll joke with me and say, "Okay, I need to borrow your phone," and he'll hold it while I'm cooking or doing something, do the facial recognition.
Okay, so he doesn't know the password and he doesn't have the facial recognition.
No,
but he is the only other person that would use your phone.
That's exactly it.
Well, Lucas.
Right. But Lucas wasn't there Sunday.
Yeah, honestly, I mean, if I'm her, I might think like
So,
my best chance out of
your
this is to try to
recollection,
talk my way
no
out of it.
videos on Sunday.
I don't know how much a lawyer can help me get out of it, but
I mean, I get my
Still-
phone, I maybe took a picture of them.
still that's the wrong
picture of
mindset.
Tess and the
Lawyer
dog.
all day, every day.
And George and them dancing, but I mean, it's just Tess.
Mhm. Okay. So I have something that I want to show you that we found, and it was from your phone.
Mm-hmm.
Can you see it?
If you need to move it around, go ahead.
Okay, so this is the video.
No, I don't remember that.
For everything you've done to me. For everything you've done to me.
Your battery's about to die.
Shut it down.
Oh, okay.
Let me.
So guys, I think this might be the way that we watch the video, is just through this interrogation. So if you're interested in it, pay shut up.
Battery
Pay
doesn't
super
last very
attention to it right now.
It used to last a lot longer than that. I don't know what happened.
Okay.
It'll be they'll get it going in a second here. When they play it, or shut up.
No, I was just simply asking because.
Pay super attention, close attention to it. And I'll set it up a little bit when they're ready to play it.
If you've ever done that before, you look kind of shocked.
I think that's a good compromise.
Okay, but why did you say it like that? Like.
I don't think you.
And if you really, really want to see it, you can go find the Sarah Boone,
I've always been a
Sarah
straight
Boone,
student. I am.
where she
an
records
outstanding
herself. I don't
all the
think
time.
it's on YouTube anymore.
I excel at everything.
I excel at everything.
I would not do that.
You wouldn't zip somebody in a suitcase?
Well, I didn't completely lock it. I mean, I opened it with one finger. I left enough in there for him to get out.
Okay.
And I wasn't planning on going upstairs and going to sleep.
Okay. No, it's just the way you said
All right.
You guys are scaring me.
Why?
Oh, that's it.
We just want you to watch this. It came from your phone. Don't you want to know what's on it?
Yes, please.
I'm shutting up. If you want to see this, zoom in, pay close attention. Setup. She is recording herself while he's in the suitcase, talking about
Is it long? Because I don't know how much I can take.
No.
I don't know how much I can take.
I don't know how to find it.
Do I have to watch this? I continuously throw up. I don't sleep. I don't want to see it, if that's okay.
Well, it's on your phone, and you can either explain it or we take it for what it is.
Yeah, we're just trying to give you the opportunity to tell us what's going on. That's it.
It's that long?
2 minutes.
No,
For everything you've done to me. For everything you've done to me. Fuck you.
And this
Fuck
is,
you.
that's you, your voice.
Stupid. Sarah. That's my name. Don't wear it up. Yeah, that's when you do when you choke me.
I don't want to watch it, please.
Last time we talked to you, you had said that you put him in the suitcase, he had two fingers hanging out. and you
I
went to
flipped him
bed.
over. I flipped him over, and that's where it was.
I mean, there's two different videos and a still picture where, yeah, it shows you flipping him in different positions and him saying that he can't breathe and you saying fuck
So
you.
this is upside down. So in order for him to have gotten into it,
It was flipped up.
right, it was flipped up normal.
Yes.
Like as if you're packing something. So this is upside down.
Guys, this is killing me right now.
So this image is upside down, and then
We are definitely
the
a we.
small video
We are a we.
that
We.
occurred 11 minutes later. It's flipped over the other way, closer to your dining room table.
Okay.
I was doing some SEO work and stuff like that for the
So
channel this weekend, and
how did that? How did it
even
go
in
from
like
the
my
back?
descriptions and things that I
I
was
flipped
writing.
it. Okay.
We watch this. We
My
do
plan
this.
was not to go
I love
upstairs
the
and
we
go to
part of
sleep,
this chat.
Well, that's what you did.
Yeah.
but not intentional.
No, you told me you went upstairs because
What?
you were
Stop
getting
here.
ready for bed.
Stopped here.
Okay, but
Where's here?
show me where you can see any fingers coming out, because there's the end.
It's, and his head's right here.
Mm-hmm.
So going like this, rather than going all the way up, it's like this.
But why is he saying
So
I
the
can't
whole
breathe?
top is open now?
Why is he pushing on it as if he can't get out?
And it doesn't show a hole.
There's no hole. There's no fingers. I don't see his fingers. There's no hole.
I don't know what you want me to tell you. Like, I don't know, like, what you want me to tell you.
I'm just showing you. I'm just telling you what we see and what we've heard from the other
I
video.
understand. I understand.
He's begging for you to let him out. You're laughing in the beginning, and then in the end, it sounds kind of like a.
No, it's not malicious.
Well, saying fuck you,
It's not malicious.
then what is that?
What does fuck you mean to you?
Well,
Like if I were to tell my
like he
partner.
does. Like, I get called everything but a white woman, so
Okay.
my intention was not to leave him in there. Please understand that. My intention was not to leave him in there.
But you went upstairs thinking that he could get himself
Yes.
out, but the video shows.
That's
at
what I
no
told
point
you.
can I see his fingers.
He'll
it
be up
looks
here any
like-
minute.
And then 30 minutes later, he didn't show.
And he's telling you
And I
he
didn't
can't
wake
breathe.
up.
Do you
He's
think
not
he's
able to get out.
joking? You told me he was laughing, and
We were
the
before.
video, there's no
When we
laughing.
first got in there, both of us were.
So how long was he in there for? Like, this video is at 11:12 when it starts, so was he in there for like a long time prior to
No.
recording this?
No. No.
So it goes from funny to no longer funny,
But
and
I
you're the
didn't-
only one laughing.
But I didn't think that he was like panicky. Like
So pushing up on a suitcase saying, Sarah, 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 I can't breathe.
George has done that in the past before too, where it's just like.
I get called everything but.
Woe is me kind of thing, where it's like, I don't.
He's never been locked in a suitcase. That's where he couldn't get out. So.
It's kind of, I thought it was
And
the
you know
boy
the oxygen
crying
is
wolf,
coming.
crying wolf kind of thing. And again, my
But,
plan.
but nowhere in there is he laughing, is he joking? He is begging. And you're the only one laughing.
Okay.
And you're the only one saying derogatory comments, like you're mad.
No. Please don't, I don't mean to sound negative, and I don't know if I can say this, but like, it's like you guys are kind of trying to like feed me. Like,
no, I'm just trying to show you a video that you no longer want to watch because you probably don't want to know the outcome of how and what you said.
Well, I know what.
You know what's on that video now?
No.
You remember making that video?
No.
Why don't you remember making the video?
Probably because we had been drinking.
But you weren't drunk.
No. Just because I went upstairs and just
You
because you're
told us-
drunk doesn't mean that you.
told us times that you were not drunk. You said that you had your wits about you. You said he had his wits about you.
Mm-hmm.
You said that you don't like not having your wits. In my experience, if somebody cannot remember doing something to the extent of making 2 videos and a video and taking a photo, they are intoxicated.
Okay. I understand where you all are coming from.
Well, we're just trying to make sense of it. We're trying to figure out what
We're trying
you're
to
saying.
figure out this
You
video.
explain it to us. We're listening.
I just did. Like, we were playing, and then, like, I thought it was. My plan was not to go upstairs and go to sleep. My plan was not to. He'll be up here any minute.
But you willingly went upstairs and went to sleep. No one forced you to go upstairs and get
My
ready
plan
for
wasn't
bed.
also to leave him in the suitcase.
So why didn't you take him out?
Because I went upstairs, and then I fell asleep.
But why didn't you consciously think he's asking to come out?
I didn't do it intentionally.
What do you think is going to happen if you leave somebody in a confined space like that?
Well, I thought by not giving it up all the way, it would be okay. My plan was not.
Who admittedly have tolerance.
What was your plan?
Waiting for him to come upstairs.
And then when he did it?
I fell asleep.
You said you were up there 30 minutes. After 30 minutes, somebody not coming up.
Knowing that that the last time you saw him was in the suitcase, 30 minutes later, you're like, maybe I should go check on him. Maybe I shouldn't.
No.
But that didn't cross your mind because
That's
it
like
didn't happen.
that's like an assumption. Like, that's what you all are thinking. Just.
We're asking.
It's the
You
whole.
tell us.
It's the drinking.
Hey,
That's
we
what it
keep
is.
getting really close to the most
It's the
concurrence
drinking.
I've ever had. Please
I
hit
thought
that
it
like
was
button
like-
if you haven't.
I thought he was okay. Like, I
Let's
didn't.
cross that threshold.
You
He's
all.
telling you he's
Thank
not. He's telling you, Sarah, I can't breathe. He's saying your name.
Share
and
it if
you're
you
like,
have
"That's my
anyone
name,
to
don't
share
wear
it
it
out.
out."
Please share it too.
Guys, that's how we are with each other. Like, he has, nobody understands our relationship. The whole suitcase never happened before.
Would you leave someone else in a suitcase? Would you leave Lucas in a suitcase jokingly? Because it was a
No.
joking matter. You put him in there jokingly. Would you leave Lucas jokingly in there? And you love Lucas, right? And you love
I wouldn't do that
George.
to him either. I wouldn't do that to him.
So.
Brittany's question.
Well, it's not like,
Would you do it to
again, I
punish
don't
him?
think you all understand. Like, it's,
I tried to avoid that question, but
I mean,
it's not my,
That's a good
that was
point.
not my
Ugh.
intention.
Well,
Y'all don't have any idea what
by
I've
your
done for
acts,
him.
though, but by your acts, and that's exactly right. You get to the point where you've done so much for somebody and they don't show
No.
you any appreciation,
He did.
not by your words in the video. I don't get that.
He did.
Because you bring up the fact that when he's choking you, you can't breathe. That's how you felt when he cheated on you. You couldn't breathe. And you verbally several times told him,
cheated on
just
me.
fuck you.
Well, you said it in the video, but you won't
video.
let us play the rest of it. 'Cause you don't
And
want
the
to.
When I
male,
say cheating,
the
it's
male detective jumps in at the
on
right
his phone.
times.
Okay.
Was
Cheating's
super like
cheating.
I
And if
think
you
so
just
too.
a little bit deeper
Exactly.
question.
It's your definition of cheating, though.
I like how
Yeah.
you sent it to her.
That's what the word cheat means.
And that's what you told him in the video. That I couldn't breathe when you cheated on me.
No.
That's how I felt when he said, Sarah, I can't breathe.
And you told
I
him,
don't
fuck
know
you.
what you, this is
What would you say if somebody told you that they had done this?
done what?
Zipped somebody in a suitcase and went up and went to bed.
Do you all not think, so you all think that it's like, oh, good, I got him in there, now I'm gonna go to sleep? Is that what you guys are trying to
I mean, we haven't
assume?
seen much of the ex-husband.
Or trying to,
But what we
like,
did,
We're
he
just, the
seems pretty put
video
together.
is very portraying
definitely
of
had-
the opposite of what you told us.
No.
It does not,
Full custody,
it is
majority
not
custody of
leading
the
up,
kid. I'm just
it's
gonna
not
hope
matching what statement you
that
gave us
dad
in the
protected
car.
his kids.
So,
And that's why we wanna know.
and
the
I don't remember
injuries-
doing those.
The injuries are not consistent with what you told us. So we have a lot of inconsistencies, and this video explains itself. It really, truly does.
You don't think that I have thought about that?
Thought about the video or thought about?
But no, again, if you don't mind, please. So you all are assuming that it's like, oh, good, I got him in there, now I'm gonna go to sleep? Is that what you all are assuming?
Well, it's not an assumption when that's what you told us that happened.
That's what happened.
And the video,
Yeah.
yeah, I mean,
But I'm not gonna say,
you thought he could
Goes
get out
off,
on his
yes.
own, but the video shows that he cannot get out on his own.
but when I unzipped it with one finger.
From the outside.
But it had the hole in it.
And you're claiming that it had a paper clip, so that's what assisted you in doing it.
No.
Is what you told us.
When I had my sweatshirt, I said I thought it had a paper clip on it. It's got,
But the zipper part is broken, that
yes,
helps
which is
you
why we were
accept
gonna
it.
send it.
Yeah.
I just,
You were able to unzip it from the outside very easily, because that's the way they're designed.
but you could on the inside too. I don't know how.
Well, why wouldn't he have gotten himself out if he could? He was
I don't
asking-
know,
he was
like, I don't know
begging,
if he saw, like, where the hole was.
In fairness to
I don't know.
I
her,
didn't see a hole.
how else do you?
No,
I didn't see
he's
no
a-
fingers
How do you
sticking out.
explain this?
That's what I'm saying, like, he's in one position, and where his head would be, we should be able to see fingers. And then when it's flipped over onto this right side, again, his head is closer to us facing the video, so we should be able to see fingers, and we don't see anything. We see no movement of him trying to unzip it or physically unzipping it. All we see is pushing up, trying to push out of it.
Please do not assume.
I'm not
My-
assuming. I haven't assumed
do-
anything. I follow
please do
evidence.
not
But my
assume.
intention was not, again, oh, good, I got him in there, now I'm just gonna go to sleep.
What do you think someone that knows nothing about this or hears just a little bit like, oh, they were playing around in a suitcase
She's been
and then
drinking
and then watches
probably
that,
sleep. That's what happened.
but you let him out before. I mean, you put him in, so why didn't you take him out?
Because I was upstairs and I fell asleep.
No, before you went upstairs. You like consciously had to walk upstairs. I mean, you obviously remember going to bed because you were able to give me a time frame on that. And you specifically told me that you
I
went
don't-
upstairs.
My intention is not for this to happen. I am sick about it.
There's
I've
George
never
Wagner was just
done
sentenced to
anything
life
like this before in the
in
past,
those Pike County
I'm
murders where
sick.
8 people were killed in Pike County, Ohio.
especially with that. I thought I couldn't sleep last night. I don't know.
Well, here's the thing. You tell us the last night, you vividly remember this when you told us last night, that he was laughing, you were laughing, you put him in the suitcase, he has 2 fingers sticking out, and you go to bed. Now we see something totally different, and it actually shows you upset and, again, using derogatory terms to him when he's begging for his life to get out of that suitcase.
So,
what
but my thing
you
is
say
with
we're
the-
assuming, we're not assuming,
but
we're
the
telling you
fingers,
what's on there.
but, so it just happened to be that whenever I was videotaping or doing whatever else it was, just happened to not have that in it.
Okay. And you also, in the video, you can't see any holes. There's nowhere in that where the zipper separates and you can see a hole. If there's a hole, he's pushing on it, begging you to get out. We should probably see that hole that
He
you're
essentially
talking
would have
about.
been able to get out.
Alcohol.
Based off what you're telling us, he should have been
Yes.
able to get out.
Okay.
But the video shows him attempting to get out, begging to get out, and he can't. So that's just what we're trying to figure out. I don't know if maybe you had too much to drink, you zipped it up all the way, and then,
I did not zip it up all the way. I did not zip it up all the way. This is horrific, okay? Horrific.
It is terrible.
Yeah, somebody left their life.
Horrific. I don't think I'll ever be right because of this. Ever be right.
Lady.
Dealing
You
with
never
everything
were.
else that I have in my life, personally. And then this,
Back to me.
whom I love.
Oh, AK, you're absolutely
It was
right.
not
It does
intentional.
go back to me so quick.
I will put my hand on the Bible. It was not intentional.
You don't believe in the Bible.
I would not do
Sorry,
that
that
to
was
him
rude.
nor
She might.
anyone
I
else.
shouldn't say that.
You did.
Not intentional.
You intentionally went up to bed.
I didn't intentionally go to bed because I'm thinking, okay,
Hold
good,
on,
he can
hold
get
on.
out.
How did you not intentionally go to bed? You said you went upstairs and got into bed. That's intentionally going to bed.
Waiting for him.
And he doesn't come, but you don't go down to check on him.
So I happen to go to sleep. When I say go to sleep,
And what do you
he goes
normally do
off
when
or
you go
whatever
to
you're
bed?
gonna do.
What do you normally do when you go to bed?
What do you mean?
What is a bed for? Going to sleep.
Right.
So you go to
But
bed to
obviously
do
you
what?
can tell too that, like, I've
You
been
go to
drinking
bed to
also.
do what? Okay.
Detective.
You kept telling us, hey, I wasn't intoxicated. I wasn't this. I wasn't that.
Being drunk and intoxicated, which, yes, you can tell that I had been drinking, but
Okay. So if you weren't intoxicated, then why would you ever leave somebody in a suitcase that's begging to get out, that's telling you they can't breathe?
if I hadn't been drinking, you still think it would be the same thing? Where it's like, hop in, I'm gonna go to sleep. Is that what you all are trying to do?
God about this part.
I'm trying to do anything. I'm simply asking you to explain to me.
There's evidence of this.
What happened?
We'll go with allegedly because you're right.
Everything
but I
was
think there's
fine
evidence.
and dandy.
I don't want to call it fine and dandy.
Was fine and dandy.
Explain
You
to
all
me how.
don't, okay, for me to tell you this, again, mind you, I've been without him for a day now.
Mm-hmm.
I don't know, I mean, I don't know what you all want me to tell you because this was not in any way, shape, or form, hand on the Bible, intentional.
Okay. So you just left
I
him there to
didn't
teach
kill
him.
him.
You left him there to teach him a lesson?
I didn't mean to leave him there. That's what I'm trying to tell you.
You got up and walked away. How is that not intentionally leaving him there?
Because I'm looking at the hole, knowing that it's there. He'll get out and no problem. Because you don't.
And then he doesn't,
but
you don't go check on him. You say you're up for 30 minutes and he doesn't come up. You don't go down and check on him?
I'm in the bed.
You even moved,
And
I
goes
mean,
off.
you admit to moving the suitcase, like, over, so.
You roll it.
You roll it out, like, it's not like.
I didn't want it to be like that. Don't.
You didn't want him to be upside down, how do you even get upside down?
Right. You guys are killing me right now.
I just want you to.
No, you killed him.
That's how he talks to me most of the time. I don't know
It says they
how
have to listen to her when she says she doesn't want to watch it.
you want me to say it.
I'm just trying to figure out what you would expect to happen to somebody when you leave them in a suitcase.
I didn't mean to leave him in there.
Okay.
What's your reasoning for, not calling 911 sooner?
Because I didn't know what to do and how horrific it was. I called Brian, and like what, 5 minutes later I called you guys? Not even 5 minutes. Nonetheless, that I had to like I was trying to do CPR. I was trying to do CPR. I had to get him out and try to do CPR.
Call till the next
And
day
then
at
call
like
you back.
noon.
And they was continually doing CPR with the dispatch on the phone, where he had me count out loud to help me focus on what I was doing.
It just, I don't know how, I mean, you can sit here all day long and say, I thought he was gonna get himself out, but that, he didn't, and you went upstairs, and you stayed there for 30 minutes before you fell asleep.
But can I say too, like,
You chose not to ever at any point during that 30 minutes walk back
Check
down
on him.
and check on him.
no, wait 1 second, because I know, like, with you all, and then, like, because you continually ask me, like, timeframes, where I told you, like, I don't bother even looking at the clock most of the time. So it's like a guesstimate. So for all I know, maybe it was 10 minutes.
Okay. But the point is, you left the living room where he was
discouraging to birds.
begging for help, went upstairs. Regardless of how long you were there, you left. You say,
I thought he was the boy calling wolf. Again.
Okay.
So when he asked to be let out, like, what's your reasoning for not letting him out?
When I was upstairs?
No, when he's asking on the video, he asked multiple times. He asked to be let out. I can't breathe. Why didn't you let him out?
Well, number one, I had no idea it was going to end like that.
Okay.
Number one.
Okay.
Number two, just, you know what? I'll give you 5 minutes or so in there. They'll give you 5 minutes.
5 minutes for what?
Because I've had the thought of, like, she doesn't seem that
Well,
evil.
based off the video, one video is at 11:12 and the next one's at 11:23. So you actually gave him at least 11 minutes per video recording. So my thing is, when it stopped, he asked multiple times.
I honestly think there's a lot of drugs at play with her.
To be honest with you, I mean.
Were you punishing him?
No, just.
Well, that's what you're saying in the video.
This is what you get. This is what you make me feel like.
See, and then it's all backfired on me. Like, it's all backfired on me. And I understand the severity of this.
You did.
It's awful, I know.
Okay.
It's awful. And I will tell you both this right now, too. I will never drink alcohol again.
Okay.
Like, I will never drink alcohol again. I don't care what it is in any way.
Oh, girl, you might be drinking hooch.
But let's get back to this. What was the reason for leaving him when he's begging to be let out? I don't understand that.
What I have a feeling was, and again, it's the whole time frame thing. You all.
I'm not asking you a time frame. I don't care about a time frame. He's in the bag saying, my God. And you say, fuck you.
For the whole few minutes that he was in there,
Detective picks his spots and goes hard. I like it.
Just a few. 11.
For the one video.
Well, in between the two videos.
Between the
11
two
minutes.
videos?
Oh, yes, but if I can get anything
So what's the question again?
in the
When
research
he's
plan,
begging
I'll
for
tell you.
advice, telling you he can't breathe, let me out, and you say, fuck you, why don't you just let him out? What are you trying to prove to him? There was obviously something in your head that you were thinking of when he was asking the lady to be let out. You're like,
again, it's the boy calling wolf.
And there didn't seem like there was a ton of substances on board in that.
You say this is a game. You got
obviously the wrong way.
Good points.
So what was your intention for leaving him in there?
And it's not fair. It is not
I try to see the good in murderers.
You
I
guys
don't know.
are
You're
trying to, again, he's in there. Night, night.
That's what happened.
No.
That's absolutely what happened.
Intentionally.
How's it not? You got up
She tricked him
off the couch,
into getting in
walked
the
up a flight of
suitcase.
stairs, and got in your bed.
Thinking he was going to get out.
And he didn't, and you still didn't go down and
And
check
it's
on
the
him.
whole 30-minute thing that you guys are trying
I don't
to
care
do.
about
Whatever.
getting in the
Like, for all I know,
He's
it was
begging
10
for his
minutes.
life. He's begging for his life, telling you he can't breathe.
I don't know what you want me to tell you. I don't. I didn't intentionally mean for this to happen.
But you
Then what
can't
did you
tell us
intend?
why you left him in there and went upstairs. That's my only issue. Like, what am I supposed to write? What do I write?
So my thing is, though, it's what I have a feeling
Didn't seem
is I
too
went
far
upstairs
gone in
and
the
went to bed,
body cam
kind of
either.
But again, I'm thinking he'll be up
That's a
here.
good point. That's going to be a good
But then
question
I
at trial.
go out.
But my question is, why didn't you just let him out prior to going up?
I don't know why.
He started as like, if you're saying, hey, let's play hide and seek.
You
Right,
said,
I know. I don't
this
know.
was supposed to be fun. You were
got
laughing
this,
before
so-
you said. He was
She was
laughing,
talking
you were
in this
laughing,
point,
you
some
went upstairs,
sort of
he had his
game.
fingers out of the bag and he was playing. Obviously, that's not the case.
So are you guys, so what is it you're trying to, like,
We're just trying to figure out why.
why? What?
Why?
What was
why,
the motivation for leaving him in the bag?
Why he was left in the bag? Why the
I
video?
didn't have any motivation. It was he and I having a great day, fooling around and being stupid, and apparently me going upstairs and going to, hitting the bed, not going to sleep, where it's like, I'm tired now, I'm gonna go to sleep.
That's excluding, it's a good analogy for the day, excluding the fact that he's got a bump on the back of his head, a bump on the front of his head, and his lip is busted, and he has a
Oh my
bump on his eye.
I don't know what you all want me to tell you. Like, this is not fair at all,
Yes.
that you all are assuming that that's from me.
Where else did it come from?
If you were, say it's opposite, you were in the suitcase and you're asking to be let out, would you hope that that person would let you out? Like, you're asking to be let out of a suitcase, should they not let you out?
Eventually, I'm guessing. I mean, I'm blaming it on the wine. So you guys are like assuming that.
You keep saying we're assuming, or we're not, we haven't assumed anything.
But you guys are assuming that that's what I did.
No, by what,
Like, this is
the facts of what happened. We got there, you said you pulled him out of a suitcase, you said you went up, you went to bed. We're not assuming that. These are the facts that you're telling us.
But
Now
what
we're
you said
asking
is
you
like,
to
oh, I'm
explain it.
tired. Oh, I'm tired.
Well, that's what you told me on a sworn recorded statement yesterday. Because when I said, oh, you went upstairs and passed out, you were like, no, I did not pass out. You got attitude with me because you were you thought I was assuming that you were drunk. So that's an assumption. That was an assumption when I said you passed out. And guess what? You corrected me.
You were very adamant about the fact that both of you had your wits about you. What's your favorite word to use?
Compass mentis.
You've used it today too, to say that you guys were within your wits. There's two empty bottles of wine.
No, but we didn't drink both of them.
I think you did.
We didn't.
There's receipts for the
They were
same
both
exact day.
purchased yesterday, so I don't know how you didn't, because they weren't there the day before.
So one
There's
was.
two Publix receipts from yesterday.
Mm-hmm.
Only thing purchased on either one was a single bottle of wine, two of them. So we have each bottle of wine that was empty in your garbage can that you purchased yesterday, or he purchased, but you two would have consumed together.
No idea where that came from.
So it's not even worth going back.
So this is. So I don't know what you guys are. I don't know.
We were just hoping that we could figure out why you.
What was the motivation?
There was no motivation.
Wow.
Well, we're watching a video that, after talking to you, everything was laughing and fun. Now we're watching a video where it's not laughing and fun. He's begging for his life, and you are in a very angry voice telling him to fuck off.
No.
Yes, that's actually absolutely what it was. It's not an assumption. The video's there. We played it for you.
So you guys think that I intentionally.
You did.
It
You got up
doesn't matter
off the couch.
He's from Texas, y'all. I don't even have
Walked
like
up the couch. Walked up the
vertical watch or clock or anything.
That was intentional. There's no way getting around that. You intentionally did that. Nobody drug you up there. You didn't float up damn stairs.
Okay, well, it's not fair. It's not fair that you guys keep trying to say that that's what I did.
I don't know what to tell you.
You told us that. You didn't go upstairs?
Again, there was a hole in a suitcase. I unzipped it from the hole with one finger.
Well, the damn hole didn't do him no good, did it?
I hate her more than they hate
Did he?
The video
No.
shows him pushing up.
And
If he could push it open, why wouldn't he have gotten out himself? Why would he beg you to open it?
I tell you, he can't breathe.
Okay.
If someone can do something for themselves, they're gonna do it. They don't need assistance unless they need assistance.
So, but why would he start doing it?
Because he couldn't, because it was all the way zipped.
Okay.
Didn't see it.
It wasn't. I intentionally didn't do it. That I intentionally did not do.
What's that? You didn't intentionally do what?
Zip it all the way. He nor I,
I think she just admitted
Yeah,
to
that's
that
on
it
each
got
other.
done, but it wasn't
He's
intentional.
dead as a result.
I understand that. That's
Sometimes
why.
she's bad at talking, so I don't know if that's what she was saying.
No. I don't have anything.
You're right.
He doesn't. Whatever that is, whatever it
He
is.
does.
See, this is what happens. It's not fair. that you guys, just because he has those, automatically blame it on me. Like,
Well,
Where else
what
are you
about
gonna
when
go?
you had your injuries and he gets arrested? Is that not fair?
really? Like,
It's
really?
the exact
Yes.
same thing.
Really?
He has injuries. You have injuries. Like, what does that mean?
I don't have any injuries.
Correct.
Because
So
he
nothing
and I
happened to
have
you.
not been at it with one another.
So every time that you guys fight, you both hit each other? So you should have probably
No.
gone to jail all those times that he went to
No.
jail for domestic?
Well, the one time I did. But he completely
She needs a lawyer.
the police report. Because that's nothing what happened. Because the reason why I got taken in was because my story was different than his. So I'm being portrayed as like this abuser.
We're not saying that he doesn't abuse you.
Absolutely.
We're not saying.
So I'm the one that's being portrayed as the abuser.
Because
I have never dealt with anything like this before. I don't know what to do, how to do it, and I always know what to do and how to do it. This, I don't know. So I don't know, like, what's going on or, like,
I'm glad I watched this a second time because I'm starting to really question if she's ever been, if he ever abused her ever.
Story. You're telling us, we're going with what you're saying, but then we find stuff that negates what you're telling us.
and I don't even remember doing that.
Okay. You're telling us that we're assuming stuff, but what we're simply doing is telling you what we saw in the video and
I
repeating what
understand.
you told us.
I understand.
You just said.
Because I don't remember that.
Okay. Doesn't mean it didn't happen just because you don't remember it.
So is the
Wow.
texting thing something about me? Like, what's,
The what? Texting? Oh, no, I'm texting.
No,
you guys are scaring me, so, like, I don't know, like, what to expect. I mean, I had questions of things that need to be taken care of, like, I don't.
What are your questions?
I have one last question. You realize you're the person that killed him, right?
I thought about that.
Okay, you left him in a bag when he's begging you, saying, I can't breathe, let me out, and you said, fuck you. And you got up off the couch and went upstairs and left him in that bag.
Not intentionally.
Again,
I would never do that to George.
you did.
Not
It happened.
intentionally. Know that.
I don't.
Know that.
You got up.
Dude, the
You
anger
went up
she's
to bed.
displaying in that, like, you
Alcohol
know that
is
too,
a
man. I didn't-
shitty thing. It's alcohol. Not,
Alcohol
again,
is the reason that you killed him?
you all,
Please sit down.
listen to me.
Please sit down.
You all, listen. I did not intentionally kill him.
So your intention.
I don't know what it is I
to
need to
punish
do
him?
or how to do it or what to say or how to say it.
But what was your intention?
Everyone knows. Everyone knows everything that I've done for George and love him and continuously helped him throughout his life with me and made him a happier, better person.
And everybody has their limits.
Everyone knows that.
Everybody has their limits.
So it's like, okay, so while we're in a good place right now, I'm gonna snap. Is that what it,
Yep.
while we're in a good place right now?
You did.
Absolutely. I got you on video screaming, fuck you.
This is what it feels like when you're choking me. This is what it feels like.
Which was however long ago. You said
The
it.
video was from last night.
Clearly,
So it wasn't
still
that,
inside you.
yeah.
there's still feelings towards it. You wouldn't say it if you didn't feel it.
But I would never do that.
But it happened, and you did.
But that's after being playful
But no one's
and
laughing.
having a good day.
No one's laughing except you.
I would hate
Everybody's
to see
having
a
a good
bad
day. Oh, I'm sorry?
I would hate to see a bad day.
I did not kill
Y'all
him.
are making me out to be a person that I'm not. Nor
I think
have,
she was just
or
going to
will
say
I
it
ever
twice
be.
to reiterate.
Or are
but
you a
who
different
knows?
person when you're drunk?
People have different personalities after they consume alcohol.
It depends. It's like well.
Because you're sober now, so sober you.
Nice
Well, what
person,
about drunk
easy
you?
going.
Not, it's both of us. It's both of us. And it's, again, it's not fair that you all are assuming that the marks that he has on him are from me.
We asked you where they came from.
I have no idea.
Well, nobody else was there, so nobody else was
I
there.
have no idea. I swear I did not lay a hand on him,
Okay. You just zipped them in the bag.
nor he.
You just zipped them in the bag. And then you flipped the bag around several times.
I didn't do that intentionally.
You didn't intentionally flip the bag around?
No, why would I do that?
Well, you
Good
told us
question,
you
you
did.
did.
When he was upside down.
Right.
You had to put them
You
upside
can't
down.
get, you can't get in a suitcase upside down
Yeah,
because
See how
the,
she acts. Like,
Oh my
it's
God.
you put the
completely
stuff
different.
That's the
where his
unfortunate,
body was.
that's the unfortunate thing too, is nobody else was there. That's the
We have a
unfortunate
video
thing.
showing the suitcase in several different positions. So it shows, one, like she just said, it had to been on its back with the lid open for him to get in there, for you to zip it up. Then it shows it on the other side with him in it, so you had to flip it to there. Then there's another video where it's on its back again, so you had to flip it to
I'm
there.
leaving it like this, please. I'm leaving it like this. I did not intentionally do this. No malicious content or effort was towards this. No malicious.
The
I
way
would
she
say
said
that
it,
help you sleep,
this is
but
how
you're
it
not
feels when you
sleeping,
choke
so.
me. When she's
Last night, I maybe
recording on
got an hour.
camera, thinking
Right.
no one
In
else
your
is
voice,
gonna
you
see
can hear the
that.
maliciousness. The
Tells
fuck
me
you is
that
very, very.
You don't talk to
that
people
he
like that.
probably
That's
did
not
at
like
one
a
time
common like,
choke her.
hey Scott, fuck you.
Thank
That's not common. It's not something
At
people
least
do.
one time.
And no one that sees that is gonna think that.
Okay.
So we were trying to give you an opportunity, and it is what it is.
There's no maliciousness towards
Okay.
that.
I would probably be telling myself that too
My
after that video.
intent was not for that to happen.
But you went upstairs and went to bed. Or maybe you passed out, I
She
don't
just
know.
did a
Waiting
double
for
negative there
him.
too.
And the whole
I don't know if it's that she
thing,
doesn't know
like,
how to talk
it's
or
regardless,
that
it's not really fair.
But it's waiting for him. It's not like you walked up the stairs. No one can, you can't fly up the stairs. No one can take you up the stairs.
Okay.
You go up the stairs, you lay in the bed, and you wait for him. Who cares if it's 5 minutes? Who cares if it's 30 freaking seconds? He's begging for his life. He's begging to get out. You go upstairs.
You leave them.
It doesn't matter. So get the time frame out of your mind. It
This
doesn't
whole
matter.
thing, look, it doesn't matter, it doesn't matter, because there's this, so it doesn't matter anything what it is I say. So it makes no difference whatsoever.
It's just you're lying, and like you're now changing
Who's
your
lying
story.
about what?
You're now you were drunk.
Oh, I never said that I was drunk.
Exactly, but you did here today. That's okay.
You said earlier.
Everything recorded.
Alcohol.
You blamed it on the alcohol.
You blamed it on the alcohol. Alcohol does a lot to people.
Yes, but I never said I was drunk.
Okay.
You did.
So you did this sober.
I blame it on the wine.
Knowingly left them down there sober.
I have already told both of you also that we were both drinking.
Right. Okay. But you want to admit that you were drunk? Is that?
I'm telling you all both. This has changed my life. I will take this. I don't know.
Yeah. That's a true statement.
Absolutely. But you're trying to dance around the fact that you
So, but what are
did
you,
leave them
okay,
there.
just,
You left them in there. You're trying to
Oh my
dance around the
gosh,
fact
this
that
is-
you left them in there.
this is not,
You didn't leave them in there?
it's not cool. Like, this is not cool.
It's not cool.
That it's,
He's dead. It's
but
not
you
cool.
think that I did that intentionally. You think that I did that intentionally.
You intentionally left them in there and left the room. You went upstairs to a different room.
Me a little bit more of like she was really just trying to scare
And I'm
the hell
thinking
out of
he's
it.
gonna get out.
Okay, and he didn't.
Obviously not.
I honestly don't think she like full-heartedly intended
But when you say that though, but you have to, y'all
Please let
don't,
me out. I can't
y'all
breathe.
don't know George though. Like, that, again, I thought it was the boy crying wolf. So it's just like, what?
Oh, so if your son was in there and said, I can't breathe, are you open, or is he 9, so he's not,
Really?
it's not a big deal. I'm just asking a question.
What he did.
Oh, you said you would never put your son in a suitcase. You would only put George in there.
No, George got in a suitcase.
And you zipped it up.
Not all the way and not intentionally to leave him there.
But that's what happened. But you keep going away from it.
I don't know.
That's exactly what happened. You went up with the bed,
So
woke up the next
are
day.
you all trying to have me admit that? Like, are you trying to have me admit that? Because I will never admit it because it's not true. It's not true.
I'm basically stating as a fact because that's what happened.
Okay.
You videotaped him asking.
For having a chat or leading me to believe this is going to be a way
So
more
what,
interesting
guys?
trial than.
So what? Like, just, I don't know what you want me to say, other than it was not out of maliciousness or intentional. I don't know what or how I can say it. I love George. Love him. To this day still. Love him.
Love makes you do crazy things.
It doesn't do, it's not one of those things where it's like, oh gosh, you know what? I've done enough for you at this point. I never gave up on him.
Okay.
Why I'm here today, I'm still not giving up on him.
He's dead, homie.
Would do anything for him.
Well, you gave up.
I'm still not giving up on him. It's weird.
Gosh.
He's dead.
We're simply just trying to go through. I mean, again, you gave us a completely different story that you churched up to. This was such a laughing matter.
It was fun.
Not by that
All
video.
day. All
Not
day.
by that video. That
All
part
day.
wasn't. Anybody looking at it doesn't. I don't think anybody would look at that video and go, George is having fun right now.
So why is it you all think that y'all don't know me, you don't know me,
Nope.
would do something like that, especially having a 9-year-old son?
I don't know.
Like,
having
why-
a 9-year-old son would be.
Like,
Why are you so like caught on what we think
Yeah.
when
because
you should be
it's
more
like
concerned about what you've told us?
It's because
And
like you guys
The
are
fact
like
that George
trying
is dead.
The things that the video shows that are opposite of what you told us, and then what you've now
like
told
what
us
is
here
opposite?
today. Well, you said that it was funny, and you're the only one laughing.
We were playing before that.
Okay.
But then it stops.
Yeah.
It obviously stops being fun.
Well, I
Because you're screaming at him. He's
am
begging
not
to get
screaming
out.
at him.
Sounds like screaming at me.
I don't know what you all want me to tell you. In no way, shape, or form was this intentional.
Except she didn't want to watch the video.
Ever.
She knew it was on that.
Are you still gonna allow us to do your fingernails?
Go for it.
Go for it. Okay, cool. All right, I'm gonna get that set up.
Do you need any more water?
Ooh.
No, but when you come back.
You read in the first sentence, but I think that's still going to be murder.
So what?
Because the actual act was intentional.
So it
I don't
wasn't.
understand how your story changes so much to the
How
fact
is
that.
it changing? Please help me explain,
Well,
understand.
You went on about how this was such a playful thing and you guys were laughing. And it probably was for a few minutes, but then it obviously changes. The whole demeanor of this whole situation completely changes. It's not the funny, laughing matter. He's not laughing at all.
I didn't think he was being serious.
You absolutely sound serious.
I
when you're
didn't think
answering
so.
that.
Like, just,
You don't think your voice, you sounded serious?
it's, okay. I don't know what you want me to tell you.
The truth, lady. The
It
truth.
was a great day.
Tell me the truth.
It didn't
It was a
end
great
well,
day.
I was
obviously.
gonna say, that's, I mean,
I can't thank you how horrific it was
okay.
to find him. Horrific. Because I don't remember taking this to you.
Okay.
How horrific. I'm thinking he's in the bathroom. I'm thinking he's downstairs in the laptop. I can't find him. So what's gonna happen? Like,
Here's what gets me though, is you don't remember taking videos, you don't know where he is, you don't remember him being in the suitcase, and you're still telling me that you had your
Pretty
wits
close
about
to 1 o'clock in Texas.
How does someone have their wits about him when?
I thought we'd have
see,
a
that's
further
the thing too, but you can clearly tell that I had been drinking some. You can clearly tell.
I had several people that came up to me in that apartment complex said that you were drunk on a daily basis. and
Oh
you were
my
screaming at
gosh.
him
Right,
regularly.
right.
Really?
Right. Talk to the property
Really?
manager. Talk to the property manager.
Okay.
Because it's not,
These are your neighbors, the ones that live next to you. Your property manager does not live next to you. They
Texas is kind of a dick, and I love it.
I mean,
Oh
you
my
had two neighbors that went
gosh.
to it.
Yeah.
see, that is just not fair.
Hold on. You had two different neighbors that lived directly next to you. You asked to use the restroom and they told you no and turned you away. You had to go
Oh,
across the way to somebody else.
no, okay. Kim and Eli Eli, or Kim is not a nice person.
Okay.
She's just automatically not nice. Even after me and Lucas went over there and introduced ourselves, she's just not a nice person.
Then why would you think she would let you use a restroom?
Because Eli was in there. Eli comes over and talks to us sometimes, which I think pisses Kim off because he comes over and talks to us. The two of them, they're like super standoffish all the time. My neighbors down the street, down the way, their toilet was broken. They had stuff in the bathroom. So then they're like, go over there and try over there.
There's 2 bathrooms.
I wouldn't let somebody go upstairs and use my personal bathroom. That's what the downstairs one is for.
If it's somebody who
It's
likes
all
it.
about her.
They're in the process of doing all this stuff in the kitchen, and there's stuff in the bathroom, and the toilet doesn't work. Just walk across the way, no problem. And of course they let me in. Them and them, they're together. They're families. And nonetheless,
The most concurrence I've ever had. Hit that like button. Hit that subscribe button.
So he's
Hit the
trying to work on
notification
it.
button. Share it out. Help me get in the algorithm. Thank you.
They didn't want to be involved.
Thanks for getting me to the most concurrence.
No, I was asking last night, because, I mean, we had several different people in the
Assuming
neighborhood come
that
up
Eli and
she was
Kim.
drunk on a regular basis.
Eli and Kim. Okay. Did you ask Vinny next door?
Those are the ones next door that she asked to use the restroom, and they said no.
No, she said no. And like I said, she's not a nice person.
They're coming. What are your questions?
Yep.
Who's coming?
To do the fingernails?
Yeah, you said that we could.
And you don't have to allow us to do it, just so you know, so don't think that it's.
I don't have a problem.
Okay. Just make sure.
So, am I getting my phone back?
No.
Not today.
What about Lucas's laptop?
No.
Not today.
What does that mean?
We're still going through everything.
Oh, that's fine.
You're the one just telling us there's videos that we need to see on it, so we need
That's
to do our
fine.
due diligence that we go through everything.
See, and that backfires on me now too, because now you all think that I had even more, in quotes, intent to do what I did to him, which was not intentional.
I'll agree on this. That she didn't really intend to kill him, but that doesn't get her away from the
So, but I'm
murder
asking
charge.
if that's correct.
It's not about like
You're
what she
saying, I'm
really
not-
intended to
you're-
happen. It's about was the
So
act
his probation officer.
intentional.
Mm-hmm.
And
Do you all inform her, or do I
I
need to
think
call her?
that's still the act committed was still absolutely intentional.
Would like to call her, you can. Are you saying because he's still on probation?
No, but because of the nice lady that she is and all that she's done for him, I thought I didn't know how it was.
Legally, we just have to tell his parents, and we don't go telling. We don't.
Everybody else?
I didn't even know who his probation officer was, so no, I wouldn't.
Who doesn't
So
want
the
those
same
parents
thing for
notified?
classes. I need to do that too.
Classes. You need to do what?
Substance abuse class and his battery
cancel.
intervention.
Yeah, we
Something
don't
else I
have
was
to
just
call
getting ready to
him.
ask. So, other than this, so initially, what was the cause of death?
She
There's
is
still
pending
the
because
intentionality,
she
and I think the
wants
intent.
to hold the body for an additional day to see if more of those bruises turn.
I
into
still think it's
something
murder
bigger.
because she intentionally zipped the suitcase
and,
closed
she's
and
doing some other
intentionally
stuff.
did not let him out.
So she's pending it for now.
So, and that couldn't have been because of him being in the suitcase? Or
That's
y'all
what-
are saying that I
that's
physically
charitable
did it?
here.
That's what she's.
I think a normal jury might be.
So,
The ones on the head, I asked her, could that have been?
A normal jury might think that she just intentionally
She didn't think so.
did it to kill him.
I didn't touch him.
And
Nor did he touch
you know
me.
what? I can't breathe. Fuck you.
I'm leaving it at that.
It's probably
Um,
murder.
So, I don't know if you all know how to do this, because
What-
so that's what I was
even-
gonna ask, you were gonna ask.
And it's
So,
still a depraved
are you
heart.
all
She
updating
was
his
still
parents today,
trying
or
to
when you get final, whatever?
abuse
What
him.
does it matter? Why? What we tell his parents, what do you mean?
Because
We're gonna talk with them.
Yeah.
okay,
I have to.
but it's
tell-
gonna
like,
come down to me.
What do you mean?
Yeah,
Like,
different stuff.
So it's being put on me.
Who said that?
But I'm not, so what is it you would tell them?
We're gonna give them an update, just like we gave you an update on their autopsy.
Okay, so it's whatever
Well,
bruise,
here's
scratch,
the
and
thing, here's the thing.
whatever on the head.
We had to deliver news to them last night that their son was dead. There's not a whole lot of conversation that goes on after that. It's not a very easy thing
Was
to
it
do.
yesterday or Sunday? Sunday. Today's Tuesday, right?
Her questions that she came in written down. She wrote down a bunch of questions now. They're getting to those questions now.
I'm just asking. Right? Did we not meet yesterday?
It's a valid question.
Really? Yes, on Monday.
Okay.
Got it. Perfect. So I don't know if I asked you guys or how I find this out other than talking to his parents, which is not gonna happen.
Yeah, probably a terrible idea.
How do you guys suggest me finding out about funeral?
That's not even something that's been probably talked about between the family. That's not something we
Sorry.
asked. We have no way of.
But
I didn't know, that's why I'm asking.
It'll
So,
be up to them to make the arrangements of what they want to do. Like she just told you this quick, just being told last night, I'll pretty much be willing to wager that they have not even considered what they're gonna do.
My body can't even be released, so.
I've been there with parents, grandparents, and uncles. So I don't know if I have the right to or not, but like I was gonna call his former employees whom he really cared for and let them know.
You can call whoever you want.
I just don't want to do something that I'm not supposed to. How do I go about getting his wedding ring, engagement ring?
It's at the medical examiner's office. It'll come to us eventually, and then.
It'll be released to
to
the next
family.
of kin.
Yeah.
I bought it for him.
That is a
Don't matter.
issue. On his finger, it goes to them. They're the ones that are gonna release it. We don't have any say in that.
So I won't get that back.
these questions just make me
So
hate her.
for all of this, like, how do I find out what's what and how many, like, what's been found?
What do you mean?
Pillow with stain, swabs of stain from pillow, suitcase.
That will all be sent off to
FDLE.
FDLE, Florida Department of Law Enforcement. They do their testing.
So, and then like whatever white can with blood and necktie with blood was from the suitcase. So, why would you guys, oh, you'll see it in there, the baseball bat for Lucas and the feet. And this is just his phone, my phone, and then the laptop.
Yeah, when anything can be released, we will release it, but we are very early in this investigation, and it's not an overnight process, unfortunately.
So, what's next?
They're gonna come and swab your fingers.
No, I'm talking about like in the long run. Like, what do I need to like? Do I need to be doing something or
Yeah.
like?
Getting your affairs ready to go to prison, lady.
I mean, like, so like for, like, I don't understand. Like,
She's
I don't know if you
100%
guys are
digging
just
for
gonna,
evidence, and she did that in the body cam video.
because it makes it sound like to me like I'm being accused of something that was not intentional. I'm being accused of it, and a handful of other things that I'm being accused of.
Okay.
So I don't want to be at home with Lucas and you guys show up. So
we're still investigating. I don't know what you want me to tell you.
So is there going to be concrete whatever it is, and then it's like, okay, this is what it is kind of thing, or like, because I've done the whole court thing, I've done the whole attorney thing, I've done whatever. So if I'm not admitting anything about being intentional and I killed George.
Dude, she's been into court before with lawyers.
That's not the situation, but it's trying
God.
to depend on me.
She has no excuse.
That
for
was
not
not
calling a lawyer
my
right away.
intent. But it's trying to depend on me. So however, or whatever it is I need to do in order for that to be proven, then I need to do so, which is why I'm trying to get my ducks in a row. So that's why I'm asking
You
what
should
the
have done
next
that a
step
while
is,
ago,
other than
you
me
drug
getting my nails
addict
swabbed.
idiot.
I mean, you want me to tell you how to not be accused of a crime? Is that what you're asking?
I'm trying to prepare myself for whatever may need
These
to be done,
detectives are
so
awesome.
I can, I guess, stick up for myself.
I mean, I think you're.
We have a verdict?
Fine. You came, you talked.
I just don't want you guys to, again, show up and Lucas is in the house.
Well, we did tell you yesterday that we don't want to do anything around your son, hence why you came to us. So I don't know why you think that's going to change.
That and or me not just show up back home.
I'm sorry, what? That or what?
Me just not show up back home. That's what, oh, he's so happy that I'm staying over at the house with Brian. So happy. And I'm not going back to the house, to my house, for however long I can stay over here because of whatever to blow over.
Mm-hmm.
And again, if you don't mind me asking, so for whatever it is you all are claiming from the videos, which, yeah, is that what you're going to tell them? Like his parents? It's like, oh yeah, and by the way, she did.
Did what?
I mean, what was
She's
he
so
telling?
concerned about his parents.
I don't think it really matters what we're gonna tell the parents.
Oh yeah, it is a fuel to the fire.
Well, we can't hide things, and I don't know, I'm not saying we're gonna go, I'm not saying that we're gonna go and tell them every single thing we have, but again, this is the Orange County Sheriff's Office, that's public record, so eventually, like, this all will come out.
Mm-hmm.
So, it does, like, I'm not,
Matters, honey.
you're making it sound like we're gonna tell them something, so then your life is in danger, and I don't like that accusation. So let's just nip that in the butt right now.
Well, that's what's going to happen.
I cannot
But
What are we gonna
choose.
tell them?
But we can't even, but so technically there's no concrete report yet even.
Right, so
it's,
you want me to like tell you exactly what I'm gonna tell them? I don't know what I'm gonna tell them. I don't know what I'm gonna tell them. Let's just leave it at
If I
that.
remember
It's like,
this,
you don't know why you went upstairs. I don't know what I'm
correctly,
gonna tell
this
them.
little argument gets kind
So,
of interesting.
Parents that are dealing with.
Can I call you the way that I did last time?
Yeah, my phone is an open line. This one should be there. I don't watch the
I get it. Look, I get it. That looks really bad.
Mm-hmm.
So that's what scares me. Like, what do I need to plan on? Like, what do I need to plan on? I promise you, on my son's life, it was not intentional. I promise you, on Lucas's life, it was not intentional.
I don't know you. I can't say I know anything about you. I don't know what would be a true statement, what would not. I mean, you're promising on your son's life, that's fine.
That's how much it means.
Sorry.
That's how much it, look, that's how much it means.
Okay.
I hope you take that to heart, please.
And it's documented that you said that, yeah, I get it.
Do you have any idea when I can get my phone back?
No telling.
What do you say?
I just said no telling. I mean, our digital forensics unit is, got a lot of cases on their plate. I mean.
Well, and that's not technically my laptop, it's Lucas's laptop. But he plays, you'll see all the games that he has on there.
As soon as we can get that back to Lucas, we will. As soon as we can release your phone, we will. But we have no way of being able to tell you because we don't have control over their caseload and how they arrange what they do. So I don't know. And at this point, I think, honestly, with everything else that's going on, that should probably be at the bottom of your list of worries.
Yeah, it's Orlando, Florida.
I'll
look up the actual charges. I think it's murder one. In that case, it could be life or death, but I don't think they're going
He
for
has
death.
his
I'll pull it up
laptop
when
that
we're
he
done
has
watching
to
this.
do for work, but he doesn't want him using it or breaking or dropping. It's not a big deal. There's nothing on the laptop anyway. So you will keep me posted, like updated.
Too screwed here.
That's my thing, is I'm trying to figure out what I need to do in the meantime.
I don't know, I can't, like, I don't know what to tell you though. Like, what?
But you all have more information than I do, where it's like, yeah, you might wanna, or yeah, you might wanna.
Like, we have more information on what?
Like,
We told you everything that we have.
There to
You know
help
everything
you.
that we know. And most of it we got from you.
but that, like I was telling her, like, yeah, that's bad. Like, which I swore on my son's life was unintentional. So that's why I'm trying to figure out what I need to do for myself going forward with this, nonetheless, with his family. And are you all just showing up with Lucas in the house?
I think we've already both told you that we would be mindful of any situations.
So you guys, I guess you're gonna call me tomorrow? Or do we need to come back down here?
I'll chat with you next time. I have no idea what I'm gonna call.
This is the report come out
With you
tomorrow?
whenever you want to be here.
I'm just saying a report is generated through us, and the sheriff's office is a public entity. So if someone were to come request something, then.
No, I'm talking about, his
I don't remember if they caught her right here or
She's
not.
waiting and doing our follow-up, but.
I hope they do. They have enough.
Yeah.
But she won't be finished with him because she's pending for other stuff.
So after this, what? I'm done? For now?
Absolutely done. Yes. AK-47.
How long does this
Big
take to
advertisement
get
there.
back?
This trial starts on January 30th.
The
I
FBI
will absolutely be covering it live, carrying it live. Hopefully we'll get some good lawyers in with
We all
us
know
to
about
provide their legal opinions and analysis as well as mine. If there is any possibility of being able to,
calling my phone.
it is a second degree murder charge. Okay, that's probably right. Second degree is right on this.
I hope you all can really both.
Research, and I'll be doing my research too and making videos.
I miss him a lot.
I mean,
No
I,
more.
but my question has remained the same. What do you expect to happen to somebody?
On trialjunkie.online.
Yes, but you have to understand too, I know.
No, just what would you expect to happen to somebody?
If there's any coverage of voir dire
I had no
or
idea
jury
because I've never
selection,
done it
I'll be
before.
covering that too.
Why have you never done it before?
Why would I?
Exactly.
Why would I
did
do
you?
it before?
Why did you do it now?
It's on January 17th.
I clearly have said why. Why?
I will cover that
No,
live.
you don't know
if,
why. You just know that it's not intentional, but you don't
Mark
know
Jensen's
why.
case doesn't bleed
That's okay.
into it. It likely will, or likely just be
I'm not trying to force you to say something that you don't know.
late at night or pulling the good stuff into a video.
Feeding and penning.
can't remember for the life of me. I hope they put bracelets on her hair. That was fine. I can't remember if that happens or not.
The fact that you guys would assume that I'm that kind of person.
We're not assuming anything. We're going by the facts. It happened.
Like you said, you don't know me.
In Texas, still no verdict announcement. I'm a little surprised. Listen, I've seen this. I watched it though when like it was first released, and I don't remember the end. Don't tell me. Don't give it away.
In itself, for me to have to live with getting him out and doing what I did is punishment enough. I think that's why I haven't slept, because that's all I see.
Well, I think these facts fit right into this.
So that right there says something. Not my intention.
You think that's right? I mean, the jury did the hard part. I can't see them trying to wanting to stay more than a day leading into Christmas week. And the way the judge was talking, he like made us. He talked with the assumption that deliberations today.
Nonetheless, I have to live without him now.
Yeah.
Nonetheless. Punishment in itself.
Everybody's justification is punishment within itself. Okay, so then we shouldn't have prison for anybody. Living with what you did is punishment enough.
I'm through with alcohol. And it's unfortunate that stupid things like this happen.
Mm-hmm. Absolutely.
Nonetheless, I have to live without him now.
Mm-hmm.
I think it was just talking. She's going for that, like, maybe we'll just get up and then walk out right now. It's so bad for me.
Are you trying to make it worse?
Sorry, what?
Are you trying to make it worse?
Make what worse?
How I feel?
Making a comment on
I like
She's
it.
fine. That was there yesterday. I think she took your photos.
She has a mouth. I don't make it worse. That's make it worse.
So I'm just gonna take a swab and go around on one hand
Don't
and
talk to
then take
cops.
it around the
Rule
other.
number 2, if you're going to talk to cops, don't talk to them like that.
Right hand.
I wonder what they need her DNA for. I wonder if they swapped for DNA on him. It'd still be hard for that to prove anything. They were boyfriend and girlfriend. Subscribed twice. One time was for 22 seconds. The other one was for 19 seconds. The other was 247. DNA, transfer DNA under her fingernails. I still don't think that proves a whole hell of a lot when you're boyfriend and girlfriend, but whatever. They need to be, just in case. Something might come up where they need it. And you know what? Actually, the more I think about it, this is just what you do right before you cuff someone. But I don't know if that's going to happen or not. Don't tell me. No stories. She looks really tough. We just hit the 3-hour mark. And I should call her a sentencing watch. Still nothing as of yet.
Okay, Sarah. So
Here we go.
you're not free to go. Okay.
Yes.
Oh, do you promise everything you told us was the truth? Or no? Everything we've talked about today?
Yes. What do you mean?
He asked to swear. Remember how I swore you yesterday on the audio recording? I just forgot, so he raised his hand to remind me to tell you.
Okay.
Do you promise and swear that everything we talked about today has been true and accurate to the best of your knowledge?
For which?
True and accurate to the best of your knowledge.
What, that it wasn't intentional?
Everything you've said today. Everything that's come out of your mouth
That's not
has been
you.
true and
Supposedly
accurate
that
to the
was.
best of your knowledge.
I had that fixed, but let me switch. I'll fix that.
Yes.
Why?
That's
Because
how
anytime
you
we talk
swear.
to somebody, we want to assure that everything that we talked about is
True and accurate to the best of that person's knowledge.
not a trick question,
To the best of my knowledge?
to the best of your knowledge.
Everything that you've told us today is true and accurate to the best of your knowledge.
Yes, but it was not intentional.
Okay. Okay.
All right, do me a favor, stand up. I need you to turn around, face the wall, put your hands behind your back. Do you have anything in your pockets that I should know about?
Back and clearer than ever.
Why is this happening?
Because George is dead.
Not intentionally.
We understand that.
He's still dead.
Well,
I remember
Someone
all
needs
this
to
now.
call Brian, please.
Okay.
Or can I not make a phone call?
You'll be able to make a, when we get you down to the jail.
So
You'll
why
be
is this
afforded.
happening? So this was a trick?
No, it's not
No,
a trick.
not
How's
a
it a
trick.
trick? I'm even here to ask you to explain a few things to us.
Uh-huh.
And
You were read your rights.
your response to everything was basically, I didn't do it.
Intentionally.
Doesn't matter. It's still there. Do me a favor. Have a seat.
Really, guys?
Really.
So if I didn't show up?
All right, guys. I think we have to do it too after this. I
Why
think
is
we're
it
going to
happening?
video recording of herself.
Before y'all said I could leave. That I was
It's
done
still on
after
YouTube.
this- after that.
We were done, yes.
I mean, it's dark, but it's not any
So
darker than
now,
what we
so that's what it is.
listen to all the time.
We are done.
Right. Not intentional. So what am I supposed to do?
Okay, you have cuffs on now. Shut up.
You will.
Someone needs to call Brian.
Okay.
Lucas is waiting for Mom to come home. This was not my intention. I thought I was waiting for you all to come and figure out what's what and how many.
This was not my
And I
intention
was
to come
going to
here
be
and
able to
get
go
cuffed up.
home and see Lucas.
Good. Too bad.
Now
So
he's just not
sad.
gonna have me come home. So there's nothing that I can do.
No.
All right, no.
There's nothing that I can do in order to go home and see Lucas and prepare.
Not right now, no. You'll be afforded a time in court. You'll be afforded an attorney. You'll be afforded a chance to talk to a judge, and all that stuff will be worked out.
But what's the time frame for that though?
How about now?
I have no way of being able to tell you. You should make first appearance probably
Is that better?
tomorrow morning, if not tonight, depending on how things are busy, how quickly you get down there. I
I had a
don't
sneaky
work in
suspicion
there.
this was gonna happen. And I need water like really bad, please.
Have a seat.
Awesome. Guys, someday I'm going to get a whole studio set up. It's going to be amazing.
Absolutely did not.
Thanks for the input.
I just got those.
Okay. They are not allowed in the jail.
So I can't
What
even
are they?
figure out where to go.
I think her shoes.
And what am I supposed to do with my car?
You'll be fine where it is. When you get down there, you'll have 3 phones. You'll be able to call.
What, as soon as possible?
Yeah, once you get down there, get booked in, you'll be able to use a phone in the waiting
But
area.
how long will that take? Because I need to talk to Brian.
I don't know, it depends how busy, how quickly they get you through.
Exactly what they are.
I would say within the hour. It's a free phone call.
I'm telling you,
in
man.
the lobby, it's a free
All
phone
I'm
call.
doing is bringing
Nicotine
dinner,
addiction
so-
is real.
She has no clue.
So can I ask you, or whoever it is, those holding cells, the holding cells, am I gonna be putting one of those?
I don't know.
Last time I had a panic attack.
Let them know that.
Yeah.
It's
I don't know.
all about
Well,
her,
you're
man.
familiar with the big bay. As long as you go in and you act civil to them, they'll set you in the big bay. And you'll be left there for
Can
a
you
while.
request that while I'm there?
No, that's not up to us. We don't work at the jail.
As long as like he's saying, is if you don't
If
act
you
up.
go in and act like this, you'll go in and they'll put you in the big bay. If you go in there screaming, kicking, and yelling and
Why would
cursing
I
at
do
people,
that?
I don't know. I'm just letting you know that's what
He's
happens.
helping you,
That's how they weed
jerk.
people out. If you go in acting like this,
So I ask for the big bay?
no, they'll put you there as long as you're acting like this.
Yeah, because the last time I had a major panic attack on the little things.
Let them know.
So that means last time you were acting like an idiot.
I have not.
So what am I gonna do with my purse? Oh, sorry.
Your purse is gonna come, but the cigarettes and stuff can't, so.
I put the lock out too. My bad.
Oh, no, it's all good. Mine are now opposite, so.
What made you all decide to do this?
Made us decide to do this.
Uh-huh.
George is dead.
George is dead.
You guys, I knew this was gonna happen,
You did? Okay.
so I came
Well,
down
we
here
gave-
willingly.
Yes, absolutely. We were trying to figure out what's going on. We're still trying to figure out what's going on.
Unintentionally.
Intentional or not, George is dead.
She's kind of admitting to manslaughter.
You act like when you say unintentionally, that absolves you from everything.
I need to get, I have my, I don't know if it's able to be or not.
I apologize.
No.
I have things in my car that I need to.
Put your.
What kind of stuff do you have in your car that you're worried about?
Well, I have my medication.
Okay, they have a pharmacy there, so if there's something that you have to have right away, you'll be seeing a nurse.
It's panic attack stuff.
Well, again, when you get checked in, you're gonna be seeing a nurse, and that they have a pharmacy there, so they'll be able to take care of any kind of that stuff. That protocol is out of my realm. I don't work down there, so I don't know, but I do know they do have a pharmacy, and that you will be afforded to see somebody. Okay?
All done?
Yes, ma'am. I, let's say,
Yeah.
my bad.
Yep.
All right. So that was fun. Yeah, even if she was innocent, her attitude sucks. She just thinks it's all about her. All right, so let's watch. Let me check in on all of our channels that we're watching to make sure that they're not saying anything new about Aaron Dean. And then we'll watch her video, and then I think there's a longer pretrial hearing for Mark Jensen that we can watch too. Let's check in with our friends at WFAA and just see what they're talking about.
Different. And the other thing we also see with the Dallas Police Department, I don't know if it's this way with Fort Worth, but I know it is with Dallas, is that you often see like a lot of veteran officers want to go up to North Central. That's the division where it's kind of a running joke that people go to retire,
right?
On duty.
Sure.
And so I just think you have to have more balance on your shifts. If you want
we're not listening to this garbage.
Then retire.
She might have a point, but
Evan Jones wants to know, will
this
the
isn't
state
helpful to any of us.
condolences change the jury's outcome?
And they're taking questions. Let me stop share here. What do we have here? She's definitely betcha 100%. Yeah, let's see if I can find her video. It's a little disturbing, but it's not that bad. Oh, I don't know if it's out there anymore. I don't know if I have it clean. Yeah, I do. Here we go. So this is going to be the cell phone video that she recorded herself. Then this is what they were asking her about in the interrogation that we just watched. Let's pull it up. Turn the volume up. The cackling's awful, but I don't see anyone bailing when I say I'm going to watch it, so let's watch it.
Sarah.
For everything you've done to me.
Sarah.
For everything you've done to me.
Sarah.
Fuck you.
Sarah.
Fuck you.
Sarah.
Stupid.
Sarah.
That's my name. Don't wear it out.
Oh, God, I forgot she said that.
Sarah. I can't fucking breathe, babe. Seriously.
Yeah, that's when you do when you choke me.
Sarah.
He's so desperate.
Sarah. Sarah. Sarah, I can't breathe, babe.
That's on you.
Sarah.
It's on you.
Sarah.
She does sound wasted.
Real ransom. I want to get video for it extra. Because I got this.
Sarah.
Real ransom.
Sarah. Sarah, I can't breathe, babe.
Oh. That's what I feel like when you ching on me.
Sarah.
Fuck you.
Fucking breathe, Sarah.
Yeah. You should probably shut the fuck up.
Sarah.
Yeah. She was definitely slurring there. From what I remembered it being a little like more angry, but alcohol and benzos is what Miss Priss is saying. That sounds right. Wow. So yeah, anyway, we'll be watching the Sarah Boone case. I think a lot of other channels will be too. But we'll be watching Sarah Boone case. Starts January 30th. We will watch pre-trial on January 17th, as long as Mark Jensen isn't live. If Mark Jensen's live, I'll probably watch it that night or during a break or something like that. Or we'll have a verdict watch where we can watch that. So that's that. She definitely, the attitude is terrible. That I think that the video puts her in, the video convicts her. That video looks like second-degree murder to me. Awesome. So let's pull up. Since we're just here waiting for a verdict, let's pull up. I think there is a longer Mark Jensen hearing. So let's pull that up. Yeah, so here's the motion hearings that happened about a month ago. I'll pull those up. And again, just pulling stuff up, hanging out with y'all while we had tried to achieve our actual goal is to make sure that we're live and ready to go when there is a sentencing decision by the jury in the Aaron Dean trial. If you haven't hit like, subscribe, please do so. The concurrent viewers are higher today than they have been for me, so I'm super excited about that. Small growth is growth. But hit that like button, hit the subscribe button, share it out, help me get in that algorithm. And I'm just pulling up. Every time we have a little transition, I just want to make sure that I don't miss anything in the Aaron Dean trial. There's still nothing tweeted out. So let's go ahead and watch the motion hearings from about a month ago in the Mark Jensen case. It is 1:30 in Fort Worth. So I think that puts us at about 3.5 hours.
There you go again. This thing is really slow today.
I love how this chat has all kinds of different areas of knowledge. So same courtroom. Like I said, from my understanding, we're being this courtroom for actual trial too.
I got some ear things for you to try and help with hearing.
See if they work. Exactly.
Mike sounds super good in this courtroom too, so that makes me happy.
Are we good?
I believe so.
All right. Let's go on the record. Mark Jensen, 2002 CF 314. Let's have the appearances, please.
The state appears by Carly McNeil from the Kenosha DA's office and Robert Jamboy, special prosecutor.
Attorneys Bridget Krause, Jeremy Perry, and Mackenzie Renner appear on behalf of Mr. Mark Jensen.
Oh yeah, I can't believe I forgot this. This is in Kenosha. This is in Kenosha, Wisconsin.
Good morning.
I can't believe I forgot that.
We have victim notification from the state.
We are in compliance.
All right, we are here for motions, and it's my understanding.
So this is in the same courthouse that
17 motions. Am I right on the number?
Kyle Rittenhouse. The Kyle Rittenhouse trial happened in. Oh, they're gonna get me.
Have that many on my sheet. I know that there is a motion in limine that has multiple ones within it, but
she's kind of quiet.
Good. That's a good start. We got rid of 6.
the question is what 6 we got rid of.
All right.
So the state did count 17 defense motions, and those are numbered in the state's consolidated reply filed June 27th of 2022. So if it's not 17, then we're not sure what the number is.
All right. Well, I'm going to knock some of them off right away.
Okay, but he's loud, so I'm not going to boost it.
Since the defense filed the motions, they should keep track of my rulings, and we're going to need some kind of written order to be filed. So then when we're in trial, we don't have any issues about evidence or rulings that are not being abided by. So the first one is the request not to use the word victim. I'm going to start out by saying that Wisconsin's always been giving victims rights. In 1993, we had a constitutional amendment, and it mentions victims numerous times. And now, as the attorneys are also aware of, we had Marcy's Law passed. That's still the law of the state of Wisconsin. It hasn't been overturned.
That's a good idea. I can do that.
And I believe when it was on the ballot, it was passed by 75% of the voters in Wisconsin. And Marcy's Law talks about, I think, at least 16 rights that victims have. And it mentions victims constantly. And there are enforceable rights through the criminal justice process, just like the accused person has. And one of the interesting aspects of Marcy's Law is if the judge doesn't follow Marcy's Law, he can have consequences. Not the attorneys, but the judge. So that's how strong victims' rights are in Wisconsin. And it talks about, and I think the exact wording on one of the sections.
Okay, bro, but Judge
crimes
Schroeder did
committed
not allow
by
the
a
term
defendant
victim in the
against a
Rittenhouse
victim.
trial.
It doesn't say convicted, it says committed. So I'm going to allow the use of victim. It's very, has a strong history in the state of Wisconsin, but
I don't like it.
We're not going to have a trial where we say victim 2,000 times. I think the state, they've have.
Okay, what about 1,000? Where you drawing the line, man?
Numerous trials. You understand what I'm saying? But it's going to be allowed. This is a homicide case. There's the burden of proof beyond a reasonable doubt. I think the jury will understand what their role is, that they have to look at the evidence and base their decision on the instructions I give as to jury instructions, as to what the burden of proof here and all the other instructions, and make their decision as to that. So the word victim is going to be allowed. The other motion that I'm going to decide, I think it's the only state's motion, and Ms. McNeil, you can correct me if I'm wrong, but you want the jury to be able to ask questions during the trial, correct?
So that was a response to a defense motion.
So who asked for that?
The defense referenced that in one of their motions in limine, and the state's response was, let's just follow the jury instruction on that.
All right. If you're going to talk
these camera
to
guys
defense,
kidding.
obviously, which attorney's
God,
talking
dude.
to the reporter, or the record's not going to be clear. So who wants to respond to whether I should allow the jury to ask questions?
Judge, I will. Bridget Krause for the defense. Asking the court not to allow the jurors to ask questions in this particular.
That's my ruling. I think it's I don't want to say a disaster.
He does.
It creates a lot of issues. If they ask a question,
I really don't like the term victim being used in a
not allowable under the rule, not
case,
relevant.
though.
It's difficult for them to understand. They want to ask their question and then they don't realize.
I understand where all the victims' rights movements have come from, and laws like Marcy's Law have come from.
Sometimes it really destroys one party's defense.
I get it.
Party's prosecution.
But
And they
this
work
trial
so
isn't
hard
really
in
about the
their trial
victim.
preparation, and suddenly this
The
juror
victim's
asks
not
a
on
question
trial.
and they go, wait a minute.
The defendant
We
is,
don't
and he
want you to
has
go there. And the other
he has a
thing
right
is,
to as fair of a
think
trial
the
as we
original
possibly can give
Jensen
him.
trial, and Mr.
And leaving the
Jensen,
term
you can correct me
victim
if I'm wrong,
out
was the longest jury criminal trial
makes
in
it
the
more
state
fair
of
for him, I think.
Well, I don't
Or
know.
her.
It was the longest
that's
one
Or
what
the
I heard.
defendant.
And it may well have been. It was a total of 6.5, 7
And I think
weeks.
there's 125 witnesses. Am I right on that?
Yes.
Okay. This case is going to take a long time. And
Yeah, I think people
jurors
like
to sit
Schroeder
for 4, 5, 6
more.
weeks, I don't
People,
know how long.
most people like Schroeder better
Just
than I
with
like
the
Schroeder.
witnesses that we have, and just with the questions the attorneys are going to ask.
I'm not.
Then
It
we're
wasn't.
gonna throw
I
in
mean, Borowski. They're all
allowing the
good.
jury to ask
I have
questions. That's just
criticisms
gonna
of
make
most
the
of them
trial
still,
longer.
but Yeah, you're right. They're all good.
And I don't think it's going to get to the ultimate question because I think the attorneys representing the state and the attorneys representing the defendant know what questions to ask, and they know what their defense is going to be or what the burden of proof is, and it'll come in. So we're not going to have any.
I think that's a very fair point.
Alright, Jelly Bean, listen up. If you're sick of sliding into strangers' DMs, begging for referrals, playing around chat.
They keep front loading these ads. I will have this fixed
Discovery
by the next time I go live, I promise.
I'm shocked that we have a discovery.
I definitely see your point on this,
my
Ms.
stuff.
Bruce, because from my standpoint, it's like, what's the real harm in
It's
leaving the
20
term
years
victim
later.
out in this case?
I was a defense attorney a long time ago.
In an SA case, I could definitely see where there's
Known
harm.
that the Kenosha District Attorney's Office has an open policy. It's one of the best things they did for discovery. It's been there for years. This case is in front of a judge for the third time. What discovery does the defense?
Yeah, I think
not have?
Daro.
I want
I think I have a
specifics. I don't
higher
want just,
opinion of
we don't
Daro
know.
than most of
Tell me what you don't have.
LawTube. I do feel like she thought she really did like to hear herself talk and didn't have to as much, but all things considered, she did a great job.
Discovery issues, specifically as it relates to this particular case. I believe the responses that they
Borowski has a little bit too short of a fuse for me, but still does a pretty darn good job.
On the back of his guilty plea questionnaire, it says that the district attorney will mention his cooperation in the Mark Jensen case. We don't have it.
Is he been sentenced already?
He had. That happened back in like 2008.
Okay, and did you look at the CCAP records to see what happened at sentencing?
We have the sentencing document. I mean, we can have the sentencing transcript, but the reality is we don't have whatever was promised to him at the time that he.
This is a different male prosecutor than we had
we have
at
another
our
snitch in this
pre-trial
case,
earlier today.
Yeah, Aaron Dillard, in which he testified in this case, and then there's
Absolutely.
a letter from the special prosecutor.
Well, and now we
to the
also know
DA
she
that
was
is filed after the Jensen trial.
she had
at the time of
state
the
Supreme
sentencing.
Court
We don't
aspirations,
have a copy of that.
which will lead anybody to
Trial date?
No, I just would like
talk
to
a little bit more.
Can the state provide that information?
So, Judge, in our consolidated response filed in June.
You want to tell me what page that response, the page on it?
Yes. So.
Yeah, folks, don't get me wrong. I
know it's 87 pages.
my opinion of Daro was higher than most. I think she did a really good job. You can find fault with anybody. All in all, she did a great job.
This would be relating to defense motion number 12, which is referred to on page 21 of the state's response. And then that refers to attachment.
And
8
I think
of the state's
we can
response
probably
as
all
well.
agree that it's pretty evident that she's a really, really good person too.
So we believe that it did, and we didn't receive any additional information after we responded in this way. So that would be page 71 of the state's response that has a letter from the Times DDA Angelina Gabrielle, and then letters that the state provided regarding these various witnesses.
All right, who wants to respond from the defense side?
Could you imagine if this wasn't, if it ended up being a Milwaukee County case and Borowski got that trial? Oh God. Someone would have to hold my hearings. Yeah, I mean,
I don't see anything on Bernard Bush.
but I think that's kind of part of the argument that a lot of like
Bernard Bush.
her critics have is that she could have been a lot
The
tougher,
defense can just specifically.
and
describe what
and the record would have been fine.
I can try to reply to that.
All right, why don't you do that for Ms. McNeil?
I'm looking for any promises
But,
that were given. to
but why
Bernard
risk it?
as a
Got a
result of his
sentencing?
testimony.
All right. Did you hear the response?
I did.
Okay.
So I believe that the letter in the state's consolidated response answered that question, but I can follow up on that. And
Why don't you follow up on it? So there's the only issue left is Bernard Bush. And we can revisit it if it has not been accomplished.
And Judge, another thing that we're working on is the updated criminal convictions for all our witnesses. And so we'll certainly provide those to the defense. We plan to do that before our judicial pretrial date in December.
Okay, I just got confused by the camera angles. It's all the same attorneys here. My bad.
Going to testify, and then before they get on the stand, we figure out how many prior convictions are, and then we obviously the witnesses talked to and told them the number. So I mean, I don't think that's a big issue.
Agreed.
Okay. I don't know how to bring up this other motion, but is the defense still wanting Mr. Thompson to testify that he sold cocaine to Bob Jamboys in 2006 or 7 or whatever that year was during the trial?
Judge, this is Jeremy Perry for the defense. We don't believe that what Mr. Thompson is saying is true. Okay, we think that this is a lie of Mr. Thompson's. We do think that his lie about this and his claim to say, or his willingness to say whatever.
Monster.com makes GANs great again. Yeah, you know what? I'm not going to say again because they never were. And
Ad Blocker Pro.
Try to
I'm
get him
just
out
going to
of
get premium.
whatever situation he's in
It's not that
whatever moment
expensive.
he's in. We think that lie is relevant in terms of being cross-examining him on that. And this is the state's witness. So he's
I don't care whose witness it is.
Well, it's the state's witness, and this is what the state's witness has told us.
It does matter.
Has happened, and so
Give me a date that he told you this. Exact date.
It's June of 2017. That's June of 2017.
Will they have an exact date? We're all waiting on the edge of our chairs to find out.
Eleven to 2016.
When?
November 2nd, 2016.
That's when he told the investigator about this.
Yes.
And when supposedly did he sell the cocaine to Mr. What year?
Sometime between November of 06 and
Between 2006 and January of 07.
And where did he sell this cocaine to him?
on a roadway in Salem in Kenosha County at nighttime.
All right. I think I could take judicial notice that Mr. Jamboy was not the district attorney that year. And my understanding, he was working for the state of Wisconsin in Madison.
That is correct, Your Honor.
The governor had
From October, I started that job October 1st of 2005.
Right.
And moved to Madison with my family.
So you're not in Salem?
No. It's about 2 hours from where I live.
You know, credibility of witnesses is always an issue. We impeach them based on prior statements. We ask them about prior convictions, and if they give us the right number, we don't get into the conviction. There's also other issues. If somebody's been convicted of some crimes that deal with truth, fraud, we bring that in. But I'm shocked that the defense would ask for this.
And Judge, just to be clear.
Can I finish?
Oh, sorry, Judge.
I think it's Bush League. I think it's unprofessional. I think it's outrageous.
Wow.
I've been an attorney since 1983. I've been a defense attorney, an assistant corporation counsel, a municipal judge, a court commissioner, a guardian ad litem. I've never seen this.
I
It's
wish I knew more
garbage.
about what's going on.
I'm not going to hold this ruling against Mr. Jensen. The record should be clear. But I think on a professional standpoint, it's uncalled for. And to say that it's a lie, what power do you have to tell me somebody's lying now? Do you have some magical power that somebody said something in 2016 about a drug
Oh, we're
deal
gonna
in
love this
2006
judge.
when Mr. Jamboy doesn't
I'm
even live in
excited.
that county? Well, one, maybe he's mistaken.
You might ask why I would be concerned with
He's
bringing
super
the
pissed at
history
the
of the
ads
Bible
that are
to
running on the stream right now. He's calling them Bush League.
And
it
what
sounds
is
like
the
they want to
jury
get
going to think?
testimony,
What does
somebody's
this have to
testimony,
do
and that
with
says
the
that they were
guilt or
set,
innocence of the defendant?
that he was selling coke to another cocaine to another
You're
person.
going to
who's not
impeach Mr.
Jensen.
Thompson. I think this is if I'm correct, because I did try to read everything, is the gentleman that was charged with 2 robberies in Illinois. Am I right?
Bank robberies, yes, Your Honor.
Bank
Yeah, it's about
robberies.
discrediting a witness.
I mean, how much? There's your impeachment. And Mr. Jamboy did write a letter to, I think it was the federal judge.
I wrote a letter to some judge.
Yeah, well, whatever. But so we know that he got consideration for 2 bank robberies. That's pretty good impeachment. And then the prosecution fulfills their obligations. So now the defense wants me to allow this defendant to say, yeah, I sold cocaine to the prosecutor who was trying this case. I mean, if it was on the other foot and the prosecution wanted me to say, hey, one of the defense attorneys bought drugs from one of the witnesses, the defendant would be screaming. And if I allowed that in, I'm sure the Court of Appeals and the Supreme Court would say, what did you do?
Okay, I just figured it
so
out.
damaged.
They're saying they wanted to bring somebody up that's saying that
No
he
way.
sold
It's reckless.
cocaine to one of the
It's just not
former
professional. It has nothing to
prosecutors
do with this
in
witness.
one of the previous trials.
It is so outlandish.
I wouldn't let it in either.
That it would just confuse the jury. It's not the way to defend.
And the
a case,
defense is
but
saying they
again,
don't
the
even think it's
record's
true.
clear. I'm just making a ruling on this motion.
That's what that's what they wanted to bring in, from what I can tell.
The other portion was, I did read that Mr. Thompson said that he sold the drugs for Mr. Brantley because Mr. Brantley couldn't do it or was in Chicago or whatever. There's documentation that Mr. Brantley was in custody at that time. So it's not coming in, and I'm not going to hold it against Mr. Jensen. He has an absolute right to a defense. And his public defenders can defend him with all sorts of other evidence and witnesses, but this is not coming in. There's no probative value here at all. It would confuse the jury to the utmost extremes. Okay.
Judge, I think we can get rid of number, I don't know what number it would be. The motion in limine that was filed by Stephen Glenn. My understanding is that was filed by Attorney Vishny because she was not prepared to file all of her motions, so she filed that. That's the purpose of that motion being filed. I think she then filed motions in lieu of.
Yeah, very highly prejudicial. It doesn't sound like it needs to come in. Like, it doesn't seem highly relevant at all.
Attorney Glenn filed back.
What's the motion regarding?
Motion on limine miscellaneous.
All right.
It has a bunch of random things that were decided back in 2008.
I'll make a random ruling that we're not going to decide.
Okay. We would just withdraw it, Judge. I think that additional motions were filed in lieu of it.
Let me get here. Oh, the issue of hypothetical questions, is the defense still asking me to limit hypothetical questions?
Your Honor, this is Attorney Renner. Your Honor, we just want to make sure that hypothetical questions are limited in such a way that they can be understood by the jury. When we get into, 2-minute, 3-minute descriptions of a hypothetical question, that seems extremely long, confusing, and really should be done more in if you ask me, in a smaller chunk. So the jury is very clear on what the facts are that the
Hypotheticals should be limited to experts. Okay, they are talking about experts.
Again, Mr. Jambos, you can correct me wrong. Correct me if I'm. I think in the original trial in front of Judge Schrader, I think he did not allow 2 hypothetical questions. That's how much I read the transcript. So
wow.
There was
This original trial was in front of Judge Schroeder.
I have great respect for Judge Schrader.
Amazing. Schroeder.
Man knows the law. You might not like.
Oh my God.
Hey, Bob, I know you're looking for your employees like me to work from home, but how am I supposed to bring this thing with me?
I think that's probably the last time it happens.
Sentence, whatever, but you want a fair trial, you go in front of Judge Schrader. I don't care what side you're on. He's going to give you a fair trial. So hypothetical
except that here,
let
some sketchy evidence in at the end.
They're used by experts.
But he's a good guy.
And, one of the interesting jury instructions as to an expert, and I've read it so many times in civil cases, is the line the judge says to the jury, you are not bound by an expert's opinion. You don't have to listen to any expert. I mean, the only civil case where you need an expert is a medical malpractice case. That's the only one.
They all do.
All the other civil cases, you don't need experts. Even the jury doesn't have to listen to them. And that's how experts testify. They get hypothetical facts. And again, even some of the facts that are given to experts don't have to be in evidence. They can be facts that they considered. So I understand what the defense is saying, that we don't want a hypothetical question that 5 or 6 minutes long, and that's not going to happen. I'm going to stop that. And I don't think.
All right, I have to fix my audio again, and I'm going to have to go to those other headphones, but I'm going to make. I think I can make it so I don't sound like I'm in a fishbowl for my first few words. I'll be right back.
It's kind of like a boilerplate motion in limiting that attorneys file. Most of the boilerplate requests are rules of evidence that we all follow, you know? And I think whatever side you're on here this morning, the attorneys are well aware of the rules of evidence and have previous trials. So we'll just leave it to what the jury instruction says on the hypothetical question. Sequestration. I don't understand what the defense is asking. I am going to order sequestration. Obviously, it's something that is important. We don't want witnesses sitting here and hearing other witnesses and say, oh man, that's what that one says. Maybe I should say something different. The only time we've had a different position is when the state comes in with their detective that did the investigation, and we allow that. And sometimes the defense has an investigator. We allow that. Is the state asking to have any exceptions to the sequestration rule?
So Judge, we believe we will be asking for one person to be accepted.
Who is that?
So right now we are thinking our investigator, Brian Stute.
Okay.
But just in terms, so I understand the court's ruling, certainly there's a lot of witnesses in this case. So we're going to have to, when they're waiting to testify, we're going to have them. Right. Just in one room though, would that be okay?
As long as you tell them, and I tell this is the attorney's obligation, you cannot discuss the case. And if somebody tells me they are discussing the case, I have the power to say, guess what? You're not testifying.
Yes, we completely understand.
I mean, I can't sit in that room and watch them.
Right. We'll certainly direct them of that. It's just there's so many witnesses that really they would be all over the place if they had to be in separate rooms. Some of the witnesses are married to each other, so certainly they're going to be coming to court.
And it's the same thing for the defense. You tell your witnesses, can't talk about the case. When the case is done, you're free to say whatever you want. And it's your obligation to control your witnesses. And if I find something that's happening, we will deal with it. But I can't. This is such a small courtroom. We have so many witnesses. I think it would be very hard to police what's happening with the witnesses, except for the parties. And we will give them that responsibility. So tell your parties we are going to do the sequestration and they cannot talk about the case. Okay, where does the defense want to go next for a motion?
We took care of that. I think there's a specific motion in limine regarding the Jensen home computer that was filed by Attorney Vishny and Renner in November 29th, 2016. I think that's an easy one for us to go to.
And what's the issue on that?
I think that the motion requested that it be listed as the Jensen home computer and not Mr. Jensen's computer. I think that's the basis of the motion.
What offer of proof can the state give me that how you're going to present that issue? We know the computer's in the home, right?
Right, correct.
So what offer of proof are you going to do?
So we're going to spend an extensive amount of time, as was done in the first trial, demonstrating when the computer was used, like time of day and dates that it was used, and the certain topics that were accessed on the computer. So of course, the state's overall argument is going to be that this use regarding poisons and things of that nature was done by Mr. Jensen. So really, this appears to be more an argument over terminology. But the state intends to prove, based on the totality of the computer evidence, that the person making the searches for things that would be evidence of guilt was the defendant.
I think that's appropriate. And you could argue in your closing or wherever you want that it's a computer in the family home, and obviously the state's going to argue that it's Mr. Jensen that used it. But that's a fact issue, and that's for the jury. I'm not going to make a ruling that they can't say that eventually. That's a jury question. They don't believe the fact, they don't consider it. I'm not going to make a ruling on evidence today whose computer it is, because that's an issue again for the jury. Okay, let's go to something else now.
Judge, the second part of that motion, sorry, was The defense requested an order that no witness be asked about the intent of a person who deleted history, files, or specific phrases, as it would be speculative.
Is that including experts?
I think it was including experts,
Yeah,
Judge.
I think experts can get into that. That's why they're going to be here. They're going to say this is what happened. I mean, people are shocked when they delete something. I'm not a computer genius, but I know one thing. They can find anything once it's in a computer on your phone. Everybody always thinks, it's deleted, or I've only sent it to this site. They'll never find it. These people
Not if you do it right, Judge.
experts in the computer field are well paid.
And sorry, everyone, I had to go back to these
anything.
headphones,
And
the
if it
AirPods.
gets
Hopefully
into
it's not
his
too
opinion,
bad on
he
the
can give
audio.
his opinion what happened. Again, originally I said juries don't have to believe experts. We're not going to have a lay witness make that opinion. It's going to be an expert. So they want to get in that area. And you could cross, the old idea of cross-examination. Ask the question, how can you come up with that opinion? What facts did you use? What did you do? And that's how
Struggling. I'm on the struggle bus now.
Experts. You have that opportunity. I'm not going to limit the expert as to his statement and his expertise here today. So if he wants to make that opinion and then you cross him and destroy his opinion, well, then the jury decides what facts are relevant as to what was deleted from the computer. Okay, what's next from the defense?
Judge, there are a couple of motions I think that are really along the same line. One is one filed on November 29th, 2016, amended motion and memorandum of law in support of motion to exclude improper opinion testimony. And this has to do specifically with Dr. Long.
Yeah, but I think one of your experts used evidence that's not even allowed in and is using it in their report. So I think Ms. McNeil, I think she used a very good legal terminology.
Judge, I think my concern is more about
Can you repeat that for me? I don't want to get it wrong. That what's good,
Actually, what's good for the goose is good for the gander.
I don't know what case that comes from or what statute it's from, but that's what I'm going to rule. Experts, I've had so many experts, and you don't know.
This guy is awesome.
If they want
I can't wait to watch him work for a couple weeks.
Allow it. I'm not. I had so many civil cases, and I used to tell the attorney, I can't try the whole case. They wanted me to try everything, every little issue. I said, what do we need the jury for? If we're going to try the case, it's not a court trial. So if you have an issue with an expert, with their report or whatever, we'll deal with it during the trial. But your expert is using stuff that maybe not should have been used, or facts that are not allowed, evidence that shouldn't come in. So we're going to.
So now we know every judge in Kenosha should tell stories from the bench.
Can I be more specific about the request? It's a very specific request. It's not just all opinion. It's a specific request as it relates to the letter that has been excluded, that Dr. Long's not able to testify.
Didn't your expert use that letter?
They may have reviewed it, but there's a difference between reviewing and relying on, Judge. And this letter has specifically been excluded by every court this case has been in front of, including the appellate court, the Seventh Circuit, and back to the Wisconsin Supreme Court. In fact, it was a unanimous decision by the Wisconsin Supreme Court that this letter was not to come in as evidence, and that it wasn't harmless error to allow that letter in.
Your expert's mentioning the letter.
Recordings just got better. Hey, it's Dana from StreamYard. I'm so excited to announce that local...
Whose expert's mentioning the letter?
Your expert.
If the expert was to testify that it was something that they reviewed, but not the contents of the letter, Judge. Not the contents. Experts can review inadmissible evidence, but it's whether they can testify about the specifics of that inadmissible evidence.
Is your expert, Ms. McNeil, going to use the contents of the letter?
Your Honor, I'll be responding to this.
Go ahead,
question. Dr. Long was primarily on cross-examination, was asked questions about that. The state intends to ask Dr. Long about the amount of ethylene glycol in Julie Jensen's body. We were not going to be asking Dr. Long about the manner of death in this case. We're simply going to ask him about the level of ethylene glycol in the body.
So why can't they ask him that question?
They can, as long as he doesn't say that his opinion is based upon the letter that Julie Jensen wrote that her husband, about her husband, her thoughts of her husband going to kill her. That's my concern, Judge. I have no concern about them asking Dr. Long about the level of ethylene glycol. That's not what's in the motion. The motion is very specific as it relates to the letter that has been excluded by all courts, except for the circuit.
Well, Your Honor, if I may respond. The state is not intending to introduce the letter at any point in this case in chief. However, it's not true that any reference to the letter is inadmissible.
I know it, because there's non-testimonial evidence by other witnesses that the letter can come in.
No, the non-testimonial evidence from other witnesses is that there was an existence of a letter, not the contents of the letter. I mean, there's a big difference there, Judge. The calls versus the contents of the calls.
All right, we'll stop it right here. I don't think the state is telling me they're going to use the content of the letter, and it's not going to, the content of the letter is not going to come in.
Your Honor, I'll just say this. What the Wisconsin Court of Appeals said in Jensen 2 was that one of the reasons that they thought it was harmless error for the letter to be admitted is because everything that was set forth in the letter was attested to by other witnesses. And so that's the content of the letter. Largely, most of the content of the letter was attested to by other witnesses in non-testimonial statements. So even if the letter hadn't come in, the jury would have heard, for example, about the Post-it note because Julie had testified about, or had spoken about the Post-it note to other witnesses. And references to the letter are admissible. References to the content of the letter are admissible. It's the letter itself that is not coming in the state's case in chief. Now, when
I'm going to stop you here. We're not going to decide this issue today. If the defense wants to give me a written argument within 5 days, I'll consider it. And the state wants to respond in 5 days.
Are we talking very specifically about the contents
Just
of the letter?
that's all. No other issue.
All right, y'all, it's official. Amber Heard has conceded defeat and is settling with Johnny Depp. I still haven't fully been able to confirm the 1 million, but that looks pretty reliable. That settled for 1 million, so no more appellate issues.
There is a defense to that, and
You got till November 25th at 5 p.m.
Breaking all kinds of other news on today's stream.
December 2nd, 5 p.m.
And Judge, I think that's going to be
Very limited issue. I don't want nothing else briefed. I got too many briefs on this case.
Judge, I was just saying that there's a motion to exclude references to testimonial statements. I think that the court is going to hold off on ruling that motion then until this, because they're the same thing. It's really about the contents of the letters being mentioned by citizen witnesses.
Guys, I wish I could tell you more about what these letters are.
Allow non-testimonial statements.
I'll be digging deep this week,
as there's a hearsay exception.
and we'll be ready to go for actual trial.
I'm talking about in reference to the
Again,
contents of the
today's
letter.
core,
I would ask the court to hold off on ruling there.
a core
until we
reason for
file
being
this.
live all day is
I will say this.
we're waiting on the Aaron Dean
I think there's
incentive.
this issue has been sufficiently briefed, but if the court wants additional briefs, we're more than happy to provide them.
Do
I
me
will-
the favor, help me out.
Yes.
I'm a senior citizen now.
There's a lot here, Judge, so I understand.
Defense counsel just made reference, however, she said, well, we've got to satisfy some hearsay exception. And the answer is no, we don't. Because what the Court of Appeals in Jensen 2 said, and by the way, Jensen 2 was not overruled on all points. They were simply overruled on the point that it was a harmless error. That's the only part of Jensen 2 that was overruled.
Get homeowners insurance. It will protect you against saying crazy
what
shit.
The Federal District Court, what the Court of Appeals said in Jensen 2 is that
Or could
the
protect you.
Wisconsin Supreme Court in Jensen 1 adopted a forfeiture by wrongdoing doctrine, a broad forfeiture by wrongdoing doctrine, which does not survive Giles, except with respect to non-testimonial statements. So with respect to non-testimonial statements, the forfeiture doctrine applies. And in this case, Judge Schrader, after a multi-day forfeiture hearing, determined that Mark Jensen was responsible, more than likely responsible for Julie's failure to appear or inability to appear. So therefore, the defense does not have a hearsay objection to any of the hearsay statements, that non-testimonial hearsay statements. That was the ruling in Jensen 2, and that is the law of the case.
Oh,
here.
wow.
And then this whole notion about references to the letter in non-testimonial statements, that's also the law of the case. And the law of the case is
Yes,
that the
absolutely.
references to the letter in the non-testimonial statements are admissible.
You
The
do
Supreme Court
absolutely have
said
to have a
that in
personal
Jensen
injury
1.
endorsement.
The Court of Appeals said
If
that
you're
in
going to try
Jensen
to
2. And there's nothing in Jensen 3 or any
have
federal
your
court
insurance
that
cover you for
changes
defamation.
that ruling. So the references to, in non-testimonial statements, the references to the letter and the descriptions of the letter are all admissible. And that's what the
Holy
courts
shit.
have said.
I'll make that ruling when after I get that brief.
Thank you, Judge.
Okay, so the letter said that it happened, and it included a photo of shopping list that he wrote that included antifreeze.
All right,
And other
what
portions.
motion do we have next here?
I think there's a motion to reconsider the decision denying defendants' motions to suppress the book, as Attorney Jamboy calls it.
To reconsider what?
Judge Kirkman's decision to allow in the book that was
Do
recovered
you have
from
any
Mark
new evidence, anything new that he didn't consider?
This is commentary. No. there's
Okay,
no
I don't know
evidence
enough about it,
that,
but
Motion's denied.
so you have to have a. I'll look into it, but
What's next?
however she pulled it off, she had it in her
There
homeowner's insurance.
is a motion and numerous responses as it relates to specific instances of, I believe, untruthful conduct of Ed Klug.
That's
And I
the
think
other
Attorney-
X motion that you have on Mr. Klug?
I think Attorney Renner's going to talk about that, Judge.
What can, Ms. McKeel, can you tell me what page your response is on?
Yeah, so this will be in the 87-page response, and there's two different responses, so let me get those for the court.
It's awesome. We have like experts in every single thing that comes in it. Oh my god. I might have to get rid of these live.
I was able to.
All right, next ad comes up. We're gonna get rid of them live.
So the state's first response is on page 44.
All right, thank you. All right, go ahead, Ms. Renner.
Your Honor,
This
under
chat
the
is
rules of
seriously
evidence,
full
we
of some
are
really,
always
really
able to get
people
into
with some
specific instances
awesome
of
expertise.
untruthful conduct. As far as the state's argument that the district attorney who ultimately was charging Mr. Klug at the time in regards to a statement that he had not hit a casino machine when the video showed that it had, according to the criminal complaints, I believe is inapropos, just because the state decided not to charge or determined that they
Inapropos.
could not
Good
meet the
word.
burden of beyond a reasonable doubt does not preclude other acts from coming in. As far as his financial dealings, I believe most of these would go to bias and need for money and ability to potentially collect on his notoriety that comes from this case. I think the question for the court is, under the rules of evidence, are these going to be considered specific acts of untruthful conduct wherein I have to accept the answer of the witness without being able to impeach using extrinsic evidence, or whether this is going to be allowed as other acts because there is such a pattern of untruthful conduct by Mr. Klug that at this point the pattern would allow us then to impeach by extrinsic evidence.
Well, as to the financial information,
It sounds like there's a lot of shady characters in this whole orbit.
The correct terminology is FINRA. It's got to be some sort of.
It's like Oler for
It's
stockbrokers.
got to be some kind of board that if you do something wrong, they investigate you. They found that there was no issues as to what the complaint was about on all the complaints. There's no police reports. There's no complaints to the IRS. There's no complaints to the SEC. You still have to prove your other acts by the preponderance of the evidence. And a lot of the issues dealt with a divorce proceeding, the issues of the financial misconduct. There's no criminal charges. One of the complaints was filed by somebody who had a bias towards Mr. Klug. It was out of a divorce case. There's depositions talking about certain financial testimony, and I don't think that goes to any untruthful statements. And but I do have an issue with this criminal charge. I mean, the
Still
financial
nothing out of
issues.
Texas.
There's a divorce. There was some complaints. There was no findings. There was nothing. But the criminal charge. What information does the state have as to exactly? I want something concrete, just not a statement. Why the state dismissed the charges? Why, you know?
So our belief that we put in our response is that the ADA concluded that the video did not show Mr.
Yeah, but do you
Klug.
have something in writing that's her statement, or is that just your belief?
So that's what I have right now. The defense did respond to the state's response and indicate that they were going to look into this issue further, but I have not heard anything else.
Has the defense looked into it further for why they dismissed it?
Your Honor, unfortunately, being a defense attorney, the DAs don't feel the need to tell us why cases are dismissed. So,
Judge, I can see if this ADA has any ability to look up her file and provide something. Maybe she can email or something like that. The other thing I would note about this criminal case is that it was alleged to have occurred in April of 2016. So at the time of trial, we're approaching almost 7 years later. So regardless, I would like the court to take into account the time that has passed.
I usually use 10 years. I've used that on all cases. So it's within 10.
And also to be clear, Judge, obviously this was a case that was dismissed. However, I can see if this ADA, if she's still an ADA, would be willing to respond to us and look at her file.
I'm going to allow it unless you give me something else from the DA as to her reason for dismissing it.
and Ms. McNeil, if you are able to reach out to the DA, we would appreciate the ability to see the video if it exists.
I will see what I can get from this ADA. Again, if she's still an ADA, I don't know her at all.
4 hours in Texas. I wonder if they're back there saying,
right, what do we
oh
have
no,
next?
now we got to compromise on this.
Judge, I think all that's left is standard motion and limines.
Which motion and limiting issues do we have?
Attorney Vishny, I think, filed one, and then I filed a subsequent one.
What's the issue in those motions?
And Attorney Vishny filed August 14th of 2017. There's some information specifically about.
I need business communication that works anywhere I do. Some of the tools may work outside the office, but others definitely.
Laura Koster. We already took care of number 2, which was the victim. We already took care number 3, which is evidence about earning money from the book. I would not argue. Number 4, I believe Attorney Jamboy agrees that they won't talk about the fact that he was convicted or sentenced.
So what ruling do I have to make here?
I think number 4, Attorney Jamboy agreed, so I guess the court could grant it.
So just so we're all looking at the same document, this is from August 14th of 2017, and this is the one labeled motion in limine to preclude prejudicial evidence, admit evidence, and set forth procedural trial matters. Is that accurate?
That's the one I'm saying, yes.
So I still don't know what the issue is.
There are 9 motion in limines that Attorney Vishney filed, and then there are 6 procedural.
Right.
Not sure
And
that
you
that-
talked about some that both sides have agreed to already, right?
Correct.
So tell me what's,
Number 2, the court already ruled on as it relates to victim, so that has been settled.
okay,
Number 3, any evidence that Mark Jensen intended to publish or earn money from a document seized from his cell.
has that been decided?
It has not.
I'm struggling
Is
over
the
here,
state
friends.
going to bring in that? Obviously, the books issue's coming in, but are you going to bring in that he earned money off it or he wanted to earn money?
We were planning on making some reference to his motivation in writing the book. It was to tell his story, and he expected to make a lot of money off of it. And it's the defendant's own words that we're going to be using. It's,
What does that have to do with the guilt or innocence?
well, it's the motive for
There's a
writing
book,
the
too.
and the whether, and he's indicated it's his purpose to tell his story and that he was going to make a lot of money off this book. And money was one of the reasons the defendant murdered his wife, so he wouldn't have to pay child support, so he wouldn't have to split up his assets with her. Money is a motivating factor. for
Allegedly,
Jensen
sir.
throughout this case, and the state is allowed to present evidence concerning motive for the crime. That's one of the reasons that the book, that the state will be requesting certain portions that would be admitted into evidence, is because of,
Don't we tell the jury that we don't care about motive?
No.
no, we don't tell the jury, we don't.
What
we
the hell
tell
are you
the jury
talking
that
about?
the state's not required to approve motive.
That's what you said it better than I said.
But nonetheless, motive
doesn't
is
mean they
something that the
can't.
state can prove. It can demonstrate.
I
as-
agree, they can bring it in, it goes to motive. Might not be true, but it goes to motive, so it's coming in.
Number 4, any evidence that Mr. Jensen was previously convicted and sentenced in this case. I believe Attorney Jamboy
Well,
agreed.
we're not bringing that in.
The state does not plan to bring that in. I will say this, Your Honor. The defense did not file a motion for change of venue. And the odds of us picking a jury in Kenosha County that doesn't know that Mark Jensen was previously convicted of this crime, I just don't see how this could be possible.
Well, that's their
That's fine.
decision.
We're just asking that they don't bring it in their case in chief.
It's not coming in.
Preclude
Yeah,
the
that should never
prosecutor from
come in.
informing the jury an opening statement what the anticipated defense would be, as that would be burden shifting.
I mean, we don't think that this is burden shifting. We agree that an opening statement is a statement about what the expected evidence will be. And both parties, everyone is to avoid argument. So
These
we
are all
agree to
boilerplate.
abide by those rules.
These
of
are
opening
very-
statements.
We don't give the
Boilerplate
juries an opportunity to
motions
take
and
notes
minutes.
during openings and closing, and there's a jury instruction that I read that opening and closings are not factual statements. They're not to consider it. It's just, an opening is the obligation of either side to show what they're going to prove or what they're going to do. And then when we do the closing, just to go over what they think has been presented. And I think, again, the attorneys are well aware of what they have to do during the openings and closings. So we'll just abide by the rules of evidence.
That would be granted.
Yes?
Preclude the prosecutor from vouching. I believe that Attorney Jamboy agreed.
We don't intend to vouch for witnesses.
All right.
Preclude the prosecutor from eliciting evidence of any telephone conversations by any witness unless the state can properly authenticate the voice.
Well, what we responded to this is we cited the authentication statute. There's many different ways to authenticate a phone call. It's not just the voice of the person. So we certainly will be abiding by the authentication
Again, it's the rules of evidence, however
This
they
is
bring
so
it in, they bring it
boilerplate.
in.
Plate.
Any
Dumb.
evidence the defendant has committed other bad acts not previously litigated before the court.
Yeah, no shit.
Do you have
But guys,
another
remember
acts
the
motion
defense
on the
had
defendant?
The defense has to bring
So
this
what
in.
we had
Or
indicated, I believe this is in our motions in limine, is that
the
Judge
defense has to make the
filed a
motion
prior trial,
so
other
that if
acts
they
we
do
intend to
this,
present. Those are
it's
the only
appealable.
other acts we intend to present again, based on the prior ruling of Judge Schrader in the case.
Are we
Was
talking
that,
about
was
the-
that issue appealed?
I don't believe so. If it's the panorama evidence, I think that's already been, also Jensen 1, that's the rule, that's the law of the case, so.
What other acts did the state bring in the original Jensen trial?
The other acts, Your Honor, from the last trial particularly pertain to the defendant leaving photographs around the house and claiming that photographs were left on the windshield of his car. These are photographs of a female head in close proximity to an erect male penis. And
oh, I thought you meant cut off head.
indicated that there was evidence that Mark Jensen was doing this in order to punish his wife for an affair that she'd had in 1991 or 1992. This evidence was deemed to be admissible by Judge Schrader because it was related, it demonstrated the defendant's hatred for his wife and his motive to kill her. And that's why it was admitted. And the state had a significant quantity of evidence supporting that, including testimony from the officers who'd investigated those instances, and also a private detective that Mark Jensen himself had hired.
But I don't know if they're letting the letter in. I don't think they are.
And the detective the private detective advised Ms. Jensen that it was Mark Jensen that was doing this. And Mark Jensen, during the course of his interview with Detective Ratzberg, conceded that he had on occasion planted these photos around the house as a means by which to get back at his wife when they were having arguments. So that was the other evidence, Your Honor.
That's the law of the case. It's already been confirmed by the appellate court or by the Supreme Court in Jensen 1. So that's not what this motion is. It says not previously litigated before the court.
Yes, and the state does not intend to present additional other acts evidence
That'd be granted.
beyond what's contained in the book. I mean, there are references to things he wrote in the book, but those are all statements by a party opponent. And the state is not contemplating any additional other acts evidence.
All right, then we got to.
Oh my God.
I recently joined forces with the Daily Wire.
An agreement. Let's go on to the next question.
As to the stuff in the book, we haven't received notice specifically about what they're trying to put into evidence. So if it's an other act, we would need notice of that. The book was not litigated before Judge Schrader. Or
did I hear you or did I not? You said you're not going to use other acts from the book?
No, what I said is that there are references in the book. There are things he wrote in the book that we will be using, and we have notified the court and counsel that the state would get that to the court and counsel sometime in advance of the final pretrial in December, which is scheduled for December 16th.
We'll wait for the final pretrial to see if it's given to the defense.
so we'll hold off on number 8.
Just remind me.
Okay. And then the last one the court already took care of as it related to discoverable material. I think we discussed that already.
All right.
The procedural things that attorney.
So Son of Sam doesn't really apply to this because his conviction was overturned.
We're not going to allow.
This is essentially an innocent man, even though he's been in jail for 20 years and probably did it.
In voir dire between possible prosecution and defense witnesses in the court.
And they're wanting to use the prosecution is wanting to use this book to.
What's the issue as to the witness list?
That there's no distinction between
prosecution statements against witnesses the party in.
I'm just going to. What I normally do is I ask the state to name their witnesses, and then I just say if there's any additional witnesses the state wishes to name. I mean, the defense wishes to name.
Okay. That all proceedings be recorded, including sidebars, voir dire, opening, closings.
Well, it's up to the attorney what they want to do with their sidebars. I have trials where the lawyers run up and do a sidebar, and then we take a break and they never put it on the record. That's not my responsibility. It's still a lawyer's responsibility, how they want to handle it.
So I want to know how the court wants to handle sidebars. Is
Well,
this something we're going to
if you had an objection and you come up and do a quick sidebar, tell me that when we go on a break, you want to put it on the record. I think that's the proper way of doing it. I don't like it when the jury has to keep going back in and out every 10 minutes. They get confused. They say, well, what are they talking about when we're not in here? So just say, I want a sidebar, come up here and tell me what you want. And then tell me, I want to put it on the record when we're not having the jury.
Judge, as to objections, does the court just want like hearsay and then we do a sidebar, or do you want speaking objections? I would ask the court to limit speaking objections, obviously, for the reason that not some of that information should always be in front of the jury.
I think objections, you do have to give me a reason, but I don't want you to start arguing in front of the jury. Okay. Give me what evidence I should not allow, hearsay or confrontation or whatever, but don't start arguing, because that's not what the jury should hear.
I think
all
number five,
rational
the court
rulings.
probably does, which is prior to the opening statements of counsel, the jury be instructed by the court as to the elements of the offense charged.
I do instruction 50, and I think the state gives me the elements that I have to read as to the charge in that number 50.
Thank you. And number 6 is the jury be given written instructions for use during deliberations on the instructions that are within this document, burden of proof, presumption of innocence, elements of the offense, and any other instructions deemed by the defense after close of evidence to be germane to the issue. And I think we could probably do that during a jury conference.
We can do that during jury instructions.
I don't think my motion in limines that I filed are anything more or less than that, honestly. I filed mine because we had a deadline and I wanted to make sure it was filed. And honestly, I hadn't gotten through everything yet. So I think the court probably ruled on all of these. The only one we have to talk about, we already talked about the book. We talked about criminal convictions. The court's fine with doing that prior to the witness testifying.
Right.
We are going to talk about the letter. I think that's in my motion in limine and the voicemail. So I think that's the motion that the court asks us to file by Friday.
I will give you a ruling then when we come back at the pretrial on the 16th.
Okay.
I wonder why they have
And then there's pretty just standard
plexiglass all around the witness stand.
I mean, they're just standard instructions like state be precluded from introducing any evidence or medical records which haven't been provided.
Maybe acoustics. I don't know. Weird.
Oh, Judge, I'm sorry.
Because nobody else is
It's
protected
the one
from
that Attorney Vichy filed.
plexiglass.
There is one
Or by
specifically
plexiglass.
as it relates to Laura Koster. There's a number of different, there's A through F to exclude evidence as it relates to Laura Koster being a witness for the prosecution of her father from 1989. It has no probative value and we're asking the court to exclude it. Judge Schroeder did not permit the state to cross on this issue and we would ask the court to
Is
rule
the
the
state
same.
going to do that or no?
Well, since Judge Schrader ruled we couldn't, we're not challenging that ruling from
All
Judge
right,
Schrader.
we answered that question.
Thank you. So these all look like they were things that were not allowed. Number in B, Judge Schrader did not allow the prosecutor to ask this question at the forfeiture by wrongdoing hearing. Does that mean the same?
Right.
Yeah, it's probably just from COVID. They tore everything else out except for that.
Thank you.
Is it ethical to take free money from the government? A lot of small businesses are grappling with this question as they learn about the ERC program.
So are there any in A through F that the prosecution disagrees with?
Yes, so the next one is C, and that one involves questioning of Laura Koster about the possibility that she withheld some information when answering questions at the forfeiture hearing. And the state just thinks it's generally true if a witness has previously testified and then in their subsequent testimony, it appears that they withheld information the first time, that the state should be allowed to inquire into that.
So she testified at the forfeiture hearing?
That's
Yeah,
right.
they
Apparently
absolutely
during
should
the
be able to do
trial,
that.
There was the implication that she had withheld information. And so the state, I think this is kind of a general principle that if the state believes based on a prior transcript that someone has withheld information, that the state should be able to inquire into that.
I think if it's an inconsistent statement, but if she wasn't asked, she couldn't have answered it. And I think there's a distinction. there.
Sounds like a great cross-examination question.
I would just
Yep.
ask the court not to allow testimony that was
I'm not going to
asked.
try the whole case. It's not a court trial. You want to waive jury?
He means bench trial. When he says
Um,
not a court trial, he means bench trial.
I think this is a hypothetical question that was asked to a citizen witness under D, and I would ask the court to exclude it.
Did we ask a hypothetical to a lay witness?
Yes, we believe that hypotheticals are allowed for lay witnesses, and we cited 907.01 for that.
What was the question? Do you remember what it
If
was?
that's the reason,
I think it was about.
and if, I'm going to stand up and applaud. What a genius solution. It's absolute bullshit.
Well, if it's in proper form, they'll be
Witnesses can wear a mask.
I'm not going to pre-try the case.
It's not because of what I think of Bass or not. It's not fair.
E is questioning Laura Coster about whether she was ever coached by the prior defense attorney to not testify about certain things at the forfeiture hearing. I think that would make it.
I'm going to go with that being the reason why and be super ecstatic about why they did that. That's awesome.
You got a comment?
So I think this is related to the one we just talked about, where if it appears that a witness was withholding information, the state should be able to inquire into that.
We will wait to see what the witness says on the stand.
Questioning Laura Coster if she had known that Mark was having an extramarital affair at the time Julie told Miss Coster she was afraid that he would kill her, and whether Miss Coster would give different advice because she allegedly knew that Mark had a motive to kill. I think that's hypothetical, and I think the
Guys, if we get through this without a verdict,
we'll wait and see.
I'm going to be stunned. I can't believe it's almost 3:00 in Fort Worth and we don't have a verdict. But if we get through this without a verdict, we'll go back and watch the closing statements from the Aaron Dean trial again.
I think the rest of the motion on limines that I filed in November of.
It's a violation of your constitutional right to face your accuser for them to wear a mask.
They're pretty standard. Not allow vouching.
In my
prohibited from
opinion.
shifting of burden.
Courts have disagreed with me.
We got anything else we need to address from the state, Ms. McNeil?
So we do have the state's motion that was filed.
Well, first of all, Your Honor, we have not addressed all the defense motions. I would commend the court's attention to the state's consolidated responses to all undecided defense motions. We filed that June 27th. As you indicated previously, I think it's like an 87-page document, but the actual response is less than that. That included attachments. But on page 16 of that,
let me get there first.
yes, that actually was the state's response to defense response.
What issue are you talking about
We're
now?
talking about the testimony that defense counsel seeks to elicit from Dr.
That's a good
Christopher
point.
Long
Maybe
about
what we're due
Patricia Stallings'
first
case.
before going back
And
to
I
closing
think Judge
arguments.
Schrader ruled there was no
Let's go listen to the
factual basis
judge's
for that testimony
jury
to come in.
instructions again.
What happened, Your Honor, at the first trial is that defense counsel
See if we can parse those
proceeded
out
to bring in the Patricia Stallings
under
case
the
without
context that
having
we're
filed
4.5
another
hours
ex
in
evidence motion in advance of
without.
trial. This necessitated the court taking a break in the middle of the trial, allowing the defense attorney to voir dire Dr. Christopher Long outside the presence of the jury. And after this extensive voir dire, Judge Schrader specifically ruled that all of this was inadmissible.
Was there another ex motion filed about the defense to bring in this Stallings case?
I think Judge Schrader ruled that the information about the Stallings case.
Judge Schrader
related
ruled
to
something
a woman
out?
being put in prison.
Knock me
and
over with a
this
feather.
mistake that was made was not allowed. But
I think I got this exact wording. It says the answer is no.
Yep.
For a variety of reasons, beginning with the fact you didn't even establish that he committed a mistake, made a mistake. No, I'm not going to argue about it. I made my ruling. I think the record's full. So
that sounds just like Judge Schroeder.
Attorney Elton to cross-examine Dr. Long about the whiting out of information on an exhibit that was presented to the jury, and the defense would like to do that again.
about you're talking about the Stallings case?
In the Stallings case, when Dr. Long testified, he whited out information on an exhibit at the request of the prosecutor, and Judge Schrader allowed that, but did not allow the other information about the Stallings case to come in.
Yep, that'll be nice.
Hey
if we
boss,
get there.
so I know you're looking to move your employees like me to work from home, but how am I supposed to bring this thing with me?
Well, I
Okay,
wasn't
everyone.
at the first trial, so.
We'll fix that.
Your Honor.
But yeah,
First
we're
of all,
definitely going to go
the
watch
defense counsel
jury
wants to
instructions
bring,
next.
wants to admit other acts evidence of Dr. Christopher Long
If we get there.
in this new trial. They're obligated to bring another acts evidence motion, and they've not done that. The state is, I'm not aware of, I do have this vague recollection about this thing about an exhibit, but I believe the defense counsel is required to bring another acts evidence motion if they want to introduce that into evidence in this trial. And the state.
Let me just stop you here. Where's the other X motion then that you were arguing?
Judge, I'm not arguing another X motion. This was the prosecutor filed a motion to exclude it, and there was a response by the defense as why it should be included.
Yeah, same thing.
It was
They brought
filed
it up.
by Attorney Vishny on July 12th of 2017.
Let's give the state a chance to look at that.
How long is he going to look?
Well, Your Honor, the state is opposed to allowing this cross-examination of Dr. Long on this issue, but I would need to go back and review the transcript of the trial on this specific issue. Could the state file a written response on that issue? When we responded to this, we were responding to the issue of cross-examining him about the Patricia Stallings case generally, and Judge Schrader excluded that. But I don't have, as I'm saying, I don't have a specific recollection of the cross-examination or the discussion on the record of this marking of an exhibit. And so I would request that I be allowed to file a written response.
Yeah, well, we could deal with it at the pretrial. Just remind me.
Thank you.
Okay, what motion does the state have that we have not decided? Did you say something, Ms. McNeil?
Yes, so that was filed on March 28th of 2022.
Okay, hang on here.
Is that just refiling
Is
of
that
the
the
number?
unavailable witnesses?
Right, it starts with 2 issues, and then it repeats what the state had filed for motions in limine. So the first issue that the state presented was just repeating what we wish the court to decide, which was the motions in limine, which are attached. The second issue is about witnesses becoming unavailable. And we filed last week, and the defense would have received our amended witness list that indicates who we believe is unavailable, either due to death or due to some health issues. And so I guess I would inquire of the defense if they had any objections to the people that the state designated as unavailable.
We got a response?
Judge, the witnesses that are deceased, we have no objection to them being unavailable. There's only one witness that I'm aware of that is not deceased, Ted Wote, and he is receiving medical Wote, W-O-J-T, I believe. And he is receiving medical treatment for a cancer diagnosis. I guess I'm unsure from the letter from the physician that he's unable to testify or that he thinks it would be difficult for him to testify.
Do we have a letter from the state, from the doctor?
There is. Yes, we submitted that to the defense counsel last week, and we can provide that to the court as well.
Why don't you provide me that letter? Right, what other state issue that I have to decide?
So there's one other person who the state indicated
This judge
was
is good.
unavailable, and that's Joan Scully. And she, I believe, has some form of dementia. So we don't believe she's capable of.
Every new business needs 4 things: a website, great SEO, digital marketing, and a strong social media.
An ad blocker
She did
pro.
testify at the prior trial, so we indicated we would like to use her testimony, even though she's not deceased.
I want to see if I can get ad
What's
blocker
the,
where it would
defense
go without
position
messing
as to
things
that?
up.
I think if there is a diagnosis of dementia, that would be make a witness unavailable. We also have a witness that we believe has a diagnosis of dementia, but we're waiting to get medical confirmation from her doctor.
Give me some kind of confirmation. That's for both sides.
Yes.
And again, if the defense wishes to present to us a stipulation or agreement, that's likely something we could agree on.
Sounds like an even trade.
Judge, how are we going to, I think that's a good question about how are we going to present this evidence to the jury? Is this going to be a reading of the transcript? Is this going
It's
to
up
be?
to the lawyers.
Okay.
I'm not trying the case.
And I think that if it is the
I'm going to see if I can
video,
get ad blocker plus right now.
recording, there is going to have
Hopefully
to
it doesn't
be
hurt our stream.
potentially some editing because of the exclusion of evidence at this point.
We would agree that there may be some portions of recorded testimony that would need to be revised or excluded. And the state's prepared to do that. What I'd propose is this, that the parties between ourselves look at the transcripts of the testimony of the witnesses that we intend to present who are no longer available. And then we'll indicate what portions of that examination we deem to be inadmissible or we object to. The parties should be able to exchange that. And if we come to an agreement, then the court won't need to be bothered with it. We'll only address to the court the issues that we can't agree to.
Sounds
That's
good.
very good advice. That's what we did in the civil trials when we had testimony from doctors. The lawyers worked it out and they agreed to what was not going to be read to the jury. And 99 out of 100 cases, they did agree to it. Okay, what do we got next, Ms. McNeil?
So our final portion of that was just, we intend to notify the parties about the use of the defendant's book by the final pretrial date in December.
And which portions of the interview transcript?
You're going to provide that information to the defense by the pretrial date, correct?
Yes, Your Honor.
And actually, regarding the interview transcript, we did file what we intended to use, and that was in, let me get the date on that.
And you're going to provide that too to the defense?
We've already provided it to them.
Already provided it, all right.
So there's a lot to dig through so that the defense knows what I'm referring to. It was on March 31st of 2017 that we filed that.
All right, it's installed. Let's see how it does.
That has not changed, and so I think we just need to confirm that we still feel the same about what should be used.
All right, what's next from the state?
So then, Judge, it's just following is the motions by the states. That's part of the same filing. We have the first 8 motions have to do with testimony that apparently was at least attempted to be elicited at the last trial regarding mental health history and some, I would say, other act type situation regarding Julie Jensen. And so the state has specifically moved to exclude this evidence from this trial, given that it was brought up at the prior trial. And so if the court wants me to go through one by one, I can do that, however the court would prefer.
Has the defense responded to that?
Judge, most of the stuff was allowed in at the first trial.
All right.
So I can tell the court which ones I don't have.
I thought we said Judge Schrader made the correct rulings.
Well, Judge, we are bringing this up because we do not think that these particular things that were questioned at the last trial were admissible as relevant. And, you know, part of the issue is a lot of this happened during cross-examination. And so it was things that the state couldn't anticipate and couldn't file a motion in limine about because we didn't know it was going to happen.
I'm not gonna
we
make
might have a
any
little
prior
better.
rulings. If it's
Yeah.
relevant, it's relevant. If it's not relevant, it's not coming in.
And Judge, I can tell the court which ones we would not attempt to do so that at least.
Would
the
that help the
prosecution
state?
knows.
It would, thank you.
All right, why don't you do that?
Number 2,
Okay.
we agree.
And if somebody can just put it in writing for me, then I have it as part of the record.
I don't know why they're giving them this. Make them sweat it.
Number 6, there's no basis for us to do that. So those are the ones we would agree to without needing further argument. I think they were attempted at cross-examination, but there was no basis, and we would not attempt to do it again.
So then I guess this motion by the state just puts everyone on notice to what the state would intend to object to when it comes up at trial.
All right.
And just so the court's clear, Attorney Vishny did respond to these motions.
All right,
so
well,
there is a response.
You got an agreement of what's coming in, and again, if it's relevant, it's coming in. Anything else from the state?
Judge is over this.
I do have one issue. If the parties want, I don't know if it's going to be an issue. Mr. Jambo, you could probably respond. Was there an issue as to the termination of Dr. Maureen Levin?
Yes, Your Honor. The defense had sought to cross-examine Dr. Mary Mainland about Dr. Lavin's termination of employment. Of course, Dr. Mainland was not here at the time that Dr. Lavin was terminated. The state believes that any testimony any information regarding Dr. Lavin's termination from employment is not relevant to this case. Dr. Lavin was the medical examiner for Kenosha County at the time this case was on December 3rd, 1998, the date that Julie was killed. But she testified at the preliminary hearing. But while preparing this case for trial, she refused to answer questions in my office about whether or not she was board certified. We knew she was not board certified. We were simply asking her questions about this, and she said she wasn't going to answer it. And I said, well, you understand that when you go into a courtroom, if you refuse to answer questions that are put to you in defiance of the judge's order, you may leave that courtroom in handcuffs, and you are required to answer questions in court. And furthermore, when you're sitting in the district attorney's office and he's asking you questions, you are obligated to answer those questions as well. And if you don't, you're going to be terminated. And she refused to answer questions about her board certification. And as a consequence, she was terminated. It had nothing to do with her opinions concerning
This case is wild.
Case. It had nothing to do with her theory of her prior testimony as to the cause or manner of death in this case. It was simply because she had not become board certified and she refused to answer that question.
So she never testified in Jensen 1, right?
No, she did not testify in the
And
trial.
Dr. Mary Mainland testified?
Yes, Your Honor.
And she was obviously the medical examiner for Kenosha County at the time, or from another county?
She was our medical examiner at the time of the Jensen trial.
So what would she know about the termination of Dr. Levin?
Well, as she indicated, she really didn't know that much about it. And she had heard things about it, but she wasn't here at the time that Dr. Levin had been terminated. I think what the defense counsel was trying to elicit from Dr. Mainland was that she was intimidated into rendering these opinions by the district attorney because the district attorney...
And that was you?
Yes, because the district attorney had gotten the previous medical examiner terminated. But she was not terminated because she refused to agree with the prosecutor's theory of the case. In fact, the prosecutor's theory of the case has always come from the medical examiners. It's not the other way around. But she was terminated because she refused to answer questions pertaining to whether or not she was board certified. It has nothing to do with the development of the evidence in this case. So it's completely...
Did we ever find out if she was certified or not?
She was not board certified. That's why she refused to answer the questions.
But Judge, I think the concern is that as it relates to the cross-examination of Dr. Mainland testified that she was aware of some of this information, maybe not everything that Attorney Jamboy said, because she wouldn't have had that information unless Attorney Jamboy told her that information. But she was aware that there was an issue as it related to the Jensen case and her findings that caused Dr. Mainland was aware that there were issues with Dr. Lavin and her findings in the Jensen case, or her testimony in the Jensen case, that caused her to be terminated from her employment.
Did she testify to that in front of Judge Schrader?
She testified that she was aware that Dr. Lavin was terminated.
While you're looking at those other transcripts, see what she said in Jensen.
Well, Your Honor, I can tell you this. The whole theory of the cross-examination of Dr. Mainland was to suggest, plant in the jury's mind, that Dr. Mainland was somehow intimidated by the prosecutor into rendering the opinions that she rendered in this case.
Sounds like fair game to me.
Said there was nothing about Dr. Lavin's testimony.
That's what I'm saying. Get the transcript and let me take a look at it.
Okay.
So remind me, that's another issue for the pretrial.
Pretrial.
All right. I'll ask the state. We got anything left?
So I think there's one other.
There's still a lot left, Judge.
So this would be this letter.
Oh, yes. The state had filed a motion to prohibit the defendant from introducing evidence concerning, in fact, introducing the letter that I had written on June 18th, 2003, and sent to defense attorney Craig Elby. The state objected to it as it being irrelevant.
So the judge wants to look at the transcript from the original trial and see if she testified to that she thought she was or not.
And the state will then address that. And
but to me, that's bringing up reasonable doubt and probably should be allowed in.
The document is document number 1487, and it was filed March 28, 2022.
Get to that document 1487.
Yes, Your Honor.
For the record, right now there's 1,515 documents.
Judge, this is something that was specifically ruled on by Judge Schrader.
This judge is
What he
not
said is he
liking
was going
all
to
of
allow
the
letter to come
discovery
in
and such
through
in
the
this
expert.
case.
Otherwise, basically, Attorney Jamboy would be a witness in the case because it's a prior inconsistent statement.
And Your Honor,
What expert are we talking about?
Dr. Long.
Well, how would Dr. Long be in a position to testify about a letter that the prosecutor wrote to Craig Elby? There's no foundation for Dr. Long to be testifying about that letter.
So let me just stop you. Did he use the letter at any time to form any opinion?
Dr. Long?
Yes.
He never saw the letter, Your Honor.
The letter was a specific statement by Attorney Jamboy as to what Dr. Long was going to testify to at the trial.
Okay.
Dr. Long did not testify consistent with that letter, making the letter from Attorney Jamboy to Attorney Elby an inconsistent statement of a party opponent. This was argued at great length before Judge Schrader, and Judge Schrader ruled that it was an inconsistent statement and the letter could be used. And he basically said that he was going to allow the letter in so that Attorney Jamboy himself would not be a witness, because otherwise Attorney Jamboy would have to testify as to the prior inconsistent statement, which would make him a witness in the case. So instead of making Attorney Jamboy a witness, Judge Schrader allowed the letter in as cross-examination of Dr. Long.
And the state opposed that at the time, Your Honor, and none of the criteria that apply to the admission of prior statements by prosecutors, none of those criteria were met in that case. But
Jamboy conceded that some of those were met.
Well, I concede, Your Honor, that I wrote the letter and that the letter was in error, that I wrote that letter, that I committed an error when I wrote that letter. Then let me finish, counsel. Then
finally we have some
at the time of the
fireworks
forfeiture hearing, Dr. Long did not testify in a manner which was consistent with the content of my letter. At the time of the trial, he did not testify in a manner which was consistent with that letter. So the fact that the prosecutor made a mistake in, what was it, March of 2003, I'm sorry, June of 2003, is not relevant, was not relevant at the time of this trial in January and February of 2008, and it's even less relevant now. So the error that I'd made in that letter was based upon a letter that Dr. Long had written, and that the state agrees that Dr. Long's letter is admissible. Dr. Long's letter made reference to the content, the amount of ethylene glycol in Julie's blood and Julie's stomach, and he described the ethylene glycol in her stomach as a large amount when it turns out it's a half a teaspoon of ethylene glycol in her stomach. That was discovered when the defense attorney filed their expert witness report, Dr. Rumack's report. So this was all resolved months, years in fact, in advance of the 2008 trial. And allowing Dr. Long to testify about this letter that I wrote in 2003 does not address the issue of it makes me a witness in the case. And I don't wish to be a witness in this case because I'm prosecuting the case along with Deputy District Attorney McNeil. So I don't think that this letter is admissible, and it doesn't fit any of the criteria for admission. It is a statement by the prosecutor, but it was never made in a courtroom. It was never made in an opening statement. It was never made in a closing argument. It was made in a letter to a defense attorney months in advance, in fact, years in advance of the case going to trial. It's just not relevant. It has nothing to do with the facts of this case today.
I'll give you a brief response from the public defender.
So, Judge, specifically the three things that the Judge Schrader considered were the law in State v. Cardenas-Hernandez, Cardenas-Hernandez, 219 Wisconsin 2nd 516. Judge Schrader found that it was an inconsistent statement because it went from a very large quantity of almost pure ethylene glycol in the stomach, which is what Attorney Jamboy wrote in his letter as an agent of the state, to just a large amount of ethylene glycol. So there is a difference between pure amount of ethylene glycol in the stomach to 660 milliliters to a half a teaspoon, which is what Dr. Long later testifies to. So Attorney Jamboy agreed that it was an inconsistent statement in his arguments before the court, and Judge Schrader found it was an inconsistent statement. It's equivalent testimony of something that of a defendant or a witness. Judge Schrader found it holds true that it seems to me that Mr. Elby has the right to argue to the jury that there's a circumstantial case tending to show that Dr. Long gave some faulty information, which would tend to raise doubts about the accuracy of some of the reports in this case. That was number two. Third, the trial court must, in a hearing outside the presence of a jury, determine by a preponderance of the evidence that the inference the prosecution seeks to draw, in this case, the defense seeks to draw from the inconsistency, is a fair one, and that an innocent explanation does not exist. Judge Schrader stated, "It strikes me that this isn't a question of an innocent explanation or anything. This is a suggestion that there exists various circumstances consisting of your letter and Dr. Lavin's testimony," because Dr. Lavin also relied upon this information from Dr. Long. "At preliminary examination, there are circumstances which might suggest to the jury," and I'm not saying that I conclude this or I believe this, but the defense would be entitled to argue to the jury that the circumstances suggest that perhaps Dr. Long was a little careless in things that were stated to the people, and that strikes me that that would meet all three tests. Judge Schrader further found that crossing Dr. Long on the letter, literally it is a substitute for calling Mr. Jamboy as a witness, which you can't realistically do in this case, and so I won't even comment on the third. So my ruling is the letter could be presented as a statement against interest by the government.
Did the letter then come into evidence, and was it used when the defense cross-examined Dr. Long?
Yes.
All right. Give me the transcript portion again, and I'll make a ruling
Sure.
at the pretrial.
It was filed January 10th, 2012, page 284. I'm sorry, it's document 27-4. I've got some different pages in here. Sorry, Judge.
When was it filed?
Oh, that's why that's long thing down there. Okay. It's the January 16th, 08. Page 289, 276 to 289. It was Dr. Long's testimony transcript, January 16th, 2008. Oh, man, I do. Hold on one second, Judge. There's too many documents. thought Attorney Vishney had it in hers. Transcript 216, it's the January 16th, 2008, transcript 216. You're asking for the number on the exhibit list?
Yes.
I know it was attached as an exhibit to her response.
I was thinking the same
Maybe
thing on this.
document
Like,
27-3, Judge?
Want to give me the number again?
wouldn't any
Maybe not. I'm
be
going to have to, I
a
have
huge
a number
issue?
of different
But it
transcripts
sounds
because
like the
some were
state's
attached
not
to the
making
appellate
that
briefs.
argument. So
This is from his testimony, though. I don't know, this goes to 145, but I think it's this. From the transcript, 27-3. I don't know what e-file number it is, Judge.
All right, why don't you just,
Find it.
if you can contact the court and make sure the DA is part of that. So there's no ex parte communication.
Your Honor, why don't I do this? Well, we'll pull up the two exhibits. One is Dr. Long's letter, and which the state agrees that Dr. Long can be cross-examined or examined and direct cross-examined about the letter that he wrote. And then we'll pull up my letter that, and we'll mark that as an exhibit that we produce, that we provide to the court. The state's response is that my letter of June of 2003 was based upon my misunderstanding arising from Dr. Long's letter. So the state agrees that Dr. Long can be cross-examined about the letter that he wrote to the state concerning the circumstances surrounding Julie Jensen's death. And in that letter, he indicated that there was a large, I think he said a large amount or a large concentration of ethylene glycol in the stomach. It was something like 3,200 micrograms per deciliter, maybe 3,280 micrograms per deciliter in her stomach. The state agrees that Dr. Long can be cross-examined about his letter. The state objects to Dr. Long being cross-examined about my letter to defense counsel because Dr. Long never saw that letter. He had nothing to do with writing that letter.
we already got that, and
That
Schroeder
letter was
already
my
ruled
letter,
on that.
and I don't wish to be a witness in this case. And I don't think that the kind of what Judge Schrader did at that time reflects the correct application of the law to the facts. Now, the state had not known that defense counsel was going to be seeking to admit my letter into evidence until defense counsel started cross-examining Dr. Long about it. So this objection and the court discussion all occurred kind of
A very cynical view on that
and there was
would
not
be
the
because
opportunity
they didn't want that
for
letter to
the
come in.
trial court to address this.
I
in
think it's
advance
more
of
that
trial.
this
Well, now you will be given that
prosecutor is
chance.
still prosecuting and
So
wants to see this
I
case
would
through.
Commend to the court's attention the letter that was written by Dr. Long, my letter that was then written to.
Just provide that to me prior to the pre-trial.
And I wish to
Both
emphasize,
letters.
Your Honor, that Dr. Long testified extensively about his letter, and I was cross-examined extensively about his letter, and the state has no objection to that. I just object to my letter coming into evidence.
Give me both letters. You give me the transcript. I'll make a decision.
And Judge, just to be clear, like the letter that Dr. Long wrote, there's no question about that. That's his letter. But what the argument was, and Judge Schrader took the time to listen to this, is a statement of a party opponent. So if we can't cross-examine Dr. Long on the letter itself, we have to bring in the witness who took the inconsistent statement, and that's Attorney Jamboy.
All right.
I think Schroeder.
All right.
I think Schroeder's way of handling this was actually pretty genius.
Hopefully the answer is nothing. Yeah.
Because you don't want to force the prosecutor to be a witness and kick him off his case. But you still want the defense to be able to get the exhibits in.
We got a no from the state.
Schroeder seems like he was
We got a
smart
no
on
from
that.
the defense.
Judge, much. I believe, except for the outstanding issues, we've covered everything.
All right, remember, we need a written order for everything that was decided today. I've given you briefing times. I want the
So what else happens
transcripts
for
and the
20
letters
minutes?
to make the decision. We do have a final pretrial. I believe it is
Schroeder was smart back then.
December 16th. We do have a speedy trial now that's been filed. We are within the timeframes for that speedy trial, for the record. Anything else from the state before we adjourn?
We'll just put on the record the state's requesting a transcript of this hearing because we want to make sure that the order reflects the court's ruling. So we'd request a transcript. We'll prepare the order shortly after we get the transcript.
Anything else from the defense?
Judge, how long did we put aside for the final pretrial?
That's a good question. Let me open up my
Pre-trial.
calendar here. You guys got 45 minutes on the calendar. We can go longer if we
We're going
need.
to need much longer than that, Your Honor. And considering the number of issues that are going to be addressed, I mean, even the issues, just the transcripts of the testimony.
Choose your words carefully.
We'll try to, the parties will try to resolve those issues among ourselves. But I anticipate there are going to be some areas where we disagree.
We'll give you as much time as needed.
Is that at 8:30, Judge?
Yeah, 8:30.
That's what I have on my calendar. I just want to make
Yeah.
sure that that's correct.
All right.
Hey,
We're
remember they
recessed.
only
Thank
ended up.
you. Have a good day.
They only ended up needing 30 minutes.
What happened to our other case? Did they leave?
All right, I'm gonna switch headphones again, and let's go re-listen to let's go re-listen to the jury instructions for the penalty phase of our trial. It's gonna take me a minute to find that. But yeah, this Mark Jensen case, I'm getting way more excited about it. It sounds like we got, whoa, this camera sucks. How about, yeah, someday I'm going to get a studio. All right, stay there. All right, we're good. This Mark Jensen case sounds fun. Sounds like there's even a little bit of sex in it. All right, let me see if there's any updates. You watching? Yep, we're still just awaiting sentencing verdict. I don't see any big updates. Let me switch headsets real quick, and then we'll come back up with the jury instructions one more time. See if we can get this right. This does not want to work right now. Come on, buddy Opel. All right, that's the best we're going to be able to do. All right, let's find this.
Okay. He read jury instructions first, right? Yeah, he did. So it shouldn't be hard to find. Hey, thanks for the ad blocker suggestion, by the way. That seems to be helping. Now I just need to get this up. Sorry, y'all. Oh, God. Okay, here we go.
Retaliate because some of their family members had been unlawfully killed.
That didn't work. Okay, I'm going to try to find this somewhere else. Sorry. Oh, here we go. One more time. Here we go. So let's watch the jury instructions. And you know what? Yeah, let's watch the jury instructions, and then I want to watch the. No, let's actually just watch this whole thing again, the jury instructions, and then into their arguments again, just to see if we kind of missed anything, what the jury could be hung up on.
Made out of a glass shank during Capitol Board Hour at one point. Metal detectors only do certain things. Mr. Mata sat within.
Okay, we don't need to hear these arguments again, though.
And why is Liz Turner?
And I'm gonna hit pause on some of this so we can make sure we talk about what's. Is that super loud?
Everyone may be seated. Good morning. Members of the jury, the defendant Aaron York Dean has been found guilty by you of the offense of manslaughter. Therefore, it now becomes your duty to determine the punishment to be assessed against the defendant. The punishment for the offense of manslaughter is by confinement in the Texas Department of Criminal Justice for any term of not more than 20 years or less than 2 years. In addition, a fine not to exceed $10,000 may be imposed. You are in.
Okay, so starting off, we were right. It's 2 to 20 and a fine of $10,000. Now let's see if we can figure out how probation works into that.
Instructed that in determining the defendant's punishment, you may take into consideration all of the facts shown by the evidence admitted before you in the full trial of this case and the law as submitted to you in this charge. In this case, the defendant has filed before trial his sworn motion in which he requests that if he is convicted, he be placed on community supervision. If you find that the defendant has not ever been convicted of a felony in this or any other state, and you assess the punishment of the defendant at confinement for a term of not more than 10 years, and you recommend that he be placed on community supervision, then let your verdict show the punishment which you assess.
I feel like I still missed that. I'm going back one time. I'm sorry, there's a little background noise in my house, but I'm going to leave mute off because I want to hit on it.
And additionally, the state had furnished to the court a list of his convictions, his pending cases. There are multiple convictions for assault, There are
Wait,
4
what happened?
pending cases for interference with public duties. And when I saw him come into the courtroom.
Oh,
and
I went
sit-
back too far on that guy. Sorry. Bad job. All right, I'm going to be
Judge
super on the
shall
pause button.
determine the conditions of community supervision and may at any
Let's watch it one more time. Sorry. Brittany says it makes 0 sense, so let's see if we can make any sense out of it.
Everyone may be seated. Good morning. Members of the jury, the defendant Aaron York Dean has been found guilty by you of the offense of manslaughter. Therefore, it now becomes your duty to determine the punishment to be assessed against the defendant. The punishment for the offense of manslaughter is by confinement in the Texas Department of Criminal Justice for any term of not more than 20 years or less than 2 years. In addition, a fine not to exceed $10,000 may be imposed. You are instructed that in determining the defendant's punishment, you may take into consideration all of the facts shown by the evidence admitted before you in the full trial of this case and the law as submitted to you in this charge. In this case, the defendant has filed before trial his sworn motion in which he requests that if he is convicted, he be placed on community supervision. If you find that the defendant has not ever been convicted of a felony in this or any other state, and you assess the punishment of the defendant at confinement for a term of not more than 10 years, and you recommend that he be placed on community supervision, then let your verdict show the punishment which you assess, and further show that you recommend that his sentence be suspended and that he be placed on community supervision.
Okay, this does make perfect sense. Okay, so here's what's happening. The prison term has to be 2 to 20 years. Or the sentence has to be 2 to 20 years for his offense. Being that he's never been convicted before, he has probably what they call, like in Louisiana, I know what they call it, first-time offender, or first offender. What that means is that you can be put on community supervision. So let's say they gave him 5 years. They can say, okay, we're giving you 5 years in prison, but for those 5 years, that sentence is suspended and you're on probation. The judge is then in charge of the probation and the term. However, if the defendant violates probation, and here sign a contract as to anything and everything that could be a probation violation, then he can be sentenced to that underlying prison time. And let's say it a little stronger. If he violates probation, he'll be sentenced to that underlying. He'll have to serve the underlying prison time that the jury sentenced him to. So we see this all the time. We see suspended sentences all the time. First-time drug offenders, second-time drug offenders are usually on suspended sentences. Now, the other thing that the judge was saying there, though, is he is only eligible for this suspended time if, one, we talked about if he is first-time offender, which he is. 2, if the sentence is less than 10 years. So if the jury gives him 11 years, he's got to serve prison. And then he'll probably be eligible for parole before 11 years. And he'll be able to be on community supervision as a parolee, opposed to as a probationer. What are questions we have here? So if he has no prior convictions of felony, he gets what time? He can get whatever time. He could still get 20 years. And the jury could say, well, and if he gets 20 years, the jury can't even give him probation. But if he say the jury gives him 9 years, the jury can also decide to suspend that sentence and have him on probation. Suspended sentences doesn't mean it goes away. You mess up on probation, you're going to prison for that term. And we see this all the time. This is a very normal thing. I've just never seen it done via a jury verdict. But he's a first-time offender, so it makes sense. Like, any judge would have the option to give him this if they were making the sentence. I think he could have made it more clear. Oh, no, not that one. I think he definitely could have made that more clear. And that's why it's taking so long. Yep, you're right. All right, so let's keep listening and see if we get any more good tidbits out of this. And let's listen to the jury forms and see how confusing they may be or not.
If you recommend that the defendant be placed on community supervision, the judge shall determine the conditions of community supervision and may, at any time during the period of community supervision, alter or modify the conditions. The judge may impose any reasonable condition that is designed to protect or restore the community, protect or restore the victim, or punish, rehabilitate, or reform the defendant. You may not recommend that part of the period of confinement be served by incarceration and part by community supervision.
That is what was confusing the hell out of me. Because sometimes, so what a judge can do, and we see this a lot, is a judge will say, all right, I'm sentencing, so let's say a defendant, first-time offender, gets busted for an aggravated assault. And the sentence on that is anywhere from 1 to 5 years. And through the whole trial process, that defendant has been incarcerated in the county jail for, I don't know, a year and a half, waiting to go to trial. A lot of times what we see a judge do, say, okay, I'm sentencing you to 364 days, giving you credit for time served, and I'm sentencing you to 4 years, with 3 years of those suspended, meaning you have to serve a year, and then you're on probation for the rest of that time. I don't know if it's just on manslaughter charges or if it's because it's a jury making the decision. What the judge is saying here is the jury can't say, okay, you're going to spend a year in jail and then be on probation for 4 years. It's not up to them to do that. They either they sentence the prison time and then they decide to suspend it for probation or not.
Should the punishment assessed by you include a fine?
Because it's different than what
a recommendation of community supervision should state whether or not the fine will be paid or be suspended and probated. Whether you do or do not recommend community supervision for the defendant is a matter that rests within the sound discretion of the jury. However, if you do recommend community supervision, the court is required by law to follow the jury's recommendations. Our law provides a defendant may testify in his own behalf if he elects to do so. This, however, is a privilege according to the defendant, and in the event he does not testify, that fact cannot be taken as a circumstance against him. In this portion of the case, the defendant has not testified, and you are instructed that you cannot and must not refer or allude to this fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against the defendant. The length of time for which a defendant is imprisoned may be reduced by the award of parole. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed. If the defendant is sentenced to a term of less than 4 years, the defendant must serve at least 2 years before the defendant is eligible for parole.
So that's the parole.
Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant if sentenced to a term of imprisonment, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant.
And really, they should never decide how a parole law would be applied to the defendant, because parole's really determined. It's not determined by your crime. It's almost completely. There's a little bit of consideration to your crime, but a huge weight goes to your behavior in prison.
Your verdict must be by a unanimous vote of all members of the jury. In deliberating on this case, you shall consider this charge as a whole, and you must not refer or discuss any matters not in evidence before you. If you need to communicate with me during your deliberations, the presiding juror should write the message, ring the jury call button on the wall, and give it to the bailiff. I will either reply in writing or bring you back into the court to answer your message. You are the exclusive judges of the facts proved of the credibility of the witnesses and the weight to be given to the testimony, but you're bound to receive the law from the court which is herein given and be governed thereby. And I've signed these instructions as judge. The last 2 pages of the instruction contain the respective verdict form.
All right, so let's pay attention.
The first verdict form says community supervision not recommended. We, the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for, and there is a blank, for the presiding jurors to fill in the number of years that the jury agrees to. In addition, we do or we do not, and the presiding juror will circle that phrase, assess a fine in the amount of blank. So if you assess a fine, circle we do assess a fine.
Okay, so this sounds like it is a little more straightforward than I thought. The first verdict form is no probation. We're giving them straight years. And then the second form is really, we're giving them straight probation. There's no in between here. He either gets probation and then the jury assigns how many years he would go to jail or go to prison if he violates that. Or they just say, hey, you're going to prison for this long. That's really their only 2 options. Now let's look at it another way. The jury could be saying, okay, here's how many years we think he should get. And then they may be arguing about, okay, do we suspend that sentence or not? And that's how judges normally do it. Judges will normally set what they think you should get, like set what the underlying prison term should be, and then decide if they're going to suspend that and give you one chance, so to speak. I think probation in these cases is kind of weird, because probation is designed to see if you're going to mess up again or not, and probation and it's to monitor like longer term criminals that are committing smaller crimes. But it's also kind of like, okay, you're probably not going to mess up again. We're monitoring to make sure you don't, and you don't, you're going to stay out. What does Paul say? I think you should get probation. Yeah. So Paul, you kind of just made that second argument that I made there.
If you don't assess a fine, circle that. We do not recommend community supervision, and there's a space for the presiding juror to sign on that form. The second verdict form is on the last page, and it recommends community supervision. So in that situation, the presiding juror will fill in the number of years that you assess between 2 and 10. Again, you can assess a fine or don't have to assess a fine. If you do assess a fine and you're recommending community supervision, there's a third blank for the presiding juror to certify whether you want the fine that you assessed be paid or that it be suspended and placed on probation. Ms. Diener.
I do too.
I need the lights, Brian.
And like, let's be honest, like both of what's been going on
Please
here.
support.
Yes, ma'am.
Atatiana's family
And these arguments were quick.
They
And this
received
jury is clearly
their
not coming up with anything
life
fast. So
sentence
let's watch them, and then we'll
on
go to
October the
the
12th, 2019.
closing arguments and the guilt phase.
They received their life sentence without her. They'll never get her back. As we approach the Christmas holiday and the end of this year, we think about those that we love. We grieve for those that we've lost. And for them, that's sadness.
I'm going to take my video down
Grief.
for like literally 30 seconds.
There's
I'll be right
multiple
back, folks. I
stages when
promise
you
I'm
go
not leaving.
through the loss of someone
The
close
stream
to
will
you.
stay up.
For those of us that have gone through that, we know what that's like. A few years can pass, and yet it feels like just yesterday that they were here. You heard Adarius testify. You heard Ashley testify. For Ashley, for Amber, for Adarius, for Zion, their whole lifetime will be without her. There's a part of grief that we all suffer when we get to a certain point. When we think about that person, there's a realization for us all. It's the finality of it.
Damn it.
Right? In your heart, you miss them, you love them, and then you really realize they're never coming back. And that's the hardest part. And that's worth something. And in this case, it is worth something. Her life is worth so much more than a probation sentence. So much more. This family, her memory, her legacy, this community deserves more. In punishment, we brought you multiple witnesses, and those were witnesses we were not able to bring you in the guilt innocence portion. You heard from Dr. Kyle Clayton, the forensic psychologist, and this is an expert that both sides call. He testifies and works for the defense, he testifies and works for the state. Whoever calls him, he does good work, and he testifies to whatever he finds. He was hired by the Fort Worth Police Department, as he's been with many other agencies, to do a pre-employment psychological evaluation. Narcissistic, grandiosity, has grandiose tendencies, domineering, over-controlling, forceful, dominant personality traits, uncritical of himself, denies flaws, minimizes behavior, little tolerance for disagreement, can be aggressive, has an unrealistic view of himself, someone that thinks that he can fly all of us in a commercial airline despite never having an hour of training. Someone that when you're asked to rank yourself, 9 out of 10. Not suitable for a position as a police officer. Psychologically speaking, he is not suitable because these tendencies that are well formed, ingrained, a thread throughout his entire personality, these are unchanged traits that put himself and others at risk. It is like a roadmap back in 2017 to how we ended up here and how we lost Atatiana back in October of 2019. These things don't change. And how do you know that even in the 3 years between the time that that was done and today? Because last week, the defendant testified. I think he did a pretty good job out there. You shot a woman in her own home. You disregarded every single standard operating procedural, general order, and just pure reasonable human instinct. And a 28-year-old woman died, and you give yourself a fine job. You give yourself a B. This is not somebody that thinks he has done anything wrong. When the defense counsel gets up here, they're going to talk about the witnesses that they called. And those witnesses are not witnesses that you could hear from until now, till punishment. You heard from us, Dr. Clayton. You heard from us, Adarius Carr. You heard from us, Liz Turner. And why is Liz Turner important? Because we wanted to show you everything that we knew about him. And it's important to know, going all the way back to college, that's the way that he treats people. He's entitled, he's arrogant, he's aggressive. And that was 20 years ago, and she was talking to you from a place going right back there. She remembers that. She got emotional.
She really did.
It's hard for her. Because that's who he is.
You do 7 minutes, Ms. Duke.
Thank you. So when he gets up here, when the defense counsel gets up here and talks to you about why you should give him probation, because that's what they're going to do. They're going to get up here in a minute and they're going to ask you for a very low sentence or probation. They're going to ask you for mercy. Mercy's been shown already for this defendant when your verdict was returned for manslaughter. Mercy is earned. It is not just given. And I want you to listen to why they're asking you for a low sentence or probation. Because his family got up here and said he was a good guy. Every case that I prosecute, there's a family member that gets up there and says you're a good guy. It's part of the deal. But I think it's important to think about the witnesses that we didn't hear from. Just as much as the ones that we did, right? Family members. We heard from one field training officer, just one single Fort Worth officer that said, I knew him for about 3 or 4 weeks. Didn't have very good personal skills.
Hey, we have a little bit of
Kept
breaking
up.
news
I don't know
here.
anything about this case.
So
don't
about
you
an
know
hour and a half ago, the
The
jurors
Fort Worth Police Department and all
asked
those
for,
guys and girls that work for him, 18 months side by side with
video.
him, almost 2 years.
For
Don't
the
you
Fort
know
Worth
if they had
PD
something
general
good
orders.
to say, they would have been in here? There would have been a line out the door. And don't you know
We're right at 6
that
hours.
those 3
An
psychologists
hour and a half ago, nobody knew this until like 2
gave
minutes
him a
ago,
passing
but
score?
an hour and a half ago, they asked for
they
the
had
body
something
cam,
good to say, if they
video,
disagreed with
and
Kyle
the
Clayton, don't you know they'd been in
general
here
orders.
saying that? They would. Guarantee you they would. But instead, we have a family, which they're good people. This is not their fault. This is not their fault. But valuing them or him over her is a tragedy. It is not right. It is not just. In this case, the only appropriate verdict is the maximum sentence. It's the only thing that's appropriate. And when the judge talked to you about the court's charge, I want y'all to think about, and y'all don't have copies with you, but you'll be able to go back and read this. When you go to this certain page, I want to ask you, do you feel comfortable with the fact that the judge gets to set the terms of probation? He gets to get off. If he wants to get off early, judge sets the terms. You heard from the probation officer talk about probation and how it is. It is no different than what all of us do every day. That is not enough. That's not even a slap on the wrist. You heard that this defendant has been out on bond for the last 3 years with his family, laughing, doing projects with them, something that they don't get to ever do. They don't get to ever do that. Doing probation values that over them, and that is not okay. The other thing that's talked about in the court's charge is a fine. I can always get questions about the fine. If you want to put an exclamation point on your verdict, then you put a fine. It doesn't go directly to the family. It goes to a fund. So you put a fine as an exclamation point. When you think about this case, you all leave here today. They go home without her. Zion never gets to have Aunt Tay again. It doesn't matter if it's a year from now, 5 years from now. People are going to ask Zion what happened to Aunt Tay. What happened to say that they found him guilty? They're also going to ask another extremely important question. What did they do? What do you want Zion's answer to be? The only just verdict is 20 years. Anything less is a travesty of justice.
Mr. Gill.
Morning. Having an entire weekend to think about what remarks I was going to make here this morning is a long
Let's
time.
remember, let's see if we still think this was
I
just as
guarantee you
bad
I went over this
as we did this morning.
matter in my mind 100 times or more about what I was going to say this morning. I've been up here for 30 seconds now, and I already know it's going to come out in a different way. Your verdict at the first phase of the trial is important to note. It's important to note what was said by the state of Texas, because if you take the emotion out of their remarks, there's really very little left. They want you to base your verdict on emotion. You know, the family's not going to get to see Atatiana anymore. We know that. It's a tragedy. We've acknowledged that. We've talked to you about that. There is no changing that. Your verdict won't change that. It can't change that. You were talked to at the jury selection phase of this trial about whether or not you could give fair consideration to the idea of probation, to assessing a probation for someone that's been convicted of the offense of manslaughter. And each and every one of you said you could give fair consideration to that concept. And that presupposes that someone's life has been taken. And it presupposes that that person isn't going to be with us anymore, that their family's going to miss them. It presupposes there's been a tragedy overlaid over the facts of the case, which is exactly what we have here. A tragedy that'll never be changed. And the prosecutors were very defensive about the fact that we were going to ask you for probation in this case. That's because they know that that's really what this case is worth. But they want you to do something else. So
I don't know if I like what that case is worth.
You found that Aaron did not act intentionally. You
I
found
think he
that
should have
did
said
not
what's
act
appropriate.
knowingly. You found that he did not intend for there to be a death resulting from his actions. Your verdict said you felt he acted recklessly, which is a much lower culpable state of mind than intentional or knowing.
This is a good
from
argument.
the facts of the case that this case was not premeditated. There was no malice involved. There was no forethought involved. Remember the state stressing to you during closing arguments how fast this matter happened? That is a very important fact for you to consider in your deliberations at this phase of the trial. How quickly that decision had to be made. Aaron Dean is literally being judged for a second of his life today. And he's being judged under man's law, not God's law. The talk about eye for an eye, I'm not sure exactly what that was meant to convey to you during questioning of our witnesses, but we're not here about God's law. We're here about man's law. And the man's law is contained in the court's charge that Judge Gallagher gave you. We're not here about money damages. That's for the civil court down the street. And you heard that there's a matter pending down there regarding this. This is about what is a fair and just verdict under the facts of this case and this case alone. What is the fair thing to do here? It's not a weighing or a balancing contest between the Carr family and the Dean family. It's not who's worth more. The judge doesn't tell you that in the court's charge. It's about what is the fair and just thing to do under the facts of this case. On the questionnaire that you filled out before trial, asking you about the three goals of punishment in the criminal justice system. Those three goals are the three purposes of punishment are punishment itself, rehabilitation, and deterrence. Those are the three things that you are to consider as jurors in a case. You were asked which of those is more important to you, punishment, rehabilitation, or deterrence. And the answers from the group of you vary. But if you are talking about punishment, what is he being punished for?
This is all still good argument.
There was a life lost.
We're just moments away from him going off the rails, though.
But Aaron was working in the line of duty as a police officer, as a law enforcement officer. He didn't take it upon himself to go hunt someone down that had wronged him before, or knowingly place someone in a dangerous situation waiting for him to spring a trap on them. He was trained by the Fort Worth Police Department. He was hired by the Fort Worth Police Department. He was assigned by the Fort Worth Police Department. He was dispatched out there that night in the line of duty. And his testimony to you was that he was protecting himself and his partner. So what are we going to punish him for? Yes, there was a life taken. That's true. But look at how these things happen. Look at the chain of events that set it all up. What is he culpable for? He didn't plan this thing. He didn't set out that night. He didn't get up that morning and go down to the headquarters and get his assignment with anything like this in mind. He was trained in the Fort Worth Police Department Academy to eliminate a threat. So keep that in mind, please. Secondly, rehabilitation. What are we going to rehabilitate Aaron from? You've heard by your verdict, he'll never be a police officer again. This situation is never going to repeat itself. He'll have to move on and find some other form of employment, which he's done as best he can. He's probably the person least in need of rehabilitation that's ever sat in a defendant's chair. Because he's a God-fearing, law-abiding citizen of our county. Yeah, Dr. Clayton came in here and said he was narcissistic, and you saw all those things. placed on the board. Dr. Clayton had a very isolated opinion about Aaron Dean. 3 other psychologists disagreed with him. He was hired by the Fort Worth Police Department. Dr. Clayton didn't follow Aaron around the church. He didn't follow Aaron around in the choir. He didn't follow Aaron around in engineering school while he was getting a physics degree. Dr. Clayton said, he could fly a commercial airliner. At least that's how I took it, which tells you the subjectivity of the discipline of psychology. Dr. Clayton had a very isolated opinion of Aaron Dean. Look at the opinion of the people that know him best. Of course his family's going to testify. That's who he spends most of his time around. He's a family man. He's very involved with his family. Is that wrong? The prosecutor tried to make it seem like that's wrong to be a family man, to be around your family, to be in church with your family. It's not wrong. That's not a bad trait that Aaron has. That's a good trait. He had an isolated incident as a late teenager in college. You heard that Aaron was homeschooled. You heard that the purpose of the homeschool club was to help people socially adapt to college and the college environment. Is Aaron going to be judged for one isolated instance in his youth? An incident, no doubt, he is deeply embarrassed about, and has been since that day. A teenager.
So I didn't catch the state talking about it the first time. They did a little bit, but he spent way too much time on this.
If there had been anything else in his background, they could have brought it to you. There are 190 prosecutors and 60-some investigators in that office could have brought it to you. You didn't hear about anything like that. They could have brought you police officers. If he had messed up anything in training, they could have brought those officers to you, and they didn't.
Oh, I hate this argument. You should have brought officers to say how good he was.
Came to testify because
and you could have too,
he
bro.
and Aaron developed a friendship while they were riding around that squad car together. A friendship that they've carried on after this event. Detective Dugan told you Aaron was devastated, as you would expect a Christian man to be over the situation. Deterrence? What about deterrence? One thing prosecutors like to argue at the punishment phase of a trial is that the jury has to send a message. You've got to send a message to the community. You've got to send a message that this type of thing isn't tolerated.
I didn't hear the prosecution say that at all either.
You have to be very, very careful of the message that your verdict sends. Because in addition to the folks here in this courtroom, this case is being followed region-wide. And the police officers that have been here and the police officers that are watching need to know that when they leave, and their families need to know, that when they leave for work in the morning, that they can follow their training and they can defend themselves. Your verdict must walk a very fine line between what you believe Aaron Dean did and what other police officers in the same or similar circumstance might do. Because This situation, this exact situation,
I like this argument.
extremely isolated event.
I can't remember when he goes off the rails because I was way madder at him
It's a one-of-a-kind
earlier this
fact
morning.
scenario. And your message needs to be tailored. If there is a message, it needs to be tailored to this event. Because the policing, the training, the methods involved, those are out of Aaron's control. You heard Judge Gallagher's in charge of the probations in this court. Judge Gallagher's in charge of the terms and conditions. And you can trust Judge Gallagher to make sure that this matter is followed up on. And make sure that he knows everything that there is to know about what's going on with this probation. And Judge Gallagher can tailor the terms and conditions. He could take and put Aaron in jail for the weekend on the anniversary of this event, so that Aaron never forgets, which he won't anyway. Judge Gallagher could order Aaron to sit down with administration from the Fort Worth Police Department, any other regional police training academies, and help them develop training curriculums so this situation never repeats itself. Aaron Dean can be an asset to law enforcement. And he can follow every other term and condition of probation that Judge Gallagher set out for. Punishment, rehabilitation, and deterrence do not include the term revenge. And believe me,
This is really the first case I've
community
covered like
that are
this.
seeking that.
But if you go to
That's not the function of a
trialjunkie.online,
jury. The
you
function
can
of a
see
jury
all the
is to
cases that I'm going to be covering.
set out the terms and conditions of probation
Trialjunkie.online.
applicable, or to make a decision that's applicable and based upon the facts of that particular case. There's no one else in this community that has heard all of the testimony and seen the demeanor of the witnesses and had your experience. This is your verdict and your verdict alone. And let's make no mistake about it. We are asking you to recommend to Judge Gallagher that Mr. Dean have his sentence probated. Because there is nothing to gain by sending this man to the penitentiary. No one
Sounds
can
like it's just a recommendation for probation.
We've talked about his need
Sounds
for
like the judge could
rehabilitation.
still say no probation.
And we've talked about what exactly is it that we would deter by a penitentiary sentence here. What exactly would that be? Aaron didn't know who was on the other side of that window. As much as people want to make this a racial issue, it's not. He didn't know who was on the other side of that window. All he knew
Fair enough.
was they were armed, and they were a threat. So everything that's happened from then on is of low value in deciding what the sentence should be in this case. We had to file, the law requires that a motion, an application for probation be filed pre-trial, as the judge tells you in the jury charge. That's because both sides have to have the ability to question jurors such as yourselves about your ability to follow the law and to give fair consideration to the concept of probation, which all of you said that you would do. Every one of you. Ladies and gentlemen, on Aaron's behalf, on behalf of police officers and those who risk their lives on a daily basis to keep us safe, we're asking that you give that concept fair consideration here. because this case deserves that fair consideration. Aaron deserves that fair consideration. You have 2 minutes, Mr. President. Ladies and gentlemen, this is Aaron Dean. This is the man that you'll be passing judgment on in a few minutes. You heard from family and friends, members of the community that know Aaron the best. He's a good man. He's a very good man. He's a very good man who finds himself in a very tough situation. And we're asking that you take into consideration all of those good qualities that you heard about. Because this man
Well,
possesses
the jury
all-
already found that he didn't follow
Those
the
people got
law.
up here, thank you.
It's kind of more a question like the jury, how bad he
Everything
broke
they
it.
said was heartfelt.
Heartfelt.
They're not the best.
Heartfelt.
Ladies and gentlemen, you have Aaron Dean in your hands. And like the prosecutor asked you to do, I hope you remember my remarks when you go back into the jury room. Because like at the first phase of the trial, the prosecutors get to close here. They get the last say. I don't know why, but that's what the law allows.
Because of the burden
So
of
I'm asking
proof.
when the jury room starts your deliberations, that you recall the things that I've said here this morning. And you take all of those into consideration. And you arrive at a just and fair verdict. Thank you very much.
Okay, I didn't hate that nearly as much as I did the first time.
I have a moment, Your Honor. Yes, sir. May I please court? Yes, sir. Ladies and gentlemen of the jury, probation. You said you'd consider it. You never promised to give it. And I want you to remember when the probation officer was on the stand. 15 minutes a meeting, maybe up to an hour, but that's usually just the first one. 15 minutes a meeting once a month. 3 hours a year. That's what that comes to. That's what that comes to. When you say probation, if you're considering probation for him, what you're saying, what happened that night, what happened in the early morning hours of October 12th, is only worth 3 hours a year for that man. Probation's not appropriate, and you know it. So let's talk about what is appropriate. Let's talk about what the defense attorney said. He's punished himself enough already. You can consider what he told you from this witness stand. When he took the stand a week ago today, that morning, did that seem like a man who had punished himself? Or a man that had given himself an excuse for his conduct?
I see what you're saying.
And the defense attorney told you this is an isolated incident. You know why it's an isolated incident? Because other officers don't act this way. Other officers don't make the same decisions that he made. That's why this is an isolated incident. It's because of him. It's because of who he is. He had a good family. He had a good education. He had a good support system. So why is he here? He's here because of who he is. I want you to watch that body cam video again. I want you to look at every decision that he made that night. I want you to look at every time he had the opportunity to save Atatiana's life, he made the wrong decision. And then I want you to look at that in the context of what Dr. Clayton said last week. Because it should all be clicking in your head now. That's who he really is. He's manipulative.
the overconfidence, the narcissism, ideas of grandiosity that he can do anything. He flaunts the rules.
There's not that much
Just
evidence.
like I
There's
told
like
you,
very
now when
little
you hear
evidence.
that, the hard charger,
God, I
the
hate that.
gung ho, that's who he is. Because those are the decisions he made.
How did you
that
prove
night.
that?
It didn't just that when that split second when he pulled the trigger. Every step he made towards that backyard was who he is and his personality traits and what he can't change. So that's why we're here. It's because of him is why you're sitting in these chairs. You're judging him for what he did. You're holding him accountable for the choices he made. And now you do have to ask yourself, what is Atatiana's life worth? What are you going to tell her family
Brittany, you're killing me.
when this is over? Atatiana, she'll never be married. She'll never have a family. She'll never get to be a doctor. She'll never grow old. Her mother lived longer than her. Mom living longer than a child. At 28 years old, she died. And this wasn't some tragic accident. He's the one that set everything in motion. Her sisters, her brother, Zayden Zion, they'll never hug her again. You saw the defendant's sister touch her hand as she left the stand. That close human contact of support. A touch that any one of her family would give anything for to have one more opportunity to experience. But they can't. Not because of anything that they've done, not because of anything that Atatiana done, but solely because of the decisions that he made on October 12, 2019. And that's why he's sitting in that seat. And that's why you're making this decision. So what is your life worth? What are you going to say to them? What are you going to say to this community? She was in her home. I've said this before, but that's because it's so important. Where else? Where else should you feel safe? Not in your own home. She didn't ask for this. Her family didn't ask for this. It was him. So what is her life worth? We've talked about who the defendant really is. We've talked about Dr. Clayton. We've talked about Atatiana. This person, the defense, all they want to talk about is the defendant. This is the person that lost her life. This is the family that lost a loved one. This is two nephews who lost an aunt, two sisters who lost a sister, and a brother who lost a sister, and a mother who buried a daughter. A woman who went to college, she wanted to be a doctor. She wanted to contribute to society. And we've all of us, you included, have been robbed by the defendant taking her from us. Is that okay? Is that worth 15 minutes a month? 3 hours a year? Is that really what you're going to tell this family? That that's what this is worth? 15 minutes a month? It's not. And you know it's not appropriate.
I think this is a little messed up on the legal argument, though, too, because he still has this
This
sentence
a tragedy
that
that
they
will never be
have
changed.
over their head. It's more saying, hey.
He had so many opportunities to make other decisions so that we wouldn't be here, and yet he didn't. He continued to push forward because that's who he is, his overconfidence, his personality traits. And we go back to Dr. Clayton because it's so important. And if someone back there starts talking about his family and the good person he is, and I have no issues with his family, it's about him. That's what you need to direct him back to. It's about him. Who is he? Dr. Clayton told you. And the best evidence to show you, to look into his soul, to tell you who he really was, who he really is as a person, and why Dr. Clayton was spot on in his evaluation of this defendant was whenever he finally got into that room. And take this back and watch it again. Finally got back into that room, and Atatiana was taking her last breaths on the floor in front of her nephew. gasping for air, struggling to live, and he stood over her, lorded over her, providing no aid, not attempting to do anything, only looking for that gun to give himself yet another excuse for his behavior.
Yet another excuse?
That's his heart. That's who he is.
Fucked up.
And she deserved better. She deserved better from that defendant. And she deserves a sentence from you. Don't just stand there and watch this happen. Take action. Tatiana deserves it. Give him the maximum. That's what her life is worth. Give him the 20 years. Thank you.
Well, there it is. The closing arguments for the penalty phase once again. I didn't hate the defense's argument nearly as much as I did the first time. I was super annoyed with the defense's arguments the first time. I didn't hate them nearly as much this time. And I think part of it is because my attention goes a little in and out because I have doing other things on the stream, but pretty good lawyering. The middle of the defense is still not great. Let's see here. I had one thing. So the jury's been out since 10, and we're rolling up on 4:30. So we're rolling up on 6.5 hours with no sentence handed down. Now, about 2 hours ago, the jury requested to see the body cam footage again and the DFWPD guidelines, their general rules again. So, and that tells you something. They're thinking that tells me that they're thinking way more about quote unquote crime. Well, it's a crime now. He's convicted of it. They're thinking way more about the crime than the character evidence. Now, that might not be true. Maybe they've debated down on the character evidence and have to break a stalemate by saying, okay, let's look at the crime. It's hard to say. But while we wait, we've been going for we're just close to 8 hours here. I thought, not that I don't love hanging out with y'all, but I thought we would be done by lunchtime. I thought they'd have, usually sentences are fast. Let's pull up the closing arguments from the guilt phase while we wait. Again, really iterate real quick. Jury's been out for 6.5 hours. They have asked to see the body cam run one more time, and they have asked to see DFWPD general rules again as they deliberate. And as I pull this up, I'll also ask you, please, please, please hit that like button. Please hit subscribe if you already haven't. I do have a donation link in the description if you feel so obliged to donate. And then if you want to share this out, definitely share this out. We'll keep going until we get a verdict or until the judge sends the jury home for the night. Here we go. These are closing arguments from the guilt phase. I will skip. I think the judge might read jury instructions here. I will skip that if that's the case.
Good morning. I apologize for the delay. We've been working. I'm going to hand each of you a copy of the jury instructions that you can follow along with me as I'm reading them
Nope,
to you.
we're not listening to jury instructions.
She had the right to protect Zion.
Went way too far. Here we go. I think we're moments away from closing arguments. Once again, replay crew.
If you can't feel safe in your own home, where can we feel safe?
I think she was a theater major that then applied to law school.
It's where you go to retreat, to get away from the world. It's where we grow up. It's where we have kids. It's where we mark on the inside of a doorway and they've gotten taller and taller. It's where we make memories. That's why it's so sacred. That's why it's so important. How many of us during the Thanksgiving holiday were in our own kitchens celebrating with our family? Christmas, right now, how many of us right now have a Christmas tree in our living room? Why do we do that? Why do we put Christmas lights outside our house? Why do we decorate our homes? Because they're ours, right? Because they're so important. And today, that's exactly why this day is so important. Because the sanctity, the safety of our homes has been compromised by what he did. He took her away. 28 years old, the rest of her life at the hands of this defendant. The Fort Worth Police Department has good officers. In fact, I've worked with some of the best officers in the state in my career. I trust them with my family. They actually do serve and protect. They don't have preconceived notions about the East Side. They don't go to certain parts of town and say some deserve
Who said a
to be
damn
served
thing
and
about the
protected,
East Side?
but not others.
No one. Oh God, that part will piss me off every time I see it.
Only the parts of town that I want to go to. That's not how it works here. Because our community is all of us. And it was her too. And despite what he thought, when he went over to that house, it wasn't a dope deal gone bad or robbery or shooting, high crime area. This is a 28-year-old woman that was a daughter, a sister, an aunt.
No, it was a potential home burglary.
Taking care of her nephew.
She never once studied to be a doctor
Yolanda,
either.
her mom was a good person. Zion was a good person. James Smith still lives on the East Side. He's a good person. His family are good people. When you put on that badge and you put on that uniform, you say you're going to serve and protect us all. That means her too. And the Fort Worth Police Department, those officers that do serve and protect us and don't have those preconceived notions, that did a thorough investigation in this case, are ashamed that they ever called somebody like him a brother in because it means something when you put on a badge. It means you don't go to a house with a preconceived notion because you want to have that kind of power. Haven't we all met an officer that just likes being an officer a little too much? I've been pulled over by those guys before. Power hungry, tunnel vision. It's a little scary to me. Those people that we don't.
Object to that shit.
Expression of the prosecutor's personal opinion, which is absolutely irrelevant to this jury. Sustained, stay within the record. Ask the judge, ask you to instruct the jury to disregard the last comments of counsel. The jury will disregard the last argument.
And throughout the course of their entire investigation, what did the Fort Worth Police Department determine? They talked to all of these witnesses. They looked at all of the evidence in this case. What you guys got over the last 2 weeks, that's what they had. Forensic interview from Zion, witness interviews. They talked to folks, the autopsy report, the photographs, the body camera video, frame by frame by frame, just like what we watched. They went through all of that and they determined it's murder. They issued an arrest warrant.
That's
and
also
the
irrelevant.
judge signed saying this is.
That's also objectionable right there.
The question in this case has never been, is it murder? The question that they raised this week was, is it self-defense? Is it self-defense?
Oh God, I can't listen to
What's
this again.
really important about the court's charge is this is the law that applies. We do not view it based on what he says and only what he says. A person doesn't get to harm another, get up on the stand and say, well, I was doing it in fear of my life. And we just let them go. We just take their word for it. Imagine that scenario. Imagine what would happen if that were the law. Then not one single person would ever be held responsible and accountable for what they do if they can just say it is, so it is. That's not the way that it works. What the law is, and what you guys have in front of you, is that it has to be a reasonable belief and immediately necessary. And so how do we define what's reasonable, right? That's also in your court charge. It's a belief that would be held by an ordinary and prudent person. All of you guys, with what he did out there, was that reasonable? Was that immediately necessary? And here's one very important part, and I can tell you right now, when they get up and talk, they don't want you to focus on this. This is the law. This is what we're charged. This is what we're bound by. Unlawful deadly force. Unlawful force. The only way that
This was by
conduct
far their
is
best argument in
justified
closing, for
by this
sure.
defendant is if it's reasonable to all of you, what he did, immediately necessary. And the most important part is her, meaning Atatiana's, unlawful force towards him, or unlawful deadly force. The only way he is justified in his conduct is that it's to the degree the actor reasonably believes the deadly force is immediately necessary to protect the actor being the defendant, against the other person, Atatiana's use of unlawful deadly force. So think
Yeah,
about
I mean, that's sometimes.
what has been
I don't know how they would.
about what Atatiana
There
did.
must be a point when the judge can.
We have
declare
not seen
hung,
one shred of evidence
But that seems like a mess.
that
Because then you'd have to have a new jury
Atatiana did
just for
was unlawful.
penalty phase.
In fact, we heard quite the opposite. You can be in your own home, owning a weapon, owning a gun, and you can protect yourself in your home. That's one of the most fundamental rights. That's the reason we all feel so safe. Atatiana Jefferson didn't commit any criminal act by walking up to the window with her gun, thinking someone was outside. It's what many of us would do if we were in our house in the middle of the night, in the back bedroom, and we hear somebody outside. That's what you would expect us to do, to try to protect ourselves.
I agree with that part.
And in this case, Zion as well. So there's not been any evidence to support anything that she did was unlawful. And you got to have that. That's what the law says. And if you think about it, it makes sense in this case because she was in her own home. If we can't feel safe there, where in the world are we going to feel safe? This defendant, when he put on this uniform, he has a tremendous amount of power, right? A tremendous amount of power. And when we talk about what's reasonable, when I talked earlier about the Fort Worth Police Department, when they went through and
So
they
the
did
way
their
the
thorough investigation of
judge
what
talked
happened
about
out
this
there,
morning was
they
like,
considered
he talked about it
all
with a very
of
clear
what you guys have
assumption
seen, as well as the general
that they'd
orders.
have a
I
decision
put that in
today.
here too. You guys can
But
ask for
they've
that.
been
If you guys
sequestered
want to
for
go through, you can ask for the general
for the
orders.
other verdict,
You
so
can
I'm
see
sure that he'd sequester him for this as well.
exactly what they say. It's not about what I say they say, or they say, or any kind of spin that the defendant wants to put on it when he took the stand. It's exactly what is written down. It's the very thing that the defense said in opening statement. They followed all the steps and procedures as you are supposed to. An open structure is a silent alarm, and he did everything right. That is what this Jay Coons got up here and said. He wouldn't agree with anything that we asked him, but that's the one thing he said. Everything he did was right. Well, that is not the case. Very first thing, officer receiving the call, that's him, right? He's the sheet officer. He's the main officer. He calls the shots. Step 2, B, all main exit ways should be guarded so as to prevent the escape of any defender. We start there and we fail, right? And that was one amongst the many, 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 many things that he did wrong, because it wasn't important to him to serve and protect that day. It was important for him to get there, get in the action.
Isn't that still kind of serving and protecting
Corrupt
to get there
certain
and get in
people don't
action?
need to wear a badge. Certain people do not need to have the power and the control if they do not respect the accountability, and in this case, the grave effect that it had. Now, you guys have the ability today, over 3.5 years, we've waited. They've waited. They've waited for this day. Everybody in this room and all the rooms outside of this room and everybody in this community has waited for today. Because today you say you can't create the danger and then claim self-defense. We want to feel safe in our own home. Today, you guys' decision in this case, finding him guilty, says, I'm holding you responsible. I'm holding you accountable. I'm following the law. And with the power you all have today, which is more power today to change lives, to hold people accountable than most people have in a lifetime.
In a lifetime.
The power you guys have is to hold him responsible.
Dude, I seriously think she could have been
Them.
a Hollywood actress. Definitely be a politician. She's a good speech giver.
It's to say that she matters. They matter. East Side matters. We protect
East Side?
everyone.
East Side
And the
matters.
law agrees. Everything in this case, all of the evidence in this case, is demanding a guilty verdict. That is exactly what we are asking for from all of you today. We know what he does with power. What are you guys going to do with it? find him guilty.
Speaking of which, if you all haven't heard, they settled today. No more appeals. Settled for $1 million. Probably good for both of them.
Mr. Gill. Morning, ladies and gentlemen. I want to first thank you for the time you've spent here the last week and a half, and all the attention you paid to this case. I mean, it's obvious to me, sitting over here on the other side of the courtroom, that you all take this case very seriously. You paid very close attention. You took a lot of notes. You're very involved in this case, and we appreciate it. Well, thank you for your service. On my behalf, co-counsel Miles, on behalf of Aaron, on behalf of his family. Well, thank you. Thank you for being here. Thank you for your service. And I can tell you that it is a very humbling experience to stand up in front of you when you're about to judge my client and have a few minutes to address you and point out to you what I think is important about this case. And the first thing that's important about the case is this jury charge. And if the judge sets out the law that you'll follow during your deliberation. And one thing that the court's charge doesn't point out, that it's very obvious from everything we've heard in this courtroom this week, is this whole thing is a tragedy. And I'm not going to stand up in front of you and tell you it's not, because it is. It's a tragedy. It was a tragedy on October 12th. It was a tragedy on October 13th. And it's been a tragedy every day since then, and it will continue to be one. But a tragedy doesn't always equal a crime. It doesn't always equal a law violation. Because as the judge points out to you in this
It
charge,
usually
and
doesn't.
as the state pointed out to you during their opening argument, Atatiana Jefferson had the right to the sanctity of her home. She had the right to protect Zion. The prosecutor called it a fundamental right, even a sacred right. You know what that right is? That's the right of self-defense. And it's the right of defense of a third person, as a judge explains it to you in this charge. And those are fundamental and sacred rights that we have as citizens of the state of Texas. And the judge explains to you that Aaron Dean, as a citizen of the state of Texas, has a right to self-defense. He has a right to defend himself. He has the right to defend a third person, Carol Darch. He has those rights. And the rights we have as citizens, the right to protect ourselves, the right to protect in our home, Atatiana Jefferson's rights the night of October 12th of 2019, she had those rights up until the point she pointed a firearm at a Fort Worth police officer. Because we never, under the law, ever have the right to point a firearm at a uniformed police officer. The rights stop there.
I think he should have won on that part, but whatever.
Conduct is a first-degree felony under the laws of the state of Texas. And it's a crime, and it's an unlawful act. The judge also tells you in this jury charge that even though Aaron has been arrested for this and charged and indicted, that is not any evidence of his guilt.
Yep. And the prosecutor kind of said it was. Kind of messed up.
Arresting someone and charging someone are very low. The standard of proof of beyond a reasonable doubt is the highest standard we have under our law. It doesn't take much to arrest or charge someone, but it takes a lot of evidence to convict someone, and that's the way our law ought to be. That's been our law from day one when this country was founded. When we passed a Constitution and a Bill of Rights, that's been our law. And it's been the law ever since, and it's the law today. So not only does the state have to convict a person of a crime beyond a reasonable doubt, you heard from this jury charge that the state has to remove all doubt in your mind as to whether or not this was self-defense or defense of a third person. When the judge includes that in a jury charge, it's the state's burden beyond a reasonable doubt to disprove it. The state, in this case, has to prove beyond any and all reasonable doubt that Aaron Dean was not lawfully defending himself or lawfully defending Carol Darch. The judge also tells you in this jury charge that in answering the issues submitted to you, you must not be swayed by mere sentiment, conjecture, sympathy, passion, prejudice, prejudgment,
I think they were slightly swayed by some passion and sympathy here.
public opinion, or public feelings. It's not your job as members of this community to see that one thing or another happens in this case. It's your decision as jurors based upon the law that the judge gives to you and the evidence that you've heard from that witness stand. There's no one else in this community other than you has heard what you have heard from this witness stand. You are the people that the community has placed in this position of trust. And you are the people that have taken an oath to follow the law of the state of Texas, which is given to you by Judge Gallagher in this jury charge. You are the ones that during the jury selection process of this case said that you could follow the law as Judge Gallagher gives it to you, as it's contained here. During jury selection, you have a right to tell us how you feel about things. That's what you told us. Now, by your oath, you are bound to follow the law. Going back to the charge just briefly, the law of self-defense is set out starting on page 7. And the judge clearly instructs you that it's a justification or defense under the law to be defending yourself or defending a third person. Halfway down the page, a reasonable doubt on either of these two defenses requires that the defendant be acquitted, found not guilty. A person's justified in using deadly force against another if the actor reasonably believes it's immediately necessary to protect himself or to protect that third party. What is more immediately necessary than having a handgun stuck in your face? And you heard from several people, starting with Aaron, that handgun looked this big when he saw it. And then it was explained to you by Dr. Coons and even by the state's expert, Mr. Priest, that's called tunnel vision, that the officer's view goes down to 2 or 3 degrees and they focus on that weapon as a robbery victim would. And you've all heard it described in the news, the robbery victim described the weapon as being as big as
I'm going to object, Your Honor. That's outside the scope of evidence.
Stay within the record.
That's what the expert witnesses.
Oh, that's right. Go ahead.
They described how robbery victims view a firearm when one stuck in their face and they're startled by it. It's huge. It's their focus. It's the focus of the officer's attention when that happens to them. And the experts say That's why when that happens to the officers, they cry out, "Show me your hands, show me your hands."
Just had another
Because
thought
that's their
about this
focus. The focus is the hands. The focus is the
settlement
weapon.
today.
That's the threat. That's the threat they have to stop.
Lati was going to be all over it
That's what they
today.
do.
Maybe tomorrow. Does this mean we never have to hear about this case again?
The application of the
What
law
are they
of
all
the
going to?
facts,
What is everybody going to have videos
page
about?
9,
It's gonna
Judge
be crazy.
first instructs you on the application of the law of self-defense to the facts of the case. And tells you if you have a reasonable doubt, or if you believe it was self-defense, you find Aaron not guilty. And then there's an or, and then the judge instructs you on the law of defense of a third person. And if you believe that Aaron was legitimately defending a third person, reasonably defending a third person, or if you have a reasonable doubt about whether he was doing such, then you ought to acquit Aaron. And you don't have to agree if it was self-defense or defense of a third person. You just have to agree.
There's just still feels like there's so much reasonable doubt here.
That he reasonably believed he was doing one of those two things. And they happened at the same time. It was the same threat that was threatening both of the officers. It was the same threat that Aaron perceived that he had to act against. The judge tells you that there is a lesser included offense, the offense of manslaughter. Manslaughter is recklessly causing an individual's death. The law of self-defense and the law of defense of a third person applies equally to manslaughter as it does to murder. If you believe that the actions of Aaron constitute manslaughter, then he has a right to defend himself and defend Carol Darge also under those circumstances. And I'm not going to stand up here and insult your intelligence and waste your time.
I don't know if I said this early, but we are officially at 9 hours of deliberations now.
He did that. He took this witness stand and took an oath, even though he didn't have to, even though the judge would have instructed you to not consider his not testifying for any reason, even though he knew he had to come up here and face cross-examination by experienced prosecutors. He took the witness stand because he wanted you to hear everything. And he told you what happened. And then he was cross-examined. And he told you again what happened. And we know that what Aaron said is correct and truthful because it was the same thing that was said by the other two eyewitnesses to what happened out there that day. We can't really discuss what Aaron told you about what happened without discussing what Zion Carr told you what happened.
This is their best moment.
Remember the circumstances of how Zion Carr testified?
He handled this
He was the
so
state's
well.
first witness. And he took this witness stand right over here and took the same oath that everybody else agrees to take. And he answered questions from the state of Texas. And then he answered questions on cross-examination, like any other witness would have to do. And Zion Carr's testimony took a real different turn from the truth during his testimony. Now, Zion's a good kid. You can tell from looking at him. He's a good kid. He came in here. He was well-spoken. He was intelligent. But you could tell he was under a lot of pressure. And a lot of time had passed. So Zion succumbed to the pressure and testified differently from the truth. But fortunately, we know what the truth is. Because as soon as police got on the scene, they separated Zion from the scene. And they got him almost immediately to an experienced, trained, qualified forensic interviewer named Lindsay Dula. And And Lindsay sat down with him and had a conversation about what he had just seen. And what he saw mirrors what Aaron saw. Because Zion Carr told you he was seated, he was laying on his aunt's bed, further away from the window than she was. And she said, I heard a noise. And she got up and went down by the window and got her gun out of her purse. And then she took that gun and she made sure she had a hot chamber. She already had a hot chamber. So she ejected an unfired round onto the floor, which was found at her feet by crime scene officers. And then she took her gun, and Zion explained to you that she pointed it at the window. And we know from Aaron's testimony and from Officer Darch's testimony that Aaron Dean was on the other side of that window in full police uniform, having been dispatched there by his department. And Zion Carr said, I thought I saw a badge. And Zion Carr said, the officer told her to put your hands up, show me your hands. And she didn't do that. And that's when the officer shot her.
In her room or in a different room? Her room, okay. You said she got her weapon. Tell me about her weapon. You said she got her gun and she pointed. Did you see her point the gun? Where was she pointing again? At the window. Do you see anything through the window? Tell me what you saw. I saw it. You think you saw a gun and maybe a badge, and then you saw one flashlight outside the window? Could you hear anything when you saw the flashlight? Tell me what you heard. Did you hear anything different than put your hands up? To put your hands up, then you put your hands up now. And then she did.
It's 5 o'clock in Fort Worth, Texas. We still don't have a sentencing decision. I'm starting to wonder what's taking them so long. There's some heated discussions going on.
It's tragic. It's tragic what happened. It's tragic that Zion saw it happen. But Zion saw enough to even know that it was the male officer, not the female officer, that had to shoot his aunt.
This should be way more compelling.
It's a mirror image of what Aaron Dean told you about what happened out there. And we know that it's true because that's what Zion said shortly after it happened. And that's what Aaron said happened out there that night.
Watching this back again makes me angry about the verdict all over again.
That you heard from about what happened out there was the body cam video. You heard Grant Fredericks the expert from Spokane, Washington, who is an instructor at the FBI Academy and many other places about forensic video. He obtained what's called a first instance copy of that video. He compared the hash number of the video he received to the audit trail from Aaron's body-worn camera and ensured that he had the original video, the best copy he could get. And he interrogated it. And based upon his interrogation of the video, he came in here to court and told you what he saw on the video. And he saw the same things that Zion and Aaron saw. He saw the woman in the video, the woman on the other side of the window from Aaron, raising her arm with a dark object in her hand. The dark object, you know from the statement of Zion and the testimony of Aaron Dean, was Atatiana Jefferson's fireball. A deadly weapon. The kind of things that police officers are trained to deal with. You heard the term officer safety mentioned several times during trial. Fort Worth police officers spend a week in a school called officer survival so that they know how to deal with situations like this. And they also know how to deal with situations like this from their general orders. And their general orders tell them, based upon the law of the state of Texas, the law of the Supreme Court of the United States of America, the statutes of the state of Texas, the right to
Yep, Zion was in the same room.
the right to defend a third person.
Sorry, I missed that.
That they have the right and they should meet deadly force with deadly force. And you recall during jury selection, we asked you, does an officer have to wait until he's dead before he exercises his right of self-defense? Of course not. That's the whole reason we have a right of self-defense, is to defend ourselves. To make sure that no one uses a deadly weapon on us, to save our own lives, to save the life of a third person. That's why that law is on the books. And Aaron had the right to do that night. And that is unfortunately what he had to do. Several witnesses told you that police work is inherently dangerous work. It's a balancing of risks. Police officers go out every night and deal with situations like this. Fortunately, most of them do not involve the confluence and continuum of events that happened in this case that unfortunately led up to this situation. And you heard about what that situation was. Mr. Smith from across the street called the police. In his mind, he wanted them to go check on his neighbor. But that's not what he told them. He told them that there was an open door over there, and he wasn't sure what was going on. He told them about the cars parked in the driveway. Now, police have rigid rules about how they deal with that kind of situation. When someone calls the police take the information given in the call and they code it. And they dispatch their officers accordingly. And in this case, the buzzwords that Miss Talbert, the call taker, heard.
At the time of the shooting, she was in the bedroom with Zion. She was shot in the bedroom
So
window.
Aaron and Carol were
Or through the bedroom window.
on signal 56, which in police jargon is an open structure call. And they are told in their general orders, generally, how they are to deal with an open structure call. And they went out there and they dealt with their open structure call. And you know from your experience as a citizen, and when police officers
Absolutely
are called
true.
out on a call, they do what's necessary to do a proper investigation. And their proper
I still think she would have had every right to shoot him.
dealing with an open door, an open structure, a silent alarm, whatever it might be, is they go check the structure. And checking the structure requires them to get on the property and have a look at it. And that's what Aaron and Carol did that night. Unfortunately, they did not get a chance to complete their investigation. You heard a lot of criticism of Aaron about how Aaron handled that call. A lot of Monday morning quarterbacking about how Aaron handled that call. Mr. Priest, that was called by the state of Texas to testify in this case, had all kinds of problems with how Aaron handled that call. He did all kinds of Monday morning quarterback. He quarterbacked all week on Aaron.
I love that line.
What did we talk about with him? He come out here and talk about, well, I didn't like the way they crossed the intersection. They crossed the intersection and they could have been seen by someone. And they're not supposed to do it that way. And that's bad policing. And gee, that's just sorry. That's just sorry work. And he had all kinds of reports to review. And he said he did all kinds of work and didn't take any notes. But by God, he remembered everything and understood it all. Really, all he had to do was go ask Mr. Smith about crossing that intersection, what that was all about. Because Mr. Smith took the witness stand here and told you, it was completely dark out there that night. Completely dark. Mr. Smith testified that he and some of his other family members were sitting out on a porch across the street. And Mr. Smith had called the police and he was expecting them to show up and he was watching for them. And all he saw were two silhouettes. And he was looking for that, paying attention for it. Aaron got criticized for not seeing him on the porch across the street, on a completely dark street. Then he got criticized for going up to the door and not announcing himself. Then he got criticized for walking around to the back and looking at the back. The general orders call for an investigation. You have a look at the structure. Figure out what's going on. Then start making decisions.
Everyone's still in the hallway at the courtroom.
If Aaron had walked up to the front and announced himself, and there had been a burglar in the house, what the burglar would have done? Go out the back, of course. You can't have it all those different ways. You can't be wrong about staying at the front. You can't be wrong about going to the back or vice versa. It's like the old trick of the balloon. You squeeze one end of the balloon.
I've always wondered about that.
Like, the other. You squeeze the other end, it goes back.
That's weird. I agree.
It's simple. You go out there and do the best you can. And snipers' nests, we talked about that, and I don't know. I don't know how we got that far off reality.
I think you're right. Like, if hindsight's 2020, they definitely should have just
they were out there doing an investigation,
secured the area,
and
they did not call
Aaron for not checking the deck lids on the cars. Like what? A burglar crawls in the trunk of the car and hides out waiting for the police? Come on.
This case is so tough. It's complicated.
But then Mr. Priest forgot about something. He forgot that several years ago, he worked on a very, very, very similar case in Fort Worth, where a man was shot by Fort Worth police officers in his own garage. Police had been dispatched out there on an alarm call and went to the wrong house. The garage they shot the man in was the wrong garage. It wasn't the garage of the house they were supposed to be at. And the man didn't put down his weapon, and he was shot by the police. And Mr. Priest, under those mirror circumstances, said that was justified. Uniformed
That part
police
was
officer
weird. How
shot a
that.
man in his own garage.
I thought they had him when they got that expert like.
And nitpick Aaron.
But you've testified to the exact opposite under mirrored circumstances. But
Money.
maybe that's what got the
to be here to say those things.
manslaughter.
But he forgot about that other opinion. I don't expect we'll be seeing Mr. Priest around here for a while. He's kind of worn out his welcome here, I always expect at this point. But he also told you after that police work's inherently dangerous.
We have completely forgot fatal funnel. I thought that would stick
Do
a little better.
officers deviate from general orders?
I don't even think we heard fatal funnel in the closing.
Of course. He also agreed you don't have to necessarily announce yourself at a silent alarm. Things changed after he was confronted with his inconsistent opinion on another very similar case. Sometimes when officers usually use deadly force, they say nothing. Because there's no requirement under the law.
Oh, for sure.
Before
For
you
sure.
exercise your right of self-defense.
Fatal funnel
that
is
you
real.
say anything or do
There was
anything
just a
else
point where they were saying
other
fatal
than exercise
funnel
your
every
right.
3 seconds in this trial.
Officers have to make those split-second decisions. And they have to decide it like that. If they're being threatened sufficiently to exercise their right of deadly force or their right to defend a third person. And that's how fast this case went. Mr. Priest had all kinds of problems with how Aaron handled that call. But in the final analysis, when Miles asked him about the actual event of firing the shot, he didn't differ with what Grant Fredericks had said about the timeline.
Yeah, we're BFFs,
about the right
Karen.
of self-defense.
I mean, we've been here for 9 hours. I actually had the most concurrent viewers I've ever had at one point today, but I think 7 hours later, people are like, okay, let's come back and watch
hadn't paid much attention to the testimony of Aaron Dean because there was a firearm present.
Brittany and Kara, have you guys both been here the whole time?
The firearm was pointed at Aaron Dean. A firearm is a deadly weapon. A firearm is the kind of thing that we're allowed to use deadly force to defend ourselves against.
Kara, we're gonna find time to do this. That
Police
between
work is inherently dangerous.
now and when
You heard
the
that from several witnesses
Mark
on
Jensen
the-
trials starts on January 9th.
Pointing.
All right, that's awesome.
A firearm.
Thank
at
you.
Another human being.
I've
is
been
an
here the whole time too.
aggressive, provocative act.
9 hours. We're 9 hours in.
And it's an aggressive, provocative act that draws a response of self-defense and defense of a third person. Aaron's actions that evening were justified under the law of the state of Texas. Aaron was a police officer in full uniform. You saw the photographs of him. He had Fort Worth PD, FWPD across his watch cap. He had distinctive patches on both shoulders. He was wearing a badge on his chest, a distinctive uniform. And when he's wearing a distinctive uniform like that, when any officer is, they have a right, a reasonable right to expect that members of the public understand that they are a police officer and that they are protected from aggressive, violent, provocative acts of other citizens. They have enough to worry about out there on their job.
No!
Aaron got there that evening because he was a Fort Worth police officer. He went to the academy, he was trained. He graduated. He was issued a badge and a firearm, trained some more, sent out onto the street. When
I
Mr.
won't.
Smith called Fort Police Department to report the neighbor's doors being open, Aaron was dispatched out there on that call. He was sent out there by his department to do a job. And the job was to check that building, check that residence under the general order.
No, I ate a little bit. I turned my video off and ate. What do you
Mr.
guys want?
Smith, you recall,
You guys didn't notice. I'm good.
said he
But I
didn't
am
go
gonna have
over
to
there
call it
himself. He didn't go up to the house and knock on the door. He didn't go holler out to the
I am gonna
neighbors
have
see what was
to
wrong.
stop at 6 o'clock.
He didn't go past the
Dallas
car.
Fort Worth time
That's
because
the
my
back
daughter has
bumper
a
of the car
gas
was
recital.
parked
So 45
in that
minutes from now.
driveway. Why not? What did he tell you?
I expect them to come back with a
Because
verdict
he didn't
before then.
have a weapon. He could have walked up to that door and knocked. He could have hollered out to the residents, "Hey, Mrs. Carr, hey, anybody in there? Everything okay? Front door's been open for hours. I've never seen your front door open before." He didn't do that. And he told you the reason was he didn't have a weapon. So he relied on the Fort Worth Police Department to go out there. And everybody in the world knows the Fort Worth Police Department carries a weapon. Every one of them. You have 10 minutes. Thank you.
Still nothing happening.
You know from what you heard from the Tarrant County Medical Examiner's Office, Dr. Freeze or Fries, it's
Yeah, I think so.
F-R-I-E-S. He told you that Ms. Jefferson had glass stippling, pseudo-stippling on her face. She had a gunshot wound in her upper chest area, a fatal gunshot wound, a gunshot wound that he said would have killed her if she'd been shot like that in a level 1 trauma center. No one was going to be able to save her out there in that house. That's a tragic fact, but it's a fact. So when Aaron's criticized for running in too fast and not clearing the rooms to get to her, but then you at the same time criticized for not getting to her quickly
Okay, cool,
enough to
Kara.
render
I'm
medical aid,
going to be working on that
medical
after this
aid,
trial too.
Unfortunately,
So set it to friends and
not
family.
matter that. But we also heard from Dr. Freeze, that Miss Jefferson, relative to where the shot
That
came
was
from,
fun.
was in a slightly bladed stance, with her right turned slightly to her right. And if the shot went from up to down, left to right, went in up here, came out down here. Didn't come out, but lodged down in her lower back on her right side. After he corrected, saw that there was an error in his autopsy report. Because that's how she was situated when she was shot.
I don't see anything wrong with her being situated like that.
She didn't have any pseudo-stippling on her hands because her hands were out in front of her, closest to the window, underneath where that cone of glass entered the room. The medical examiner's testimony mirrors the testimony of Zion and Aaron and Grant Fredericks, because the position is correct. It all fits together, ladies and gentlemen. It all fits together. And from Aaron's standpoint, which is how you are to judge his reasonableness that evening, he saw a firearm pointed at him, and based upon his training,
Ooh, I didn't think of it that way.
he reacted tragically, but he reacted correctly under the law. The state cannot prove to you beyond a reasonable doubt that this was not self-defense. They cannot prove to you beyond a reasonable doubt it was not defensive.
It seems like it was 3 days ago that I accidentally yeeted the chat.
He reasonably believed
That was
his
this morning?
actions, his deadly force, was immediately necessary to counter her use of unlawful deadly force, because it is always against the law to point a handgun at a uniformed police officer. And that's what happened here. It's tragic, but it's not an offense under the laws of the state of Texas. The jury charge contains verdict forms at the end.
Yeah. The elves
jury
were
verdict form
hanged, so
uses the top one.
they had a
It says, "We, the
string or
jury,
a little
find
rope
the
drawn
defendant,
between the
Aaron York
lights
Dean,
in my
not guilty.
bar
He's not
area
guilty
in the kitchen, and they were
because he
swinging from it.
validly exercised his right of self-defense on that occasion. And he validly and reasonably exercised his right to defend a third person, that being Carol Darch, who he had every reason to believe, based upon training and experience, was going to be right behind him where her training told her she needed to be. And she was. And she was in the line of fire, just the same as Aaron Dean was. So, nothing that we do here this week is ever going to bring Miss Jefferson back, unfortunately. Nothing can change that. But by the same token, the tragedy should not be compounded by finding guilty.
I'm working on finding out when the judge is going to tell the jury to
As a police
take a
officer,
rest for the night.
his rights under the laws of the state of Texas.
I haven't seen much of anything yet.
We would ask you to find Mr. Dean not guilty of his charges. Thank you very much for your time and the attention that you've given me this morning.
Mr. Smith, may I have a moment, Your Honor?
Yes, sir.
I don't know if I want to listen to this guy yell again.
Please court. Yes, sir. Defense counsels, ladies and gentlemen of the jury. I guess it's inherently dangerous to sit in your own bedroom, in your own home, in the middle of the night, while you're babysitting your 8-year-old nephew. Because she's the one that's dead, not the defendant. And all this talk about training and self-defense, it's not the defendant's point of view. You will not see anywhere in this charge that you're to look at it from the defendant's point of view. You're to look at it from a reasonable person in the same circumstances. Well, you know who is in the same circumstances as the defendant, who was looking death in the eye? That was Atatiana. Did she fire? No. He did. And we're going to talk about it here in a minute. You're going to see that he didn't even see a gun. But let's talk about how we got there on October 12th, 2019. Because let me tell you, the one person that had no input on any choices that night was
Sure. We're probably close to the same age. And Garrett, you know, you're probably younger than me, but yeah, I got really into John Bonet. Dude.
Because on October 12th, 2019, when the defendant was called to her house, he was the one making choices. When he approached that front door, he could have knocked and Atatiana would still be alive. When he approached that front door, he could have said, Fort Worth Police, and Atatiana would still be alive. The general orders are here for a reason. They're here to guide these officers, they get home safely, and the citizens of Tarrant County and Fort Worth are protected and served. Atatiana Jefferson was not protected or served on October 12th, 2019. The defendant's own words. They want to argue about Dr. Priest or Mr. Priest or Dr. Coons. Dr. Coons couldn't answer a question. If I would have asked him if the sky was blue, he would have said, maybe, perhaps, there are other factors. The man couldn't answer one straight question.
Like
what does that
nighttime?
say about his credibility?
You fucking idiot. Sorry.
The defense's witness.
The other
Wouldn't
factor,
even
like
answer one question after
nighttime.
he saw the defendant time and time again sitting in that seat, look at you on road and say, that was some bad police work. That was some bad police work. Dr. Coons watched him admit bad police work over and over again, then stood up here and told you he did everything great. The defendant knew he didn't do everything the right way. And when you look at the general orders for silent alarms, because that's what you can look at, it's in the exhibits. It says, if you see signs of damaged entry, you shall call for backup. What did the defendant tell you on Monday? I thought the window had been, the screen door, there was damage. Someone had broken in. There was a screwdriver right next to the door. That's signs of forced entry. Signs of forced entry. His general orders say it. Signs of forced entry, you shall call for backup. But he ignored that. Because you see, you know who the defendant really is as he testified. You know, I mean, he cracked a joke. I guess I just should have stayed home that night. Someone lost their life. He's supposed to be testifying in his own defense, and he's cracking jokes from the witness stand. I guess I should have just stayed home that night. Well, Atatiana was home, and she's no longer here because of what he did. The choices he made, the choices that she had no input into.
I don't know this
The
side.
defendant did not call for backup when he saw that second
I have
screen
trouble
door,
with the
even
fact
though
that
it
he
was
didn't
in
tell
his
his
general
partner there
orders
was a gun.
to do it, shall do it.
If
So
he saw a
kept
gun, he'd
going
probably tell his
because
partner he
that's
saw
who
a
he
gun,
is.
like right away.
Gung-ho, hard charger. Ignoring his own safety, ignoring Officer Darch's safety, he leads her into that backyard. And I guess Dr. Coon says if you don't want the police in your backyard, you better lock your gate. All of Fort Worth better go lock your gates right now, or I guess the police can just go in your backyard whenever they want to. Or was that as ridiculous to y'all as it was to me? We have a reasonable expectation of privacy in our homes, just like Ashley talked about. Just like home is where you feel safest.
Good call, Brittany.
Home is where you know you can protect your family.
That might be why they're looking at the
Is where you know you can care for your nephew
general orders.
and mothers in the hospital. But the defendant didn't care about any of that. He was going to get in that backyard. Regardless of that front entryway being completely open, anyone that was in that house could have taken off running. Anyone in that house could have come back around and shot him in the back. He wouldn't have known it because he didn't care. He didn't care about the general orders. He doesn't care about who's in that house. He's a hard charger. He is gung-ho. He was going to get in that backyard. And Atatiana's sitting there playing video games, watching Zion, knowing that this defendant.
Okay, I want to pull up WFAA real quick.
Life-ending.
I trust you, AK, but I'm just going to see if they say anything about it.
No idea.
It's 5:30. Perfect time for them to be leaving. They must have known my daughter has a dance recital. Oh, here, let me do this. I can't believe we've been here all day without a verdict. Trying to get it up. So, okay. So both of y'all see it. Let's pull up WFAA real quick, see if they have anything to say. Yeah, it's not coming up right. You know what? I trust my trial junkies. So here's the deal. I did not plan for this to go to Tuesday. My son has hockey tournaments all day tomorrow and Wednesday. I don't think they start till a little later in the day, so I'll try to be on 7:30 tomorrow morning. But there's a possibility that I won't be able to. I'll do everything I can. Follow me on Twitter. I'll keep you all posted. And okay, yeah, WFA did just end the stream. I saw that too. So I will do everything I can to be here 8:30 Central Time tomorrow, 7:30 Mountain Standard Time. But I am not going to be able to be live all day, as my son has a hockey tournament that I actually coach in. Anyway, I can't believe that we're going into another day of this. I can't believe it. Thank you all for being here. They waited to get me over the 9-hour mark today, so that's pretty cool. I thank you all for being here, and I should at the very least see you for a short while in the morning. If you haven't already, hit that like button, hit that subscribe button. Make sure you hit notifications so that you know when I go live tomorrow. Thanks, everybody, and have a great night.